Mississippi and the best tax program in San Diego. As we approach almost 1,000 LLM graduates, it is truly an honor to shape our next generation. The primary goal of this institute is to bring together the tax community across the United States to discuss IRS updates, share tips and recommendations, network, and become a tighter tax community where everyone can kind of reach out to one another and help each other. This institute is a little different in that we truly want it to be a gathering of not only tax attorneys, but CPAs, enrolled agents, tax preparers, financial planners, anyone interested in tax. Our emphasis here is on community. We want to mix tax professionals with government officials that we could be successful together, working with each other versus against each other. Every year, we are truly grateful for the overwhelming support for this institute. I would like to first sincerely thank Dean Shapiro, Paul Young, and Miranda Fleischer for making today possible. The USD staff, Debbie Ryder, Jeanette Nichols, Stacy Groff, and many others for hosting all of their efforts and putting this great event together. The esteemed panelists for volunteering to share their tremendous knowledge with us. Our guests and wonderful community for supporting the University of San Diego School of Law. But last but not least, my incredible staff, I see them all here, who worked so hard to help put this event together. Today, you will hear from many expert panelists and our luncheon keynote speaker, Chuck Rettig. Unfortunately, the commissioner was called to duty and unexpectedly for an important matter, so he will not be able to join us today for the luncheon in person, but fortunately, he will be Zooming in and he will address us virtually. We hope that today's presentations provide you with valuable insights and strong new connections. In addition to learning and networking, today is also about celebrating. During our luncheon, we will be presenting Marty Shanebaum with the Richard Carpenter Excellence in Tax Award to honor his contributions to the tax community. Since he could not be here in person as well, we will buzz him in via Zoom during our evening reception, stop by and say hello to him on an iPad. We'll wave hi to him, and we'll greet him while he and have a drink with him virtually. I look forward to learning alongside you today and celebrating our community. And with that said, welcome to the 7th Annual USD Law RJS Law Tax Controversy Institute.
Well, good morning. I'm Robert Shapiro, the Dean of the University of San Diego School of Law. Thank you, Ronson. Thank all of you for being here. Like many of you, I am delighted to be taking part in this year's Tax Controversy Institute in person. It's also great to have the option of tuning in remotely. So whether you are in this beautiful auditorium at the Kroc School of Peace on the campus of USD, or in your office, or at home, or in your car, it is my honor to welcome you to the 2022 Tax Controversy Institute at the USD School of Law. I want to express my sincere thanks to Ronson J. Shamoon and the entire RJS Law Office for, once again, putting together a stellar selection of panels and panelists to discuss cutting-edge issues of importance to tax law. Now, Ronson is a dedicated alumnus of the law school, the School of Business, and the undergraduate school at USD. We are all very proud to claim Ronson as a distinguished alumnus, but we all know that tax is Ronson's highest calling, and with good reason. I also want to thank my colleagues at USD, and particularly Stacy Groff, who works tirelessly to make events like this run as smoothly as possible. Now, the University of San Diego School of Law is recognized for the excellence of its faculty, the depth of its curriculum, and the strength of its clinical programs. One of the areas of special renown is our tax program. We are proud of our superb tax faculty, and our commitment to tax runs throughout the curriculum. That commitment begins with a requirement that all of our JST students take tax, and of course also includes our top-ranked tax LLM program, as well as our tax diploma program and our tax clinics. In these and other ways, our outstanding tax program plays a starring role among our superb academic specialties. And I'm delighted to mention that we recently have enhanced our tax universe with the addition of some new stars. Paul Young, who you'll be hearing from later, has joined us as Director of Tax Programs, and USD is already benefiting from Paul's expertise, energy, and vision. Later this summer, Professor Shelley Laser, a superb young tax scholar, will be joining our faculty. We are very happy to be able to recruit Shelley from the University of Illinois. Now, of course, this RJS Law Tax Controversy Institute also plays a starring role in our tax firmament, consistently offering penetrating insight and analysis from experts in the field. Along those lines, we are very fortunate to be able to begin our program today on a very high note with remarks by James Lee, the Chief of Criminal Investigation at the Internal Revenue Service. Chief Lee oversees a worldwide staff of some 3,000 employees in 20 field offices and 11 foreign countries. He supervises some of the most significant investigations of financial crimes involving tax, money laundering, public corruption, cyber crimes, narcotics, and terrorist financing. Chief Lee has extensive enforcement experience. Most recently, he was the Deputy Chief of Criminal Investigation. Previously, he served as Director of Field Operations, both for the northern area and for the southern area. Now, our tax and financial systems, and so much more, depend on the fair and effective enforcement of the law. And there is no one with more insight into those enforcement efforts. We are very grateful for his long dedication to public service and for his willingness to share his expertise with us this morning. Please join me in welcoming the Chief of Criminal Investigation, James Lee.
Morning, everybody. Mr. Shapiro, thanks for the introduction. Quite an introduction, appreciate it. Welcome this morning. It's a good crowd. I, like the two people speaking before me, are happy to be here in person. I did this virtually with RJS Law and the university here last year, so appreciate being in person. It's easier when you can actually look out and talk to people. So you mentioned the commissioner. It's too bad he's not going to be here in person. Typically, I speak after him, and when he say he's got 30 minutes, he goes like an hour and a half, so I end up with like 10 minutes. So it's good that I get to go first, but you're in for quite a treat, and I know you all know the commissioner, and he's a huge supporter of CI in my division, so you're lucky to have him later this afternoon virtually. So again, thanks for RJS Law asking me to come back in the university. It's great to be here. So I do want to I've got about 25 minutes or so is what I'm going to try to target for y'all. And I want to take about 3 minutes and just talk about IRS criminal investigation to give everybody a little bit of context, because not everybody deals or has dealt with a special agent. And so I just want to give you a little bit of context here before I jump into some of the things I want to talk to you about. So our main priority, my main priority, the division, is to instill confidence in the American public by investigating tax violations. Okay, that's my main priority. That's the division's main priority. But as Mr. Shapiro said, we do a lot more than just tax. He talked about the money laundering, bank secrecy, narcotics, terrorism financing, national defense. I mean, we work a lot of different type of money crimes. I like to tell people, that, and maybe I would challenge you here if I had a little more time, but if you think about it, other than random acts of violence, why are most crimes committed? You can think of 3 or 4 if I give you enough time, but it's to make money, right? And we can get involved in all of those. I just have to be really selective because of the number of personnel that I actually have in the division. So highest priority is tax. It's been that. That's our legacy. That's our history. No one else does that kind of work. We're the only agency that can investigate criminal tax violations, federal criminal tax violations, okay? So we investigate and recommend prosecution of criminal tax violations, and then we work with DOJ to actually prosecute those cases. That's our relevance in the service, okay? We play a significant role in the service, and you'll probably hear this from the commissioner because he always talks about this division. And, you know, I see, and when I speak to my agents, you know, try to make sure they understand what our mission focus is, especially the new guys coming in. I'll talk about hiring in a minute. But the deterrent role we play, we're almost like the teeth of the dog, so to say, okay? Because we have to make sure that people know that there's a consequence for being willfully non-compliant. And I stress willfully. And the consequence is going to jail. So that's far different than paying a fine, you know, to resolve some type of an issue, okay? That's why I say kind of the teeth of the dog and our deterrent impact that we really have. But also, we're the only federal law enforcement agency that dedicates 100% of our time to financial crime. Okay, so we really play an intricate role in the integrity of the overall financial system, is how I like to explain it. So the broad range, Mr. Shapiro, you named it. You know, there's so many different priority program areas that I have in just the tax realm alone. You mentioned a couple, you know, a couple that you didn't mention, employment tax, international tax fraud, refund fraud, abusive tax crimes, the list goes on. We have to have an impact and a presence in all of these program areas. And then you get into the non-tax type violations, money laundering, bank secrecy, national security, national defense, terrorist financing, sanction cases. Maybe I'll chat about that here if I have a couple minutes. Give you some perspective. About 75% of the division's time is tax or tax-related crimes. Another 12-ish% is pure narcotics. And then another 12% is other, bank secrecy, the national security, terrorist financing, that type of crime. To give you just a, you mentioned 20 offices, about 3,100 personnel today. Interesting thing is the service is about 80,000, between 70 and 80,000 people, depending on, you know, what time of year it is with some of the seasonal employees. So it's a moving target, but we're roughly 2.5% of the division. We're a criminal division and a civil agency. Again, just for some context. So I want to just kind of quickly shift to some fiscal year 21 successes that I actually have, and I have some stats here. Fine, I'm really proud of what our division does, and we're really close to these numbers, and probably going to exceed these numbers this year for fiscal year 22. But our conviction rate is about 90% in fiscal year 21. And I bring that up, that's in everything that we do. It's a little higher in tax. But I bring that up because if you get in the crosshairs of an IRS CI special agent, about 90% chance you're going to jail, is why I bring that stat up. In fiscal year 21, we identified about $10 billion in fraud. And it's actually a larger number. I use that number because when we make a recommendation for prosecution to the Department of Justice, that's what we have in our report. It's about $10 billion. About 8 of that was tax or tax-related or money laundering, and about $2 billion of that was pure tax for fiscal year 21. And the other kind of fun fact I bring up is we analyzed about 1,350 terabytes of data through about 3,000 devices that we've seized. And that's every device, every cyber type of device you can think of, a phone, you know, a tablet, a server, you know, that's where we're at today. But I like this number, and to put that 1,350 terabytes in perspective, 10 terabytes is equal to the printed collection of the Library of Congress. Okay, just to give it a little perspective. And if I got a minute, I'll come back to that too. $3.6 billion in crypto, in value, in crypto seized in fiscal year 21. Okay, now we know what that same seizure, if it's not all the way through the system and forfeited, you know, I think it was probably $60,000 for a Bitcoin at the time. Now I think as of this morning, it was right around 19 or 20. So, but at the time, it was 3.6 billion Cs. In fiscal year 22, we've already surpassed that, almost doubled in crypto seizures value, which is important. So very proud of the division and the results that we've had. I'll talk a little bit here now, just a couple of cases. In fiscal year 22, I could spend the next 2 hours talking about the successes and the results of some of the cases that we've had. I almost moved that. But I'm going to just give you a couple of recent high publicity tax cases just to kind of give this a little perspective. I'd actually almost tell you every time you see the Bureau, my Bureau partner would probably, kind of hit me for this, but we're involved in most of those cases. We work very closely with our Department of Justice partners, Homeland Security. But a couple tax cases that you might have heard of recently. Todd and Julie Chrisley. Ever hear of them? Chrisley Knows Best. I didn't watch the reality show, but just in June, they were found guilty in trial for conspiring to defraud the community bank out of about $30 million, along with their CPA. Recent case received a lot of publicity. It was the Chrisley. They're known for the reality TV show Chrisley Knows Best. Anybody watch it? You can admit it. Okay. All right. There you go. We got one at least. All right. So they basically submitted false bank statements, audit reports, personal financial statements to banks to obtain this money. And then while earning millions, they were evading tax. So recent case received a lot of publicity for us. This is just in the indictment phase, so I'm not going to talk about this too much, but y'all have heard of syndicated conservation easements. I'm sure a lot of people here, we had the first, but this is about a $1.3 billion. And I stress the billion because these are big cases, right? I mean, everybody doesn't see themselves in an abusive tax scheme, but this is just giving you some context of the type of work we're doing. Big case, February 22, we indicted about 7 individuals. There were a couple of guilty pleas prior to that, or late in fiscal year 21. Big tax shelter scheme, first criminal charges of its kind. Pretty proud of that within the division. Another case that you might be familiar with, DC Solar. Mr. Karpov was sentenced to 30 years in prison, ordered to pay about $860 million in restitution. That was the biggest fraud right out at the time. I've got a November of 21 here. Biggest fraud scheme in the history of the Eastern District of California. I think that's why I bring that up. Pretty big case. It was basically a Ponzi scheme. You're like, well, why are you mentioning that in a tax setting? The reality of it is because we work very close with the other operating divisions within the service, it was a Ponzi scheme, about $1 billion Ponzi scheme. However, it caused a number of significant fictitious tax credits filed by the investors. So we worked pretty close with LB&I. We partnered with them. So again, it's more like a tax or tax-related type of crime, but we're the only ones that are going to work that, hence why I bring that up. A couple non-tax cases, and these are bigger cases that receive a lot of publicity. This one, these were bad folks. We called it Operation Pocket Sweep. And the reason I bring it up, because Mr. Garland actually made an announcement just back in April, so fairly recent, and you might have heard of it. It was 3 enlisted Army soldiers that were purchasing firearms, and what they were doing is then selling them to members of the Pocket Town gangster disciples out of Chicago. And I bring it up, and I say it was a big deal because, so what these soldiers would do is they'd buy weapons at a reduced price, Glocks typically, like through a Blue Label program. It's a military type discount. And then they'd sell them to these gangsters, gang members in Chicago at a premium price, move money around through these peer-to-peer payment platforms, hence why we get involved. But the reason I bring it up, 5 of those weapons that were purchased were identified in one homicide, a shooting, and a mass shooting in Chicago. So again, pretty big deal. And this is how we help our partners and our law enforcement partners, in the community. Hydra. Anybody heard of Hydra? This was another AG announcement. This was in April. It was the largest darknet marketplace takedown in the history of government. Now, prior to that, it was Alpha Bay and Silk Road, which you might have heard of. And then Then it became Hydra. Now it's going to be something else. But this was a dark web marketplace. It essentially sold, well, they sold a lot of nefarious stuff, but it was primarily narcotics is what they were known for. And then they used virtual currencies to actually pay for it. But we led that case, just to give, again, some perspective. And the other big case that received a ton of publicity this year was the Bitfinex hack, the Bitfinex exchange that was hacked. And that was, at the time, was about a $3.6 billion seizure in and of itself. And I believe it was the deputy attorney, Miss Monaco, got up and said that was the largest single financial seizure in the history of government. So my division led that case. Just again, I'm trying to give you a broad range of the stuff we do. So, and the list goes on. I'll stop there. But so virtual currency, it's not emerging. You know, it's here. I actually have in the division hundreds of cases in inventory revolving around all types of virtual currencies. Very interested in virtual currency and tax. Early on in the virtual currency days, a lot of these were money laundering charges, but it really has flipped. About half the cases I have in inventory now are tax related. So think of unreported income, capital gains, payment for service, employment. I mean, you got employment tax issues in there. A lot of those cases in inventory right now. Not a lot outward facing yet in the tax world, but they're there. So let me shift quickly to hiring, because a lot of times people want to know, I mean, gosh, you got all this work. I mean, how many people do you have and are you hiring? We are hiring now. Mr. Shapiro, we do have about 3,100 people. That's about 2,100 agents. That's 900 to 1,000 other investigative analysts, IT, employment, I mean, HR, a lot of other. But 2,100 sworn law enforcement officers. And it's challenging for me because special agents in federal law enforcement have a mandatory retirement age of 57. And then, but they can leave at age 50 if they have 20 years of service on. So a lot of times what happens is they go and find another job and they retire with an incredibly impressive federal pension. Fiscal year 20, we hired about 330 external folks altogether. That net gain was about 140. Fiscal year 21, about 350 folks, about a 70 personnel net gain. That's everybody I'm talking about. And I bring it up because previous 5 fiscal years, we didn't hire 330 external people combined. So hence I'm hiring. I'm on track to hire about 400 personnel this year. That would be a net gain this year of about 200 people. I mean, if we achieve it. And with this commissioner, we get the funding to plus up. And we need to. I want to get to about 4,200 personnel is my ideal, and we're about 3,100. But it's going to take me 5-7 years to get there. At the pace we attrit. So quality is incredible of the personnel we're getting. We have a continuous announcement out there right now. So kind of selfishly, if you know anybody that you think would be a good special agent, have them go apply because we're hiring right now. Great jobs. All right, time. Okay. I'm going to talk a little bit about COVID because, past 2 years we've been locked down a lot. I mean, my agents never stopped working, okay, but they're in law enforcement. A ton is expected of them. But I want to maybe touch on a couple of things because we are in that space as well. Didn't think it was there, but it's a financial crime, right? So I had to dedicate, time to that, and that took. I gave you those stats from my money laundering space. These are primarily money laundering charges right now, but every single one of them could be a tax charge. And they probably will be as we continue to investigate these in the future. But, we recently marked 2-year anniversary of the CARES Act. We've identified nearly $2 billion in COVID fraud, every program area that you can think of. About 300 indictments since the beginning, 700 cases initiated. The thing I'm most proud of is we got a 100% conviction rate in that program. It's pretty impressive. And it's a disgusting crime if you really think about it. Because the banks that are processing these loans, the professionals that are helping people process these loans, they could be spending their time helping people who really need the money. So, it's a disgusting crime to me. Another kind of interesting talking point I like to say, that I only have through March of this year. It's about a 3-year average sentence for these crimes, these 300 folks that have actually gone through the judicial system and made it to sentencing. So that says to me these judges don't take these crimes lightly. I'll give you one example, just due to time. James Stote was just sentenced to 120 months. Philip Augustine was just sentenced to 68 months in May. So fairly recent. This is common. For some reason, they like to take this money and buy Bentleys. For some reason, it seems that's like that, what typically happens. But these guys, these two gentlemen were out of Florida. There's a nationwide PPP scheme involving millions of dollars. Kind of interesting thing about this one, Mr. Augustine used his network. He was and business contacts as a manager for professional football players. And then submitted applications, false loans. I mean, we all know how these schemes work. But they had about 70, Mr. Stote, I have submitted about 79 fraudulent loans worth about $35 million. And then among those, Augustine, he was held responsible for about 34 other loans. That was worth about $15 million. So this is quite common in this COVID arena. I got 6 other cases here, but for time I won't give it because I mean, they're all pretty similar the way it looks. But when I say COVID fraud, I mean all COVID fraud. And we have cases in every program area. I just mentioned the PPP, but we've got the EIDL loans, you know, the economic impact payments. There's a lot of identity theft in that arena. Personal protective equipment, Form 7200, you know, we're working some of those cases. States unemployment benefits, working a lot of those cases as well. So I'm just continuing to stress to work those cases fast. I just got a briefing up in Seattle this week, you know, where I had an agent work one of these cases in about 6 weeks, which is really impressive, and she did a great job beginning to end. You know, in this arena. So it's had an impact on me. We've learned a lot of things, you know, within CI about COVID. I mean, we've all learned how to use Zoom, you know, pretty well. And it's, you know, the technology has just really enhanced us with training. You know, you can imagine, you know, if I have to send somebody somewhere, now I can train, and you know, maybe I can only put 24 in a class, now I can train 200 people at a time over Zoom. And we weren't really doing that before, you know, so there were some benefits. It's had a negative impact. You know, when you're not in law enforcement, you got to be dealing with people, and our agents are out there. But with all these hiring that I'm doing, new agents need to interact with people because they just don't walk into the job and know how to be a federal law enforcement officer. So we've lost a little bit of that, you know, due to the lack of face time. But, you know, we're back and people are in the offices and working, so a little bit of negative impact. But want to move quickly. Have we all heard of the J5? I know I did this update the last time I did this virtually, but I want to give you a new update that I have. And for those that didn't hear me or don't know what the J5 is, the Joint Chiefs of Global Tax Enforcement, and we refer to it as the J5. These are my counterparts in 4 other countries, specifically Australia, Canada, the Netherlands, and the UK, and myself. Okay, this is a group that was stood up about 3 years ago, I believe. I'm looking at my communications director, Justin Cole, sitting down here 4 years ago. It was stood up at the OECD, the Organization for Economic Cooperation and Development. They asked tax authorities to do more. And so 5 like-minded criminal chiefs got together and formed the J5. So I bring it up, talk about this. This is an hour, 2-hour topic, but I bring it up because just in May, we did a J5 Chiefs meeting, so I got together with my peers in the respective countries, and we set new priorities, recommitted to what we're doing within the J5, revolving around international tax fraud and other financial crimes as well. We had a global financial institution summit with the Wolfsburg Group. So these are the heads of the largest banks where they're talking about public-private partnership with us. Pretty impressive group of folks that we need. We had another just bank consortium with other banks that came in that want to cooperate with law enforcement on an international scale. And then we also have something that I really like. It's called, we dub it the Challenge. We just had this was our 4th chapter of the challenge. I'm like, what the heck is this guy talking about? Picture me taking subject matter experts, law enforcement officers, analysts, putting them in a room with private partners, like contractors. Think of people like, Chainalysis is big right now, Deloitte, really smart, technical kids from the private sector, banks. Put them in a room. I like to figuratively say, and I got to say figuratively, but I lock them in a room for 24 hours and tell them to produce results. This is the fourth time we did it. It's incredibly impressive. What we focused on were NFTs this time and decentralized exchanges. Tax and financial crimes is what the challenge was. Produce leads for every J5 country. And that's exactly what they've done in the previous 3 challenges, and that's exactly what they did in May. Couple results. We reviewed more than 50 active leads. They identified and reviewed 50 active leads. Because again, when they come together, they bring real data that we're legally allowed to see. And they develop these cases, 50 active leads. And we don't operate in a vacuum. I mentioned the 5 countries that are working together, but if we find something in Germany, you better believe I'm calling my German partners and they're going to have the lead. Okay, so it's not, we don't operate in a vacuum. We developed significant NFT cases there. And those are going to be tax type cases that were developed in May. Actually, one of the leads that this team developed, it was a $1 billion, appears to be a $1 billion Ponzi scheme that involves actors in each of the J5 countries. Pretty impressive. Other leads in these decentralized exchanges as well. So did exactly what we said we were going to do. The only other thing for time that I'm going to mention, I just recently participated in a press conference in Puerto Rico with the OSIF Commissioner, the Office of the Commissioner of Financial Institutions. This is a regulator in Puerto Rico. And we dubbed about two years ago, and I've stood here in a lot of forums talking about, we did a day of action about 2 years ago, and the bank is Euro Pacific Bank, okay? But a couple of years ago, we did the day of action. Couldn't really talk about it until recently, but in each of the 5 countries, we did search warrants or interviews or served subpoenas. Went out and talked to people, and then we did publicize the heck out of this again to create deterrence, throughout the J5 countries. But so what happened in June is the commissioner of OSIF. They deregistered Euro Pacific Bank. And I believe, if my memory serves me right, the act is the 273 Act. It's for non-U.S. citizens using this bank, to kind of move money around the globe. So, excuse me, while I didn't have criminal investigations in the U.S., there's hundreds of criminal or civil investigations in my other J5 countries that were using Euro Pacific Bank, allegedly at this point, to shelter money. So pretty impressive result with OSIF down there, and that was a civil action they took to deregister that bank, but that made some press as well. So a couple other cases here I won't get into, just looking at the clock for you guys. I do want to talk about one other thing. This might be my last topic. Klepto capture, and maybe our role in klepto capture. You might have heard where Mr. Garland, he created this task force, obviously. First I heard about it, little inside baseball, that we were on the task force was when he made the announcement, that federal law enforcement was on this task force. But the reality of it is we've always been involved in sanction investigations. This was just formalized. So in March, we joined the Klepto Capture Task Force. Again, we've already had sanction cases in inventory, but it makes sense that IRS CI is on this task force because that's what we do. We track financial transactions globally. That's what we're really good at. Takes a public-private partnership, make no doubt about it, but we're really good at that too. So that's our specialty. We spend a lot of time there. I've spent a lot of time addressing that, over the past, since March, really. Klepto capture in general. Our primary role, I like to put it in 3 kind of buckets. how we're working with our federal law enforcement partners and DOJ in this sanctioned space. We conduct criminal investigations, criminal and civil forfeitures we'll pursue as well, one bucket. We work with the Office of Foreign Asset Control, or OFAC, to expand the Special Designated Nationals List. SDNs is what you hear on the news all the time. The government's real good at throwing acronyms around, but that's what that is. So we work with them to not only freeze assets, but expand that list if we identify bad actors. And then, kind of the third bucket, we share information with our local, state, and federal partners, domestically and internationally. Time's up? Okay. All right, I'm going to close up. Thank you, by the way. Final thoughts, if I could. Public-private partnerships are incredibly important to me. They're weaved in, involved in everything we do, everything, day to day. It's a globally connected world, so as my director always tells me, global problems require global solutions. Be on the lookout for some more J5 kind of outward-facing press and successes that we're going to have. Crypto tax is on. You're going to start seeing some of this. It's out there. So thanks for having me. I do got a new chief of staff back here, Denise Leuenberger. That's with me as well, and my communications director. So I appreciate them being here. Thank you for having me, and thanks for the heads up. All right. Thanks, everybody.
The Tax Lawyer's Guide to Bankruptcy. Good morning, everyone. I am your bankruptcy panel moderator. My name is Richard Commissars, and I'm of counsel at RJS Law in San Diego. Aside from helping debtors deal with tax debts and resolve tax disputes, I've been debtors counsel in bankruptcy court for the past 14 years or so. And with inflation on the rise and other macroeconomic forces at play, a recession may be just around the corner. And with recession comes layoffs, and with layoffs come bankruptcies. When individuals and businesses accumulate tax debt, bankruptcy can be a very attractive option to eliminate most forms of debt, including certain tax debts. As counsel, CPA, or other tax professional for your clients, it is important as ever to have a clear understanding of dischargeability of tax debts, tax liens in bankruptcy, and litigation of tax debts in bankruptcy court, because in many cases, bankruptcy can be the solution your clients need to best solve their tax problems. Our three bankruptcy panelists are here today to discuss these areas, these topics regarding tax debts and bankruptcy. First, certified specialist in bankruptcy law, attorney Mark J. Marcus of Law Office of Mark J. Marcus will discuss the dischargeability of tax debts in bankruptcy. And he has about 31 years of experience handling these cases. Second, Robert Horwitz of Hochman, Sulkin, Tosher, Perez, PC will discuss federal tax liens in bankruptcy, and he has about 35 years of experience in handling this. Third, LeVar Taylor of Law Offices of A. LeVar Taylor will discuss litigation of tax disputes in bankruptcy court, and this is something he's been doing for over 40 years. So between our three panelists, there's a combined approximately 106 years of experience in handling bankruptcy and tax litigation matters. So we'll go ahead and start here with Mark J. Marcus.
Good morning, everybody. Yeah, I think 106 years of experience translates to how many years we've forgotten of things. But how many people here, just a quick show of hands, thought that taxes were not dischargeable in bankruptcy? Okay, so we have a mostly educated audience here, because most of my clients over the years that I've dealt with, assume that you can't get rid of taxes in bankruptcy. And among other professionals, the ones that the ones that know something about it generally believe that certain taxes are not dischargeable, which sometimes they are. So I'm going to go over the dischargeability of taxes, which ones you can get rid of, and how, what tests you need to meet to get rid of them, and some related information on that before I turn it over to my esteemed colleagues. Some taxes are never dischargeable in bankruptcy. Among those include property taxes, excise taxes, and any trust fund taxes, and those are, the pass-through taxes that come, I think it's under our Internal Revenue Code 6672, for anything that you have a trust obligation, a principal of a corporation or something would be responsible for those, and those are never dischargeable in a bankruptcy case. And the Bankruptcy Code does allow for discharge of taxes if certain criteria are met. And the biggest problem that I've found in getting taxes discharged seems to always come with the failure to timely file tax returns. And I'll get into that in more detail in a minute, but I think, one takeaway that I've got for any kind of a tax practitioner is if you've got the ability to have your clients file their tax returns, have them file the tax returns. It's probably the single biggest hurdle to people being able to discharge taxes in bankruptcy. So starting with the most common tax, which would be income taxes. Those are dischargeable in bankruptcy, and these are taxes based on, by the definition in the Bankruptcy Code, measured by income or gross receipts. So these are any taxes that are based on that, and that also includes sales taxes, which is something that many people, including other bankruptcy practitioners, frequently call me up and tell me, you can't discharge sales taxes. And yes, you can, if you meet certain criteria. So those criteria are the first test, the first hurdle that you have to pass is that the taxes must be at least 3 years old from the last date that the returns are due to be filed. So what you're looking at is the due date on the return. So that includes extensions. So if you get an extension to file, which is, as I'm sure all of you know, is I think it's automatic if you get it automatic.
With the state, you get it automatically.
With the state, you get it automatically.
Feds, you gotta send in a piece of paper, but I think there's a new rule that came into effect that if you send in an estimated payment, it's an automatic extension.
Right. So anyway, the extension extends it to the deadline to October 15th of any given year. So you're either running from approximately April 15th, sometimes it ends up being April 17th. I've never quite understood how they come up with the dates. But it has to be at least 3 years from the date the return was due to be filed. Okay.
So I got a question for all, there was all these COVID rules that extended due dates. Do you need to pay attention to those?
Well, the answer to that is yes. But there were several extensions of dates for that, and that does affect the time periods that have to run for the tax dischargeability. So the next, and also that 3-year period can be extended. The biggest reason for extending that would be if you're in a prior bankruptcy case. So any time that you're in a bankruptcy case, that 3-year period is told, because you can file multiple bankruptcies. So it is something that can affect the running of the 3 years. And this is sort of a caveat to anybody who's trying to figure out whether or not a tax is dischargeable, is that there's probably, a dozen exceptions to each one of these rules. So you really need, this is not a pitch for my services, but you really need a bankruptcy attorney to analyze the transcripts and go through all of the different things to make sure that the taxes are actually going to be dischargeable. The guidelines that I put in my materials for you is something you can use that will definitely give you a pretty good idea of whether or not the taxes are dischargeable. But like I said, there's lots of exceptions to everything, so you really need somebody who knows what they're doing to go through and make sure. So the 3-year period is one requirement. The next thing is that it has to be at least 240 days from the date the taxes were assessed. So the bankruptcy case has to be filed at least 240 days after the date of assessment. The date of assessment becomes extremely important when you're dealing with taxes such as sales taxes, and I'll explain why in a minute. But, because it's usually pretty easy to figure out what the date of assessment is for IRS taxes and franchise tax board taxes, because you can get it, it shows on the transcript what the date is. And so it's usually easy to calculate that. Sales taxes are a lot more difficult because they don't really publish that information, and you can get it, but it's not easy. And you need to, the biggest problem you run into with sales taxes is that it's typically the individual who is having what they call the dual determination made against them by it's the California Department of Tax and Fee Administration now, CDTFA, that they have 3 years to make that determination after a business is closed. So a lot of times people come to me and they say, I've got $600,000 worth of sales taxes. And after I get over the shock of, how they underreported that much sales tax, you have to tell them that the taxes haven't even been assessed against them yet. They're still, they had an audit done, but they haven't assessed the tax against the individual yet. So it has to be at least 240 days after the taxes are assessed against the individual, and the agency, the CDTFA, has 3 years from the date that the business is closed to make that determination. So it can be quite a while before that 240-day period runs against an individual trying to get rid of sales taxes. But sales taxes, you can get rid of them in bankruptcy, you just have to have those time periods run.
Yeah, just so you know who lost the Ninth Circuit case that said you have to be assessed against the individual, right? That was me.
Oh, is that right?
40 years, you get a chance to lose a lot of cases.
I did not know that. All right, so now that 240-day period can also be extended, as with everything. And the main reason for extending that would be if there's an offer in compromise pending. So for any time that there's an offer in compromise pending, you have to add, I believe it's 30 days more on an offer in compromise. And if there's any other stay of collections during that 240-day period, it's extended by 90 days. But offer in compromise is the most common thing that I run into, so you need to add additional time for that. And obviously the reason for that is obvious. It's just, during an offer in compromise, they're not able to pursue collections, so they're not really getting the benefit of the time period. So that is the 240-day period, and one of the next requirement is that the taxes cannot still be assessable after the filing of the bankruptcy case, and that is pretty much the concept of the sales tax issue that I was talking about, that you can't get rid of taxes that haven't been assessed yet. So they can't be still assessable. So that's that. And the next prerequisite, as sort of a prerequisite, is that there cannot have been a willful attempt to evade or defeat the tax or filing a fraudulent return. If you do that, I suspect you'll be hearing from our friend that was just talking a few minutes ago. That is something that will prevent the tax debt from being discharged. If they can prove that there was a willful attempt to evade paying the tax, then it will not be discharged. It's a little bit difficult to determine that ahead of time because typically your clients are not going to come in and tell you that they willfully evaded trying to pay the tax. And there isn't usually something that you can see on a transcript that tells you that that's the case. Although actually you can get that information if you dig. If they audit, if they've done an audit, usually that'll show up in an audit. Sometimes you just have to really dig into the facts of why the taxes weren't paid and try to get a sense of whether that's a risk or not. That ultimately that's something that would have to be determined by a bankruptcy court as to whether or not there was a willful attempt to evade. And the last overall main requirement for discharging the taxes is the one that is currently getting the most the most analysis in the courts, and that is that the tax return, if required, must have been filed at least 2 years prior to filing the bankruptcy case. So we have, a lot of times where, our clients don't file their tax returns or they don't file them on time. And so this creates a big problem. So obviously they can go back and they can file their tax returns and then wait for 2 years to run. But then the question becomes, and there's a litany of court cases on this, which I set out a few in my materials, dealing with whether or not, when you file a return late, if it actually constitutes a return. And the thing that the courts look at, the overall idea that most of them seem to hold on to on this, is whether or not the subsequent filing of a late return is an honest and reasonable attempt to satisfy state laws. And the problem is that when the IRS or the Franchise Tax Board file a substitute return, that becomes the return. And my experience has been that it's very difficult once that happens to ever prove that if you file a return after that it's going to count as a return. It's typically the substitute return that's filed that's going to count as the return, which does not satisfy the requirement for discharge in bankruptcy. Just looking through the different types of cases that they've found on this, like a tax return being sent to Arlington National Cemetery rather than the Internal Revenue Service did not clearly constitute an honest and reasonable attempt to file a return. There's just some really weird cases out there as far as what people try to argue are honest and reasonable attempts. And so that's the basic. I mean, determining that, like I said at the outset, the biggest problem that I run into as a practitioner is people not filing their tax returns on time. It's not impossible for them to file it late and still be able to discharge the tax, but once a substitute return is filed by the agency, it's still not impossible, but then you're getting into a situation where your best case scenario is you're going to end up having to argue the case in front of a judge that's going to have to determine whether or not the return that was filed constitutes an honest and reasonable attempt to satisfy the bankruptcy laws.
What about these crazy courts outside the Ninth Circuit that have done this one-day late rule?
Yeah.
What does that mean?
Yeah, well, fortunately, since I'm in the Ninth Circuit, I've been able to ignore most of those cases. But yeah, there are very draconian decisions of courts across the country. That have basically said exactly what he just said, that if you're late on filing the return, it's never dischargeable. Okay, that is not what the bankruptcy code says.
There's 2 courts of appeals, or 3 that disagree with you.
Yes, there may be more than that, but it is
And
not, it is,
it's all due to that little hanging paragraph
yeah,
added by Congress.
right. So as with many things in the current bankruptcy code, it's not the best drafted piece of literature in history.
And where the case law might be against a debtor here with regards to dischargeability when there's a late filed return, what about IRS policy as compared to, say, the case law?
Yeah, actually, I'm not sure that I'm up on the current IRS policy on that. They do publish what their policy is on it. I don't think even the IRS agrees with those decisions. It says that it's 1 day late.
Oh, no, it's the states that are out there
Right.
pushing
Right.
the 1-day late rule.
Right.
The IRS disagrees with it. There's actually, if you go look at this, there's 4 different positions. Three of them have been adopted by the courts. One was adopted by the IRS, Darren, but no single court has ever agreed with the IRS position. That's Darren Dio there. He's like the collection maven for the IRS nationwide.
Yeah, so right. So there's this sort of continuum of lateness, you know, for tax returns, and when does it become too late? And the problem is you just don't know until you get. It depends on where you're located, which jurisdiction, and you know what the facts and circumstances are for the late filing of the tax returns. Obviously, I think it's better to file the return than to not file it, aside from the fact that you're legally required to.
Darren agrees.
I mean, it's like, yeah, I've never understood why people don't file their tax returns. I mean, I hear the excuses, I just don't really understand it because, you know, you're not required to actually make a payment with the return when you file the return, so file the return. And that takes care of the problem right there.
But the one thing, there's a split in the circuits. So I'm afraid of what the Supremes are going to do when they get their hands on this issue.
Yeah.
So if you're advising clients, we're safe here in the Ninth Circuit for now.
For now.
Until they grant cert.
Right.
And then who knows?
Right, that is definitely a scary proposition, but again, the best thing is just to file your tax returns. Really quickly, how am I doing on time?
Pretty good.
Are we in the
range?
In the range. So the other interesting thing is that tax penalties. So what I was talking about was the actual underlying tax and the dischargeability of that. So penalties can also be dischargeable in bankruptcy to a certain extent. In a Chapter 13 case, all tax penalties are dischargeable. The Chapter 13 is a bankruptcy where you're making some kind of a payment plan to your creditors based on your budget and other factors. So you can get rid of penalties in a Chapter 13 case, even if they're not dischargeable otherwise, meaning even if the underlying tax is not dischargeable. So that is a very powerful tool because sometimes there's massive penalties on these debts. Something people haven't paid them for 20 years or something, and they've just got huge penalties. And even if they didn't file the tax returns, and the underlying tax is not dischargeable, you can get rid of the penalties in a Chapter 13 case. And in a Chapter 7 case, you can get rid of the penalties, but it's only for, they have to meet the requirements for, it has to be more than 3 years old, basically, for the tax return, from the tax return due date in order to get rid of the penalties in a Chapter 7 case. So I can go through, if I've got a little time, I can go through how the taxes are treated in the various chapters, or
Kind of
might be
bit
overlapping
on,
some of
bit
those.
of-
Yeah.
bit- yeah.
Okay, great. That's my, and if anybody has any questions, we'll take them at
We'll
the
take
end,
them,
or?
yeah, we'll take
Okay.
questions.
Okay, excellent.
Or sorry,
Okay,
Robert?
I'm up, thank you. I'm going to be talking about federal tax liens in bankruptcy. Tax liens and levies are probably the IRS's main tool for collecting taxes from people who don't pay them on time with their returns or make their estimated tax payments. And the IRS tax liens have been around since the first tax acts, way back at the beginning of late 18th century. And there's always been that where a taxpayer is assessed a tax by the United States, there is a lien that arises in favor of the United States against all the taxpayers' property and rights to property. Up until, I believe, the late 1930s or early 1940s, the tax lien was always a secret lien. It was good against everyone, and the IRS did not have to file a notice of tax lien. And the rule was the person you won't have priority over the tax lien unless you obtain an interest in the taxpayer's property prior to the IRS lien arising. And so someone, like in the 1920s, before they had the lien notice statute, if an individual purchased property from a taxpayer, bona fide purchase for cash, and did not know that there was a tax lien because there was no notice of lien filing, the IRS could come in and say, we have a lien, sorry, you took that property subject to our lien. And basically, a tax lien arises under 6321, sets out when a tax lien arises and what the lien attaches to. And it arises in favor of the United States upon assessment of a tax, when the taxpayer fails to pay the tax after notice and demand. In the assessment, there's something they call, you must remember this, the 23C date, LeVar?
Sure.
You want to tell them what it is?
It's the date some IRS official signs a form, the 23C form.
And that is the date that, in these 23C form, it used to be a long roll of paper where they would write the name of everyone who owed taxes and the amount that was being assessed. And then at the end of the week, someone at the IRS district director's office or the service center would sign the roll, and that was known as the 23C row. I think it's now all computerized, probably.
Somebody's got to sign a form.
Yeah, but someone has to sign it. Darren, do they e-sign it now, or? I don't sign. Okay. But there has to be, the assessment has to be made, and the IRS has to give notice and demand to the taxpayer that he owes the tax and he has to pay it. And prior to the time the IRS had kept computer records, when all they had were paper files, occasionally the IRS would lose a copy of the letter the initial letter, notice and demand for payment. And it would go in to enforce its lien, and every once in a while, if you go back to cases from the 50s or early 60s, you will find a case where the court has held that the government lien did not arise because the government failed to prove that it actually made notice and demand, and the taxpayer testified that they never received notice and demand. But I don't think that occurs anymore because the IRS now has its computer records that say notice and demand sent, and the courts accept that as basically almost irrebuttable proof because the IRS doesn't keep those paper notice and demand letters anymore. Now, the tax lien attaches to all property and rights to property of the taxpayer, both owned at the time of the assessment and acquired after the assessment. So it doesn't matter if 8 years after the assessment, if the tax has not been paid in full, and the taxpayer acquires property, no matter how it's acquired, the IRS has a lien against it. And it is automatically perfected. And the IRS doesn't have to do anything other than make the assessment and send out notice and demand for it to have priority over the interest of the taxpayer and the interest of any other person who acquires an interest in the property after the lien arises, except as provided by Congress. And this is regardless of whether or not a lien notice has been filed, and that's set out in the United States versus Vermont case and the City of New Britain versus United States Supreme Court cases. And the amount of the lien is for the unpaid tax plus all penalties, interest, additional amounts, additions to tax, and costs. And the IRS, they say additional amounts and additions to tax. If you look in Chapter 63, that is the penalty chapter of the Internal Revenue Code, it's broken out into the first part is additional amounts and additions to tax. Those are such things as the late filing and late payment penalty, which Mark alluded to about all the penalties that accrue, and they can accrue payment and late filing penalties to almost 50% of the amount of the unpaid tax. And a person could go into bankruptcy and they pay down almost all the amount of the original tax, but it took them 4 or 5 years to do so, and they have tens, hundreds of thousands of dollars of penalties and interest on the penalties that are unpaid. And all of that is going to be covered by the IRS lien that arises upon assessment. And the lien continues for a period of 10 years or until the tax is satisfied and paid in full, including all penalties, interests, additions, and costs. Now, the 10-year period is statutory under Section 6502 of the Internal Revenue Code, and 6503 contains exceptions to, and other provisions contain exceptions as to what extends the statute of limitations. Mark alluded to the fact that an offer in compromise extends the statute of limitations. If the IRS, under the 1998 Tax Reform Act, the Congress enacted 6330, 6331, and 63. But basically they gave 6320, and they gave taxpayers the right, if the IRS sent them a notice of tax lien and your right to a due process hearing, or a notice of federal tax lien, a taxpayer within 30 days after that notice can appeal the determination and seek an appeals hearing, and if appeals upholds the IRS lien or proposed levy action, they can go to tax court. And if they do protest timely, then that suspends the running of the statute of limitations until the case is all resolved, I think for 60 days thereafter. If a taxpayer leaves the United States and is away from the United States continually for 6 months or more, that suspends the statute of limitations on collection during the time the taxpayer was away from the United States. So someone could go on the Antique Roadshow, they go on and they bring a painting that they had always liked, that their grandparents had, that their grandparents gave the person when he or she got married, and they come on and say, we're not sure whether this is worth anything. Little did they know that just before their marriage, their grandparents had been in a abusive tax shelter partnership, got hit with the big assessment, they got the painting, they bring it in, the grandparents had moved to Costa Rica to retire, haven't been in the United States for 6 or 7 years, and now it's 15 years after they got the gift, 16 years after the assessment, but the statute of limitations is still open because the grandparents that lived out of the U.S., and they go on the Antique Roadshow and the person says, I got this from my grandparents, Mr. and Mrs. So-and-so, and I don't know if it's any valuable, and they look at it and say, God, this is an Arthur Dove. Arthur Dove was an early 20th century American painter who was one of the leading post-expressionist painters in the U.S., and this is worth $2.5 million. An IRS revenue agent is watching the show, realizes that name sounds familiar, the grandparents, and then they go and they bring a lawsuit against the owner of the painting to foreclose upon the oil painting and sell it. It's sold, and there's just enough money to pay the IRS. And that's because they weren't a bona fide purchaser for value. They got it as a gift from the grandparents, and the grandparents left the country, so the statute has remained open indefinitely. Now then, to be valid, In Congress, like I said, around 80 years or so ago, passed what is currently 6233 of the Internal Revenue Code, which provides that to have priority over certain persons, the IRS must file a notice of federal tax lien. And that is a bona fide purchaser for value who acquires, purchases the property prior to the IRS lien filing, a person who obtains a security interest that's perfected under state law prior to the time that the IRS notice of lien is filed, someone who obtains a perfected mechanics lien, and a judgment lien creditor whose lien is perfected under local law. If someone has obtained that status before the notice of federal tax lien is filed, then they would have priority over the United States. It's tax lien. Now, there are also several classes of persons who can have priority over a federal tax lien, even if they acquired their interests after the tax lien were filed. These are people who acquire securities if they do not have actual knowledge of the tax lien, someone who purchases property at retail after they file if they don't have actual knowledge, someone who purchases a motor vehicle without actual knowledge. There's also an exception for someone who is doing commercial security financing secured by accounts receivable. They'd have a priority over the IRS for accounts receivable that came into existence within 45 days after the lien is filed. But the most important one of these for purposes of the bankruptcy cases are the judgment lien creditor, and that's because under the bankruptcy code, the trustee in bankruptcy, or in a Chapter 11 case, the debtor in possession, has the status of a judgment lien creditor who's perfected his judgment lien at the time the bankruptcy petition is filed. And so even though technically the IRS secret lien, if someone doesn't challenge it, could be viewed as being remaining throughout the bankruptcy, the IRS takes the position that if we didn't file a notice of tax lien prior to the time the bankruptcy petition was filed, then we don't have a secured interest in the taxpayer's property, and so all we have is either a unsecured priority claim or an unsecured general claim for the unpaid taxes, penalties, and interest. And unlike the unperfected lien where the notice of lien has not been filed, it's normally very difficult to defeat a filed federal tax lien in bankruptcy if the taxpayer still owes the tax. There was a recent case out of Tennessee bankruptcy court, and there was a blog this morning in Procedurally Taxing, which is run by Keith Fogg. And it's, if you're interested in basically tax procedure and tax controversy, you should periodically at least look at Procedurally Taxing, because they have a lot of good stuff. Look up LeVar occasionally blogs for them. I've blogged for them a couple of times. And it's a very good thing. It's a case called Stevenson. It was in the Eastern District of Tennessee, and the IRS had filed a tax lien against the taxpayer who consistently had filed tax returns that showed that used her mother's address as her address, except the taxpayer, and she did that because she would move from job to job, state to state. She'd be in Colorado for 8 or 9 months as a waitress. Then she'd get a job in Kansas, so she'd move to Kansas, and she thought, I'll have my most important documents sent, including my tax returns. I'll have that address as my mailing address. And so the IRS assessed taxes, filed a tax lien in the county in Tennessee where her mother resided, because that was on the tax return. And to be valid, the 6233 has provisions that to be valid, a tax return against real property has to be filed in the county where the property is located, pursuant to in the office designated by state law, which is usually the county recorder or the county clerk. As to personal property, it has to be filed in one location as designated by state law. I believe in California it would be filed with the Secretary of State.
Only for non-individuals.
Okay.
For individuals, it's the county of their residence at the time the lien's recorded.
Yeah, and in Tennessee, it was the county of residence. And so the taxpayer went in to challenge the IRS's lien as being invalid on the grounds that, well, when they filed the lien, sure, it had my mother's address, but that wasn't where I resided. I resided in the county next door, and the court did an analysis and determined that the taxpayer, in fact, did not reside with her mother, even though she used that as the address on her tax return. She resided in another county, and therefore the IRS's lien was not secured, and since these were all owed taxes, the taxes were dischargeable.
Thank you. I think we're going to need to move on here to litigation.
All right, before I get into litigation, I want to tell you a story about this woman who was driving 80 miles an hour in a 30-mile-an-hour zone. She was pulled over by this rookie cop, and he got out of his car, walked up to her window, and he says, "Excuse me, ma'am, you were going awfully fast. Can I see your driver's license?" And she said, "I don't have a driver's license. I got like a bunch of tickets for drunk driving, and I don't have a license anymore." He goes, "Okay, can I see your registration?" She said, "Well, I don't have the registration for this car. I stole it. Not only did I steal it, I killed the owner and chopped up its body into little parts. They're in the trunk. You want to see them?" And the officer said, "Well, ma'am, why don't you just wait right here?" So he leaves and he goes and calls his commanding officer. The commanding officer comes there with a couple other cars just because of what he's been told. And so the commanding officer walks over to the woman. She's still sitting in the car. And he asks her, he says, "Excuse me, ma'am, I've been told that you have a body in your trunk. Would you mind opening your trunk?" She says, "Well, my trunk's completely empty. I'll be glad to open it for you." She opens the trunk. He looks in there. There's nothing in the trunk. He says, "Well, I've been told that you don't have your registration to the car." And the woman says, "Oh, absolutely, I have the registration. Here it is. I'll reach into the glove compartment. Here it is." He says, "Well, I've been told you don't have a driver's license." And she says, "Oh, no, absolutely, I have a driver's license." And she opens up her purse and hands him the driver's license. And he says, "I can't believe that nothing I've been told is true." And the woman said, "And I bet you that cop told you I was speeding, too." All right, so litigation. Here's what happens, at least in my practice. A lot, way more often than it should. Somebody walks into my office and says, "I got this piece of paper here from the IRS that says I owe them a bunch of money." I say, "Well, can you show it to me?" It says, "Oh, it's a notice of deficiency." "Okay, when you got this, did you do anything?" "Well, I was busy, my dog needed manicuring, whatever it is." They always have excuses, right? And I look at the date of the notice of deficiency, and it's like 95 days before the day they walk in, so it's too late to go to tax court. They're gonna get a bill, okay? This can happen at the state level with sales tax audits. You got 30 days to file an appeal. It can happen with EDD, it can, or an NPA from the franchise tax board. These people miss deadlines right and left, and they come walking to you, and now what do? Well, there are certain things you can do without filing bankruptcy. You can try audit reconsideration with the IRS. Franchise tax board really doesn't have formal audit reconsideration. And so what can be done in that situation? Well, one option to discuss with the client is to file bankruptcy and challenge the tax in bankruptcy. Now, that's not the only time you can litigate in bankruptcy, and that's what practitioners like myself, and I suspect many of you, see, okay? But I want to talk a little bit about the different types of tax-related litigation you can have in bankruptcy. I started to make this list, and it went on, and I got down from A to K, and I stopped because I don't have much time to talk today. So I'm going to just talk about it so you understand what can happen, when are the circumstances you can litigate. taxes in bankruptcy or have tax-related litigation. First circumstance is an objection to claim. Taxing authorities, like all other creditors, have the ability to file claims in bankruptcy. And when they do file claims, you can object. The interesting part is that, you know, in bankruptcy, everybody's fighting over money. You have creditors competing, okay? And the IRS wants to come in and get it, and the Franchise Tax Board wants to come in and get it. Everybody's competing. And so the focus is, yes, the debtor, but more importantly, the debtor's money or the debtor's ability to earn income to pay off debts. And so you file a claim to get a piece of the pie. Outside of bankruptcy, you know, there's rules on when you can litigate. Sovereign immunity comes up all the time. Inside bankruptcy, if a creditor, including the state of California or IRS, files a claim, they waive sovereign immunity and you can go sue them and challenge them on the claim. An interesting footnote in this claim objection litigation is that any party in interest can go do litigation. So you have a trustee in bankruptcy, the trustee can file an objection to the IRS's claim. If there's a creditor out there who would get paid money if the IRS claim went away, the competing creditor can file an objection to the claim. So that makes bankruptcy a little bit unique. So the first category is actually they file a claim and you're going to object to the claim and try to knock it down. Second type of litigation is under a code section in the bankruptcy code called section 505. 505 is this, you know, not completely magical, but quasi-magical code section that allows debtors to come in, people who file bankruptcy, and that's the key. You can't use the bankruptcy code unless you actually file bankruptcy. And before you file bankruptcy, you don't just need to talk to somebody like me, you need to talk to somebody like this guy sitting to my left, right? So you file bankruptcy. Section 505 allows debtors to challenge liabilities in the bankruptcy in situations where you cannot challenge them outside of bankruptcy. I just briefly mentioned the first type of situation where the client has blown the deadline to file an administrative appeal with the state or has blown the deadline to file a tax court petition. Even though they've blown those deadlines, inside of bankruptcy, it's possible to litigate.
LeVar?
Yeah.
Can you use, normally when people use 505, it's because there has been an assessed tax or a notice of deficiency or 30-day letter issued where the IRS is claiming that a certain amount of tax is owed, and where there is a determination by the IRS, even if there's not an assessment, that's presumed to be correct by the courts, and the taxpayer has a burden of proof. Can a debtor who's under audit go in and file a 505 while the audit is still ongoing and there's been no determination by the IRS?
The debtor can file a 505 action even though the audit's not complete. Sometimes in that situation, the debtor may file what's the last thing on the list, and that's litigation to estimate a claim. So if there's pressure to confirm a Chapter 11 plan, and the court saying, you need to confirm the Chapter 11 plan, but there's this pending IRS audit, and we need to figure out how much is owed to the IRS to get the plan confirmed, but it's going to take 10 years to litigate in the tax court and the Ninth Circuit, and maybe the Supreme Court if there's a split in the circuits. You have a claim estimation hearing where the bankruptcy court estimates the amount of the claim for purposes of the Chapter 11 plan. So you can either do a claim estimation motion, and they're rare, but actually I've had to do 2 of them in the last couple of years. Or you can actually file a 505 proceeding, but what's going to happen if the audit's not complete is the Department of Justice, who represents the IRS in bankruptcy cases, is going to come in and they're going to raise their hand and say, hey, look, Judge, we need more time. If it's just a straight 505, they're going to say, we want more time, and you can do it, but it's going to, it won't move as quickly as if they've already assessed it. Next.
One other thing, since it's an estimate of tax, is it going to be res judicata, or can the IRS continue an audit, subsequently determine that more tax is owed, in which case
it's not res judicata. A ruling in a claims estimation proceeding is not res judicata, but the reality is there's the infamous case from the IRS's standpoint called storage technology. It's 40 years old, And what happened was, it was a corporate audit, the IRS was claiming $1 billion, and they came in and from the IRS's standpoint, sandbagged the IRS on a claim estimation proceeding. And basically, the result of the claim estimation proceeding was that what happened, was followed by the government, because they were going to have to litigate in front of the same judge who ruled against them on the estimation motion. You can also go in for refunds under 505. You better have dotted all your I's and crossed your T's as far as being able to get the refund under the rules outside of bankruptcy, or else have filed a claim while the bankruptcy is pending. And there's a rule that allows the court to consider it on an accelerated basis. Another type of litigation, tax-related litigation in bankruptcy, is whether or not the taxes were discharged. So we talked about this one-day late rule, okay? And at least here in the Ninth Circuit, we don't have that rule, but at any point in time, one of those pesky state taxing agencies could invoke the one-day late rule. Again, the IRS is not going there, but the state could. And if a state agency does that, then you may have to go to court and litigate that, or if you want to go to court and litigate. Here's the tip, folks. I have never, in 32 years of private practice, unless I know for a fact that the IRS is coming after my client on the theory that the tax was discharged, I have never, ever filed a complaint to determine dischargeability. Why? Because it's a whole lot better to be able to deal with non-attorneys than it is the Department of Justice when I'm talking to them. And it's a lot less expensive. So I've never, unless I knew I was headed to litigation anyway, I have never gone there. There's people, if you go look at all the bad case law out there, most of it results from people going into court under circumstances where I would never go. So that's another type.
Sorry, so is it a cross your fingers and wait and see what the outcome is type of
If the
approach?
client can wait, because what happens is, the IRS gets notice of the discharge, and then some bankruptcy analyst will look and say, okay, let's pick up the file and see whether or not they think it's discharged. And you can talk to those people. You can call them and talk to them, and I'd much rather be talking to one of them than the DOJ attorney.
And if it's a dischargeable tax, but the IRS has a filed notice of tax lien that still survives, that will survive bankruptcy, if the IRS determines that it's been discharged, you can usually buy out the IRS interest for what the IRS calls, if you come up with a reasonable amount. So
Yes, you can do that, and just so you understand, if the tax is discharged, what Robert just described is technically not an offer in compromise. The manual says if the liability's been discharged and all we're doing is enforcing our lien, we can't do an offer in compromise because there's no liability to compromise. You're actually just, if all of you remember Let's Make a Deal in Monty Hall, some of you are old enough to remember Monty Hall. It really is Monty Hall territory. You go in and you make a deal.
and it's advisable to do so because the statute of limitations is extended due to the bankruptcy for the period. The lien itself will survive because the statute of limitations is theoretically extended. So the lien will be extended, and the IRS may wait 2 or 3 years. The taxpayer has built up equity in the property, and then they could come in and try to foreclose and claim we get all the equity that's built up.
Well, I can argue against that based on something, but you could, which also can cut going that direction. And that depends on whether property values are increasing or decreasing. If property values are decreasing, and I know with reasonable certainty that the property value is going to go down, I don't want to go talk to the IRS about buying back their lien right now. I want to wait till the property value goes down. If I believe the property value is going to go up, I want to talk to them yesterday, not tomorrow. And in fact, I had a case once years ago where the IRS had a lien against a piece of property at the time the bankruptcy was filed. There was no equity. 5 years later, because the statute of limitations was still open, the property had $500,000 of equity, and guess what they did? They went to court to foreclose their lien and take away my client's house. So in that case, had the client gone and tried to buy it back early on, they would not have faced that situation.
Right, and we eventually settled it with the government.
We did eventually settle it.
Less than the amount the government claimed was due, but more than they could have bought out their equity.
So, I got maybe 5 minutes left, and I want to talk about some of the other types of litigation that takes place. One, there's litigation on what I call plan feasibility. Okay, let's say you got a corporation that has net operating losses, and they're not sure if they can use the net operating losses, and they must be able to use the net operating losses in order to generate cash flow to pay creditors. So the feasibility of a Chapter 11 plan is entirely determined by reference to taxes and the availability of the net operating losses, and what's the effect of the discharge on the net operating losses, and you get into 368 L5 or whatever the code section is, and it gets really hairy. And so what happens is the debtor will go up to the court and put on evidence. They'll get usually an accounting firm that deals with net operating losses every day, and put an expert on the stand and say, yes, these net operating losses are going to be good, and the court makes a feasibility determination saying, okay, the net operating losses are good, the plan is feasible. Okay? Now, if the IRS comes along 2 years later and says, we want to audit the return to see whether or not those NOLs are really good, sometimes debtors have said, wait, we litigated this and you're bound by the ruling of the bankruptcy court. And most courts have said, no, nice try, doesn't work, because the IRS wasn't there, you weren't litigating the actual merits against the IRS. It was just a feasibility determination. And guess what? The IRS can come in and try to wreak havoc on the feasibility of your plan afterwards, and there's nothing you can do about it. That's another type. Another very interesting type is fraudulent conveyance litigation. And there's two types. One you probably have thought of, and the other one you probably have not, unless you're in the bankruptcy community regularly. First type is where the IRS is suing for fraudulent conveyance. Well, a trustee in bankruptcy can come in, steps into the shoes of all creditors and can bring fraudulent conveyance actions on behalf of all creditors. Not only that, in cases where the IRS is a creditor, courts have said that the trustee can invoke the statute of limitations that the IRS could use, which means you could go back, I won't say quite to the beginning of time, but back to the beginning of the tax liability. So if you file a bankruptcy 9 years after the tax was incurred, because the IRS could go back and file a fraudulent conveyance action for year 2, with the tax liability being in year 1, the trustee can go invoke that statute of limitations and go sue creditors. So be very careful when you're talking about putting your client into a bankruptcy in Chapter 7 to discharge, because if there was a fraudulent conveyance 8 or 9 years ago, the trustee can chase it under this line of cases. The second type, you have not really probably heard much about it, and that's where you sue the IRS for a fraudulent conveyance. I mean, how much fun is that? All right? I'm in one of those cases right now. What happened? S Corporation. S Corporation cuts a check directly to the IRS for the shareholders' taxes. And the corporation now is becoming insolvent. And guess what? You can sue. There's 9th Circuit case law right on point. You can go sue the IRS to get that money back, the same as you get it from any other creditor, on a fraudulent conveyance theory. One caveat. There's some pesky other Circuit Court of Appeals that says, in that situation, the IRS hasn't waived sovereign immunity. I don't think they're right. But there is a split in the circuits, and at some point the Supreme Court's going to decide whether or not there's a waiver of sovereign immunity in that situation.
What happens if a corporation pays the IRS for past due taxes, income taxes, couple of months before they go into bankruptcy? Can the payment be set aside as avoidable preference?
Under certain circumstances, the IRS could be sued for a preference. If it's payment of trust fund taxes, forget it. It's not going to happen. But if it's just regular old taxes and a preference, basically, within 90 days of the bankruptcy, you make a payment to a creditor that's not in the ordinary course of business. And it allows that creditor to get more than they would get in a hypothetical Chapter 7. That transfer could be set aside as a preference. Theoretically, the IRS might raise sovereign immunity, but, it's out there. Am I out of time?
Close, another minute or so.
Oh, great. So, classification of tax claims, okay? We talked about, I cite some stuff. One was a case handled by our office, and that is, how do you classify a claim? Is it priority claim? Is it general unsecured claim? That's really important, because general unsecured claims, if you got the right facts, get treated like dirt, okay? whereas a priority claim, you got to pay it in full to get the plan confirmed. So we had a litigation over, my client got audited by those sales tax folks. My client sold cigarettes. There was an audit for cigarette excise taxes, okay? And they came in and said, well, it's not assessed yet, and therefore it's priority. And we said, no. Excise taxes have a different rule. If it's more than 3 years past the due date of the return, it doesn't matter if it hasn't been assessed yet. It's general unsecured creditors, and we can treat it like dirt. And guess what? The bankruptcy code said, you're right, you can treat it like dirt. So that's another type of litigation, whether it's secured. Robert talked about filing a lien notice in the right place. I'll end with a war story. Years ago, we had a client, was a retired law enforcement person who retired and went and sailed around the world in their yacht. Stopped filing their tax returns. Didn't realize that their pension, which they used to fund their expenses, around the world, the IRS could do substitute for returns. It was taxable, and the pension's a really easy levy source. So eventually, the IRS levied the pension, forced the client to come and file bankruptcy. The IRS had filed a lien notice in Florida, which was the last stop of our client before he left around the world to go to wherever. And the IRS said, oh, he lived in Florida. That was the right place to file a lien notice. We said, oh, no. He didn't live anywhere in the United States at the time, and if you don't live anywhere, the IRS has to file in Washington, D.C. So we actually litigated whether or not the IRS had a valid lien against the boat. And if they didn't have a valid lien against the boat, it was an unsecured claim and could get treated like dirt.
But there's another thing, and that is if a taxpayer has in a Chapter 7 case, under 724A, the IRS secured claim is the penalties and additions to tax are not part of the secured claim.
Right. So so penalties get treated worse than dirt in bankruptcy. I mean, they just like they're down underneath the dirt, the core of the earth, and they get nothing. And you can there's all kinds of tricks up my sleeve when I'm dealing with penalties, but you have to watch out because a trustee could come in and step into the shoes of the penalties and then take the debtor's property.
And even if it's a secret lien, no lien has been, notice of tax lien has been filed, there's something called exempt property, which never becomes part of the bankruptcy estate, and that would include pension plans.
ERISA qualified pension plans, not IRS.
Yes, ERISA qualified pension plans, homestead exemptions, and even though since that's not part of the bankruptcy estate, the secret lien continues to attach, and after bankruptcy discharge, the IRS can go and levy on.
That's true. That's true if it's not property of the estate, but if it's exempt property, they can't do that.
Well, if it's exempt, it's not property of the estate.
No, it is. It is exempt. It is, but then it's exempted.
Yeah.
Great. Okay. I want to thank the three bankruptcy panelists very much. It was a great presentation, and we've been over on time.
Oh, you must stand up. Oh.
They can see our suits.
Yeah, we can see our suits. I always wonder how you say that word. Break it in.
It's like to sport. It's like to wear something for the first time. You know, like be proud about it.
Yeah, exactly.
Sport. Like first kids in school.
Yeah, some words are better. They even have more flavors.
Yeah, of course.
Hello.
Thank you to everyone in attendance today. We're so happy to see your faces and to join in a day of education and collaboration on all things tax. I want to start by thanking our panelists for accepting our invitation and joining us here today. We have a wonderful panel featuring leaders in the field of international tax. We're going to move through two main topics, the foreign tax credit development and a major Ninth Circuit caveat, attorney-client privilege in tax matters. Although many of you in the audience today might not deal with international tax matters in their daily lives or work, as you will see, these two topics are of the utmost importance to all of us. Our first topic, the foreign tax credit, presents an opportunity and potentially a trap for the unwary for all tax preparers and accountants. Almost every tax preparer and accountant will at some point have a client with foreign income and associated income taxes. The foreign tax rate may enable the taxes on that foreign income to be offset against US tax and may prove as a valuable tool for tax professionals and their clients. As for our second topic, attorney-client privilege in tax matters, a major case in the Ninth Circuit may change the landscape of how we communicate with our clients. The case in Rare Grand Jury 2022 affirmed the decision that written advice from international tax lawyers is not protected by client attorney privilege. If the same rationale used to decide this case is used in others, then the decision could impact attorney-client privilege matters in all other areas of law. Now, to introduce our panelists. Patrick Martin is a partner at Procopio, Corey, Hargreaves, and Savage. He advises clients on a variety of tax-related matters. He's also a former chair of the State Bar of California Taxation Section. My former boss and the person who inspired me to get into international tax. He's a passionate underwater cave explorer, and I would not be here today without him. Thank you, Patrick. Diana Gis is an international tax manager for Deloitte Tax. She provides a wide variety of international tax compliance and consulting services with U.S. cross-border issues. She has experience advising companies in various industries. Her work focuses on helping clients achieve the most tax-efficient structuring as possible. Michael Dallo is the founder of Dallo Law Group, and he is an adjunct professor at USD School of Law and Business. His firm focuses on resolving high-stakes and complex tax disputes with the IRS and California taxing agencies. Dallo Law Group has worked hand-in-hand with RJS Law since the beginning. Rene Fimbres, unfortunately, was not able to attend today due to something that we all know. It's called COVID. He tested positive 2 days ago. But he's a dear friend of mine, and he's my go-to whenever I have a technical question. Rene is a member of Ernst & Young's International Tax and Transaction Services practice. Rene proposed a foreign tax rate topic for our institute, and he provided us with the slides for this topic. Thank you, Rene. Thank you again to our panelists for joining us today and all of our attendees. Diana, let's get started.
Hello, everyone. Oh, that was really loud. I hope I didn't break your ears. Thank you so much for being here on a Friday, really nice day outside, and you're here learning about foreign tax credits. Good for you. So I wanted to preamble this by saying that if there's something you don't understand or something that you feel super confused about, don't worry. At my firm, there's like people who are studying the foreign tax credit new regulations day and night. They've been doing it for about 6 to 7 months, and they still have questions. There's even the IRS has questions, so I'll tell you more about that later. But yes, foreign tax credits are a very important aspect of the international tax sphere because they generally allow a dollar for dollar credit for taxes paid abroad by US taxpayers. So this is super important because it kind of mitigates double taxation and allows for a more globalized economy where US taxpayers feel comfortable doing business in other countries because they have that backdrop where they can get a dollar for dollar credit for the taxes that they pay abroad. So in January 4th, 2022, the new federal or foreign tax credit regulations were published in the Federal Register. And there are a lot of different items that come as part of the FTC new regulations package, but I'm going to be focusing more on the creditability of foreign tax credits, which is one of the main hot topics currently, because a lot of my clients are seeing that maybe some of their taxes that they normally would be able to take as credits won't be creditable, or there are some added nuances. So generally, under previous regulations, a foreign levy was able to be taken as a foreign tax credit in the US if it was a tax, number one, and if it had the predominant character of an income tax. And to be able to satisfy the predominant character of an income tax, I don't even remember where I'm in my slide. All of these are still applicable. To fulfill the predominant character of an income tax, previously there were 3 tests that needed to be met. The realization test, which basically meant that the tax was imposed on the occurrence of a taxable event. The gross receipt test, which is based on the gross receipts of the actual taxpayer and not someone else. And then the net income test, which meant that the tax was imposed after certain deductions. So in order to meet these tests before, empirical analysis could be used, which required both the IRS and the taxpayers to gather statistical evidence of whether certain taxes in certain countries could reach the net gain requirements and meet these tests. However, now in the final 2021 regulations, these regulations don't allow a taxpayer to look at empirical data anymore, but rather they require the taxpayer to look at the actual letter of the law, the foreign tax law, to see if this tax would be creditable in the United States or not. So the 2 first tests of the net gains test, or the 2 first elements of the net gains test remain the same, the realization and the gross receipts. But there are 2 new elements to this test, the cost recovery and the attribution. So I think this one is, okay. So the first test, the realization, remains the same, like I mentioned. The gross receipts test or element remained the same as well, but there used to be an option for calculating an alternative gross receipts amount, which is no longer an option in the new Treasury regulations. And then finally, or the third element is the cost recovery test, which is the third column, if you want to kind of read along. It won't be the same because I'm saying different things in the slides, but in essence, it's the same. So the cost recovery test basically indicates that the taxpayer must be able to recover all significant costs and expenses attributable to the foreign gross receipts. So certain expenses are indicated by the new regulations as being very important, that if these are not deducted from the gross receipts, then the actual tax would be imposed on an amount that would be different than what an amount of tax would be imposed in the US. So basically some of these deductions that the IRS really wants to see being reducing the gross receipts amount of foreign receipts would be like capital expenditures, interests, rents, royalties, payments for services, and research and development expenses. So in essence, what the IRS is trying to do is they're trying to basically say, okay, we're going to be allowing a foreign tax credit, and we're going to be allowing it on an amount, like a net income amount that would be similar to what a taxpayer would pay if that amount was being taxed in the US. So if any of these amounts are not able to be deducted based on foreign law, then the IRS is like, no, this entire foreign tax is not going to be creditable. So this is an issue for some countries that we'll be discussing later, such as Brazil and some items in like the Mexican taxes. So that kind of creates a little bit of a hesitancy for everyone, and even for the IRS. I think, well, I'll tell you later what I've heard through the grapevine. Very, very interesting. So also, the new Treasury regulations allow an alternative cost allowance. So if any of these costs aren't able to be deducted from the gross receipts, and there's an alternative cost that's deducted that would be similar or more than such deduction, then that would be allowed, and that would kind of meet the test, and the foreign tax would be creditable in the US. So on to the next slide, please. So this attribution requirement is one of the new elements of the net income test. And this rule provides limits on the scope of gross receipts and costs that are attributable to a taxpayer's activities. So in essence, some of the activities, so like for example, the first one, you only have to meet one of these elements in order for the attribution element to be met. So as a reminder, the 4 elements of the new requirements are realization, gross receipts, cost recovery, and attribution. So you have to meet all those 4 elements for a credit to be, or for a foreign tax to be creditable. However, in the attribution element, you only have to meet one of these in order for the attribution element to be met. So in the activities section, this is basically for like sales of property, but not real property. And this activities tax would be taxed on gross receipts that are attributable to activities in the country. So if a country is taxing activities, for example, like sale of property or, I don't remember, is this one the services? No, so sale of property for sales made to another country, then that would not allow the activities element of the attribution to be met. But for example, if the country is taxing receipts for the sale of inventory within its country, then that would allow this element to be met. Then the second one is sourcing. So for example, services. If income from services needs to be sourced based on where the services are performed. So some countries source the income in, like for example, if certain person is providing services in another country and they are sourcing this income on where the contract is made, then that wouldn't be applicable for this element. It has to, the sourcing of the services or royalty payments must be made where the services were performed. The third element is the property situs, and this tax would be based on the gains from the disposition of real property and also on the disposition of stock that's considered like a real property investment holding company. So this is in essence very similar to our FIRPTA rules, where if you sell a property that's in another country, then that country will be able to kind of like tax it one last time. So if none of these are met, the activities, sourcing, property, situs rules, then the entire tax for that particular item won't be creditable in the US. And then finally, we have the arm's length element, which means that the calculation of taxes is an attribution of what each country could tax would be based on an attribution concept. So this is where it gets a little bit sticky with Brazil, for example. In Brazil, they don't really have like an attribution concept. They have something called a formulary apportionment approach, which is not an arm's length approach based on transfer pricing rules. It's based on like a formula that Brazil has kind of, I don't want to say made up, but formulated in order to determine what income they could tax. So because this is not an attribution formula or anything that would be based on transfer pricing rules, then this type of income tax would not be creditable in the U.S. And then some of the other issues that are currently being analyzed for Brazil is that Brazil taxes royalties based on the residence of the payor rather than of the payee. And then they tax services based on the residence of the customer rather than based on where the services were performed. So these items are kind of not compatible with the U.S. tax rules, in which they kind of want to have something very similar to what would be taxed in the U.S. in order to really allow taxes to be creditable. So we can go to the next slide. Yeah, so that's the income tax and the tests that would allow an income tax to be creditable in the U.S. And then there's something called in lieu of tax. So if certain items of income are not per se taxed like as an income or they don't have an income tax being imposed in another country, then this would be something called in lieu of tax, which is like a substitute for a tax. But there are some rules that should be met in order for, or rules or tests that should be met in order for these in lieu of taxes to be creditable in the U.S. And I'll go through the 4 tests initially really fast, and then the covered withholding taxes are in essence similar tests to the first 4 tests. So a substitution tax would be creditable in the U.S. if the 4 tests are met or if the tax is a covered withholding tax. So the first of the 4 tests, and I won't go through them in detail because these are very nuanced, and if you have a situation where you're kind of like analyzing these items and you get lost, I would talk to an international tax person just because these are very like nuanced, and like I mentioned before, even the IRS is kind of scratching their heads like, hey, what's going on? Like, is this really what they meant? So the first of the 4 tests is that the foreign country imposes net income on tax. So for this amount, or for this income that's being taxed, it's not being taxed with a net income tax. However, it has like a substitution income tax. So it's not like an income tax in that country, it's an in lieu, like a substitute tax, which goes hand in hand with the second element of the test, which means that, but for that substitution test, that amount of income would be taxed in that country with a normal general tax. And then the last one, let's see. So also that, I think this is like really nuanced. I'm not going to go through all of these tests, but just know that if there's a substitution test, either the 4 elements listed should be met, or a covered withholding tax element should be met in order for the tax to be creditable. And then we can go to the next slide. Actually, I'd like to touch on the next slide before this example. Okay. And having said everything that I've just said, a lot of attention is being given to income tax treaties. The U.S. has a lot of income tax treaties with many different countries. So a lot of attention is given to that because if a U.S. taxpayer pays like a foreign levy or a foreign tax amount that is an income tax under a treaty and elects the benefits of the treaty, then that tax is automatically considered to be a creditable foreign tax. And then you don't have to go through all of the elements. So if you have a client who has interactions or transactions with a foreign country and the foreign country has an income tax treaty with the U.S., then you would look at the foreign tax treaty first and see if your client is taking advantage of the double tax treaty and meeting the requirements of it, and then you would be able to kind of skip all of the tests and attribution and arm's length and all of that stuff. So, yeah, the model tax treaty normally contains a list of covered taxes, and one of them is obviously an income tax, and then they mention something like substantially similar taxes. So it really is a treaty by treaty analysis that you have to look at in order to determine whether the treaty applies and if your client is actually taking advantage of the treaty, and then finally, if those two are yes and yes, then you don't have to do the other tests that we discussed. I know that PwC is comfortable with certain treaties, and KPMG is comfortable with substantial authority that treaties apply to Section 960 credits, and substantial authority that income tax is creditable under the new regulations. EY and Deloitte have not taken any positions regarding any treaties. Like internally, we do have a lot of weekly updates on which treaties are favorable and which aren't. But currently, there are no official word on the street of which treaties are better or worse for these purposes. I do know that some of my colleagues have had discussions with the IRS and some of the writers of the legislation, and they have mentioned that there's going to be clarifying guidance in different forms, either through technical corrections, but of course technical corrections don't include any preambles, and they also they're not able to have any examples, so that wouldn't be too helpful because we already have the face of what the Treasury regulation says, so it would be helpful to have more examples. Or they're thinking of releasing GLAMs, the generic legal advice memorandums, which of course are not legally binding, but would kind of have some guidance as to what they're thinking. And then through the grapevine, we've heard that maybe there will be new proposed regulations by the end of this year. So we'll see, hopefully there will be something that could offer more guidance there. And I have a few other points. I'm going to skip the last slide because it just talks about peanut butter and jelly of everything else, but I don't want to overwhelm everyone. So let's see. Yeah, so like I mentioned earlier, the IRS is also struggling with some of the mechanics of the Treasury regulations. I know that they mentioned that these were out for comment, and I think a lot of people were focused on some of the other items that were included and not really like the tests because I don't know why not. But yeah, now we have these Treasury regulations. The one thing that's certain is that that the IRS is not going to be delaying the effective date. So yeah, all of these are effective. Most of these are effective for the tax years ending after December 28th, 2021, with the exception of a few items because either doubt or previous conflicting decisions are pending. And let's see. Yeah, that is all that I have for now. Thank you so much.
Thank you,
Hopefully it
Diana.
wasn't too
So you think that,
crazy.
You think that it would be fair to say that as a quick takeaway, the foreign tax credit was used to accredit to whatever taxes you were owning in the US and whatever taxes you were paying overseas, you could accredit that against the US taxes. Now, with the new regulations, it's going to be more complicated to use the foreign tax credit. So we're going to have to double see if within the tax treaty first and then the new regulations, if we can take the foreign tax credit, right? And it's interesting what you said about Brazil, but I have also heard that it can be conflicted with Mexico now. I mean, my practice really relates to Mexico, and I know that we have some Mexican accountants here, and it was very common, very useful to take the FTC all the time, but now we're going to have to double check if it will apply or not.
Yeah, definitely. And In terms of that, with the different countries, it's kind of like a new thing for everyone, even in the quarter 1, quarter 2 provision. A lot of my clients are like, oh, well, we normally used to take like the Netherlands and Brazil and Mexico credit for granted, and now there's all these rules that need to be checked in order to determine whether those will be creditable or not. And I have a little table here in my notes of some of the countries that might be problematic, which is Brazil because of the resident corporate income tax, non-resident withholding tax on royalties, and such. China has withholding tax on capital gains, which would not be credible. France, Germany, India, Korea, Singapore, Mexico because of the inflation adjustments and stuff like that. And I know that there are a lot of countries that impose a tax for the indirect transfer of shares. Like if there, for example, if the US has a sub that's, let's say, Mexican, and then the Mexican sub has a Malaysian sub under it, and the US sells the Mexican entity, Malaysia would impose an indirect tax on a tax on the indirect sale of its shares. So that definitely will not be creditable in the US as well.
Yeah, just to add to that, I also the Netherlands and Hong Kong
Yeah.
have like some issues there. Okay, we're gonna continue to our next topic. Michael, you wanna take the mic?
Thank you. Yeah, we're switching gears to a topic that gives all tax attorneys heartburn, and increasingly so given the new Ninth Circuit case. That's the attorney-client privilege in tax cases. So the Ninth Circuit, when they rendered the opinion, they acknowledged that the tax world, the regulatory schemes are getting more and more complicated. We need more specialized, clients need more specialized attorneys that offer more comprehensive tax services to give good, solid advice to their clients. And we all heard from Diana how complex the international tax world is becoming, hence the more need for comprehensive and really good tax attorneys. But what happens is, when you have comprehensive services, you have a spillover between tax advice bleeding into tax compliance. And oftentimes communications with clients may have more than one purpose. It may have a legal purpose, talking about sourcing and all the complex rules, and it may have compliance purpose, talking about math and how things go on a return. And the question is, does privilege apply to a communication that may have two purposes? And ironically, you would think, given the preamble to the case, that, well, of course, privilege is going to apply because, it's getting complex. But the Ninth Circuit did the opposite. They really put a wrench in the attorney-client privilege, especially in international tax cases, and that's why we're talking on the international tax panel. But it has far-reaching and broad considerations to really any tax practitioner that services bleed over either to tax prep or from tax prep. And that's why I'm here. I have that problem. I wear multiple hats all the time, like many of you do. I'm an attorney, duly licensed in the state of California to practice law and provide legal services. And I'm also a CPA, duly licensed to practice public accounting. My clients know that I wear both hats, and that's why they hire me, because they have complex tax problems that they want someone that really understands the tax returns, the inner workings, to explain and give comprehensive advice. So I have both hats, and whether I like it or not, I'm wearing them all the time. Even if I wasn't a CPA, I'd be wearing two hats. I practice tax controversy. Tax controversy is kind of, always has tax compliance elements to it, especially in the more complex cases where accounting is a mess, high stakes situations, chronic non-filers. We always have compliance elements intertwined with tax controversy. And really any firm that offers comprehensive services should be worried about the Ninth Circuit case because of the same reasons, that we really can't separate out, it's not easy to separate out the accounting components, especially the international tax arena, from the legal ones. And so if there's a wrench in privilege, what is that going to do? That's going to chill communications between our clients and possibly deter us representing the more comprehensive or high-stakes cases. And that's really the irony. And Patrick will talk more about the case and the implication it has on the international tax arena. I'm going to talk more about privilege generally and how tax prep and tax compliance creates that problem. Can you go to the footnote slide? Oh, yeah. So this is the infamous footnote 5 of the Ninth Circuit case, right? I teach tax and we have some famous footnotes, and I think this will be one of them in at least the privilege world. Let's go over this footnote. Footnote 5, the original one, it was later amended, but the original one is more important. It says, we are aware, for example, that normal tax advice, even coming from lawyers, is generally not privileged, and courts should be careful to not accidentally create an accountant's privilege where none is supposed to exist. Every tax attorney reading that footnote should be worried, because what do? We give tax advice to our clients about whether to take a deduction and all sorts of things. That's our job. And to have the Ninth Circuit think that what we do is not law related, even if it's in a footnote, is scary. And this sent shockwaves throughout the tax community, of course. And when I read it, that's when I got interested in being on this panel. I didn't even have to read the case. I just had to read the footnote to say we have a problem here in the Ninth Circuit. Doesn't matter what the outcome of the case is, we have a problem. I think the Ninth Circuit realized they made a boo-boo, and so they amended the footnote. They published an amended opinion with a changed footnote, saying, no, sorry, we didn't really mean that. What we meant is normal tax preparation is not privileged. Well, that's also problematic, as we'll see, because what does that mean? What is normal tax prep? Is the tax prep, international tax prep stuff normal? Maybe to international tax experts it is, because it may come easy to them, but of course it's more complex. So that just leaves a more case-by-case determination as to what might be privileged and what may be not. Just reading those two footnotes. To really understand how privilege applies in tax cases, we need to go over the full spectrum of privilege. Because to understand privilege, we need to think about the timeline of a tax case from beginning to end. On the one end of the spectrum, we have pre-transactional tax planning. Transaction has not yet occurred. Client comes to an attorney asking the tax advice about that proposed transaction to see if they're going to go through with it or not. Undoubtedly privileged. Every communication pertaining to that representation will be privileged. That's the outer edge of tax. On the complete opposite side, we have post-transactional tax litigation, that we're going to court to represent our client in a tax dispute after everything is settled, tax returns are filed, or after a transaction has been made. Undoubtedly, communications between attorneys and clients will be privileged. I mean, that's just pure lawyer work. But look at the middle, tax prep. We have accountants and we have lawyers here. We share this hemisphere, right? And so as services start bleeding towards tax prep, because there are many steps in between tax prep, tax planning and tax prep and tax litigation, that's where privilege starts to become more unclear and problematic in the tax controversy world, for example, and in the international tax world. And so we'll go over kind of what's the lay of the land in pure tax prep. Okay, so what I've done here is I've distilled what I think the holdings of various circuits come out in how attorney-client privilege applies in just tax preparation cases. So the question is tax preparation when done by an attorney a legal service? Well, at least one circuit says yes. If an attorney is doing tax prep, we believe that we're going to defer to the attorney that what he's doing is more legal related, because that's why you would hire an attorney to do tax prep, and presumptively communications between attorney and client would have a privilege. That's one end of the spectrum. The other end of the spectrum is no. Tax preparation is the job of an accountant. If an attorney is doing tax prep, he's not engaged in legal services, and therefore communications between attorney and client are not privileged at all. And then we have the in-between, Ninth Circuit being one of those before this case came out, more of a case-by-case basis, asking, well, is what you're doing more accounting related or is it more law related? Is it something that TurboTax can just punch out, or is it something that attorneys got to think and do research? Well, that's where the heartburn lies. That's what the law has always been in the Ninth Circuit in the Abrams case, kind of uncertainty as to where privilege would apply in the tax prep arena. So the last slide talked about tax preparation generally, when tax prep services are being rendered by a lawyer to a client. Well, now we're getting into the world of dual purpose, right? Kind of what the case is all about. And the seminal case on dual purpose, pretty much the only one we've really had to work off of, has been USD Frederick in the Seventh Circuit, Posner case. That was a harsh case for the attorney in that case. The facts were very simple, very similar to the facts of the In re grand jury case. We have a tax attorney who is preparing tax returns for his client, but also giving tax advice. No doubt with what he's doing, serving two purposes. And he had several communications with his client, part of which were legal related and part of which were more tax prep related. Well, the court says no. We think that when we have a dual purpose communication that involves tax prep, it's tainted. The entire communication is pertaining to tax prep, therefore privilege is not going to apply. A harsh case, but thankfully that was just a Seventh Circuit case. We could always distinguish from that case and just hope that what we do, if we're very careful about how we phrase things, would be privileged. So here comes in re grand jury. Remember the Fredericks case. Simple facts. Attorney providing dual, multi-services to a client, kind of very similar to what we have here. We have a law firm specializing in international tax issues, including advising clients on expatriation matters. Super complicated stuff, high-stakes stuff, lawyers' world things, right? Well, this lawyer says, you know what? It's very difficult to offer advice on expatriation and not also just help prepare the return, the forms dealing with expatriation. They kind of go hand in hand. So the law firm did both. The law firm prepared the forms and also gave advice. And we know we cannot separate, it's impossible to separate the compliance elements from the legal elements. And so in communications, you're going to have a blend, right? You're going to have an email saying, hey, can you remind me what your position was on this matter and also where it goes on a return? Okay, here's the answer. We do it because we think that's the right thing to do. We're offering comprehensive services. That's why they hire us. And so this law firm got a grand jury subpoena to produce all communications between the attorney and the client. And they asserted privilege. They says, no, I'm not going to hand over those emails to you, those documents. I'm a lawyer, I'm offering very complicated legal services to my client. The fact that my emails may have another purpose, maybe a compliance element or two, does not taint my communication. I'm still practicing law and offering legal services. But that did not go well in the district court. They actually held the law firm in contempt for not producing over the emails and communications, and held that there is no privilege in those communications. They rejected the because of test. The because of test would focus on the connection between the representation and the communications, and that I was hired to offer legal advice, therefore you should defer. Therefore, if communications arose out of that relationship and out of that service, then those should be protected, just as it would arise in the work product arena. District Court rejected that test, and instead went to the primary purpose test, which is now the law of the land, and what Patrick will talk more about, and how that impacts practitioners, especially international tax lawyers, dealing with this area.
So is that my cue?
That's your cue.
Oh, excellent. Hopefully everyone can hear me. We don't have a lot of time. And let me start by saying, can everybody hear me in the back? Fine, excellent. Let me start by saying, I don't think this is an international case. It's an international tax case, but I think it applies equally to any kind of tax matter. Any kind of tax matter. So, there we go. I think it applies beyond certainly international tax matters. It just happens to be this was an international tax case, the Ninth Circuit case. And I don't know if we can go to those slides that we have. How do we get there? I'll let somebody more sophisticated figure out how to do it. I put at the beginning of the slide, I think that's, this is from a case, no, the first one, there we go. These are not my words. These are from Charles Ruckelman and Akiva Masse, if I get the pronunciation correct. 2021, not a good year for privilege in tax cases. 2 appellate court rulings stand out in the privilege context. So the first one, of course, is this in re grand jury, the Ninth Circuit case that Mike's talking about. And that's a criminal case. Just to be super clear, these were criminal grand jury subpoenas that were issued. And that was here in California. And I know it's near and dear to the hearts of many of those of us who practice. I practice in this tax expatriation world, the 877, 877 Cap A area. There's a blog I keep that's called tax-expatriation.com. It gets in a lot of the technical analysis. That's a criminal case, though. I mean, obviously, serious stuff. And then there's the Taylor-Lohmeyer law firm case. Again, another law firm, and that was an IRS investigation. That was a John Doe summons case that the Fifth Circuit upheld the ruling by the district court, again, in favor of the government, requiring that the law firm turn over expansive records to the IRS. That was a civil case. That was a John Doe summons case. Now, where can any of these cases lead? Who knows? In the Taylor-Lohmeyer case in the Fifth Circuit, that was petitioned. There were a number of people who filed amicus briefs trying to get the Supreme Court to take that up. They rejected it at the end of last year. I don't know. As far as I know, the in re grand jury, there's been no decision. I know there's a couple of the partners of the...
Yeah, Patrick, they accepted cert.
Oh.
Already have 3 briefs have been filed by, looking at right now, Chambers, California Lawyer Association, and the Legal Foundation have all filed.
Excellent. So they have accepted cert. So that would have been some time ago, because I think those amicus briefs were filed a couple months ago, or very recently. Okay. So there's a lot of important developments, and so we're going to get an opinion. Now, the Supreme Court's going to tell us which rule should apply with respect to attorney-client privileges. But before and we don't have a lot of time, but in my view, I think there's a lot of sort of misunderstanding. I'm not sure if the word's misunderstanding, but I have a hard time getting my head around the idea of legal advice versus tax advice. Just to be clear, that's what the Supreme Court, the terminology they used in the decision in Ray Grand Jury. They said, even though they changed their footnote, they did change their footnote, but in the body of the opinion, they reference legal advice versus tax advice, not tax preparation, not tax return filing, but tax advice and legal advice. And they say in the opinion that tax advice is not privileged. And the reason that you say, well, what is tax advice? And they say that under the primary purpose test, courts look at whether the primary purpose of the communication is to give or receive legal advice with respect to the law, as opposed to business or tax advice. So where does the tax law come from? It comes from Title 26. That's our Internal Revenue Code. Well, in my mind, having an accounting background, I could never understand the distinction between saying, I look at the law, the federal statutory regime under Title 26, and say when you're advising on that law under Title 26, that would not somehow be legal advice. It just happens to be, it's the law of taxation. Federal taxation, income, state and gift, and excise taxes, but that is the law of taxation. Like if you go to Title 8, that's the federal statute of immigration. Now that's a body of law. If you're advising on that specific statutory regime, how is that, if you're a lawyer, how is that not legal advice? So in my mind, I can't even, really, it's not clear to me before you start getting into the primary purpose and because of test and a primary purpose or the primary purpose test. I think you have to just ask yourself, well, wait a minute, how and why is there particular, when is it legal advice, even though the legal advice given is specific to Title 26 tax advice, the rules under this body of law. So that seems like an artificial distinction in my mind. I don't know to what extent that will be addressed, but that is in the body of the Ninth Circuit. There are other cases, and like the Eighth Circuit has said, tax advice, using that terminology, is protected under the attorney-client privilege. Since we don't have loads of time, I would like to think now, practically speaking, what does this mean for us when you're communicating with your clients, with return preparers? In this case, by the way, the best way to learn more about the In Re Grand Jury case is to read Evans' writ to the Supreme Court, because you learn more about the case. You say, oh my goodness, now I see what this case is more about, because reading just the Ninth Circuit decision, it's hard to glean and learn about, for example, the expatriation tax advice that was being given by the firm, the law firm. And the law firm apparently was involved in, as I can best tell, the preparation of some return and form information, like Form 8854, which is sort of a detailed disclosure of all the assets and income. So again, tax preparation, tax advice, legal advice. I think it's based on like the Frederickson's case. If you're going to put the information on a tax return, it's going to be made effectively available to the government. I've always thought, well, of course that can't be privileged. That's I know there's some case law that talks about that, but that's sort of one view, or at least my thinking. It's on the return, and what got into the return, that's going to be hard to argue that's privilege, on the attorney-client privilege. That's one practical point. The other practical point, I tend to think we should assume most communications the government will argue they're simply not privileged if they are related to tax return or tax compliance in one form or another, even though if it's lawyers giving the specific advice. I say that because maybe I'm just I'm a skeptic on how, or practically speaking, how you need to best protect yourself, especially, God forbid, you end up getting a grand jury subpoena on a criminal investigation and ultimately are held in contempt. Not a comfortable place to be, I'm certain of it. So that practical advice, what do you do? How do you communicate? I would also suggest maybe you don't want to be involved directly in the return compliance, reporting, whatever return it is, 8854, 3520, 5471, all the information, international returns, let alone the corporate or individual return, actually, and certainly signing the return. But still, I'm not certain to what extent when you've got a third-party CPA return preparer, you're going to be able to protect a lot of those communications. So I think, practically speaking, you have to be thoughtful about how and to what extent this would ultimately be available to the government if they pushed it through, say, a summons or through a subpoena in a criminal case, like a grand jury subpoena. Those are the main thoughts without getting deep into the details of a primary purpose, the primary purpose. That's what the Ninth Circuit has said. Currently, the Supreme Court is going to tell us if they're right or not, or if it should be the Seventh Circuit or the D.C. Circuit's view of the attorney-client privilege in this context.
Hey, Pat, Mike Friedman. Can you contrast this with the 7525 confidentiality privilege?
For return preparers.
Yeah, so if we're in the process of providing tax advice,
Right.
planning a transaction, and then we're also preparing returns for that same client. Contrast that with what?
Right. Well, that statutory privilege that's been around now. I was here with somebody in the room. We were reminiscing when we were young tax lawyers, and that was so. Everything that's been passed in our career seems not long ago. I know that statute has been a number of years ago when it was passed. Again, I think most return preparers, especially if they're not lawyers, I don't know who really relies upon and feels that they can rely upon that privilege to argue that whatever information they got with their client would not be required to be turned over. Again, that's just maybe because I'm so conservative about what the realistic possibility is if the IRS is demanding that information be provided. I think practically speaking, most accounting firms also take a general view that, hey, we're not going to try to rely on that statutory privilege with respect to return preparation. But I'm really curious about others, because it's a good question, especially if somebody's trying to rely on the privilege.
We still have time, Patrick. So what would you think about the cover letter?
The
I think
Covell
that
letter, yeah.
we use it a lot, like all attorneys. And
Sure. I think that's a good question. And I managed to get only to the first slide. But I think, here we go. This is obviously I discuss about the tax practitioner privilege, 7525. It applies in civil administrative proceedings. That's why, by its definition, it's very limited. And by the way, I think from a practical point of view, when you're an audit and you keep telling a revenue agent you're not going to provide information or records, that could be just a strategically very bad decision as to how they will respond to that. I tend to think, obviously, unless it's really a real eggshell risk kind of transaction, better to be cooperative, but maybe that's from my short time many years ago at the government. Obviously, it doesn't apply to criminal tax proceedings. It's so limited, the 7525 privilege. Here we go. I've always wanted to take a poll. Do we say Covell letter? How that's pronounced. These are generated and used all the time. What I would recommend you do, this is an old case, is read the opinion, because the opinion is so fact specific. The accountant was employed by the law firm, actually employed by the law firm, and ultimately was held in contempt. If I recall, I just read it again a few days ago in preparation. The judge was not happy with the accountant. When he was held in contempt in a criminal proceeding, again, this is a criminal proceeding, I think he said he had to spend a year in jail. I think that was his punishment. So it was definitely an incentive to turn over the information. The client was apparently convicted. This was during the criminal trial, and was convicted, and he was ultimately released straight away. But it was very fact specific. But if you read the actual opinion, I don't think it gives you a lot of comfort that you can rely on that Second Circuit decision. to have a privilege working with third parties, on the one hand. On the other hand, I think it's probably better than nothing. And there is specific language, I don't think I put it in the slide, that does use this analogy. Oh, here it is. I think this is I pulled this language out, and it says, this is where I think you have comfort to rely on a couple return preparer, expert of any type that the lawyer contracts with, although the opinion doesn't seem to make it have to be the attorney. It says, hence the presence of an accountant, whether hired by the lawyer or by the client, while the client is relating a complicated tax story to the lawyer, ought not to destroy the privilege any more than would that of the linguist in the second or third variations of the foreign language. They go through some different scenarios. So I use them. I think they're a good thing to use. I think we have, if I'm going to predict, 5 minutes left, if I can read the sign. I'm going to keep skipping through these. The John Doe summons, this case, these are country-specific cases that people should be aware of. The statute was amended on the summons rules. I think it's worth noting. That's if you get this is specific to John Doe summons. It's 7609. It was narrowed a bit. I've just included what those key points are. I think, do you have an observation about?
No, Ronnie, you have
I'm
a
sorry, is there
question?
a question?
Do you think lawyers should then start thinking about their fee agreements and hiring, when giving tax advice or legal advice, to just, expand the scope of what you're providing the clients, so that if it's ever questioned, you could use your engagement letter to say, this is what I was retained to do, therefore, we're going to stick to this. And you try to, add more language in your fee agreements that spell out the scope so that you're more protected later.
Well, that's an interesting thought. So for those who couldn't hear, is it better just not to expand the scope of the engagement with your client, between the attorney and the client, so that if it's expanded, that you could argue, aha, I was providing those specific quote-unquote legal services. I'm not sure that would necessarily help based on what the language of the Ninth Circuit is, because they keep talking about tax advice as not being part of the attorney-client privilege. So in some ways, that I think could be work against you, because they said, oh, well, you've just expanded the scope of your services beyond what is legal advice, even though, like I said, I don't understand the Title 26 distinction to begin with. So I'm not sure that gets you the comfort you would need. That's my quick take at it.
I agree with Patrick, especially because the court rejected the because of test. So it's not so much about the scope, it's more about the primary purpose focuses on the communication itself. And what is the primary purpose or a primary purpose of the communication? And if the or a primary purpose is not law, then it's not privileged.
But how do they know the communication? You're just saying, look, I provided what's within this agreement. You're assuming I'm going to stick to the privilege. I'm not providing any information. This is what I did for the client. And you're assuming there's tax advice in there, but this is what I did. There is no tax advice. Therefore, I'm not going to comply because I never provided the tax advice.
And that's the problem with the case. The courts now are making judgment calls, reading, communications.
Yeah, well, that's exactly, that's the Taylor-Lohmeyer case in the civil. John Doe Summons said, we're not going to provide that. The district court said, you must provide it. The Fifth Circuit said, you must. They confirmed. And obviously, they were held in contempt in the Ninth Circuit. It's another question.
If you have a tax law firm, but there's a CPA at the firm, and the CPA does the tax prep, and the attorney provides the advice, does that split the privilege concept if the tax attorney is not doing the tax prep, but the CPA is? Does the privilege lie with the firm or the person?
Well, it's a great question. That gets you back to the Covell decision. That's really the fact pattern there. They had accountants employed by the law firm. Ultimately, the Second Circuit said that was protected. I think it goes to what activities. You need to know what exact activities are being done by each. I mean, in the Covell case, it was a criminal investigation, and there were specific communications about numbers and amounts, but it wasn't on the return itself that was being used to argue the privilege was gone, is how I would take a look at it. So I know we're about out of time. There's a whole bunch more to talk about. I think from a practical point of view, those of us that started practicing 30 years ago in my case, I had a much an idea that this attorney-client privilege in the tax world was much more robust and much more protective of what communications we had with our clients. But I basically see the world almost the opposite now at this point.
Sorry, time's up, but we will have our panelists at the luncheon if you have any other questions. Thank you so much, Michael, Diana, and Patrick.
And by the way, I'm getting ready to do a program just on that issue. What is our responsibility in the U.S. as attorneys in new cases? Clients are not criminals. And corporate transparency.
Okay, let's get started here. Can you hear me?
Oh, that's on. Who's doing the slides for today? I believe so. Is that really?
Okay, thank you very much. This is the death and taxes, the inevitable. Let's lighten up the room here. So let's face it, the two certainties in life are we're all going to die and we're all going to pay taxes, unless you're Wesley Snipes or Nicolas Cage. So, my name is Brian Malloy. I'm moderating this panel today. I am of counsel at RJS Law. My practice includes trust and estates, business transactions, and real estate transactions. Prior to joining RJS Law, I was in-house counsel for a national home building company and also partner at an AmLaw 100 national law firm and co-chair of its wealth management, probate, and asset protection practice group. And I was also coach of my 6-year-old son's Little League team. Kind of a big deal. So I'd like to introduce my panel. To my right, I have Nancy Henderson. She's terrific at trusts, perfect at probate. She's a founding partner of Henderson, Caverly, Poom, and Triton LLP with offices in San Diego, Rancho Santa Fe, Pasadena, California. Her firm specializes in estates and trust matters, planning, administration, and litigation, and family law mediation. Ms. Henderson has served for 22 years as the managing partner of the firm and chair of the estate planning group. Ms. Henderson is a fellow of the American College of Trust and Estate Counsel and is also named in Best Lawyers in America, Taxation Law, and Estates and Trust Law. San Diego Super Lawyers, and was named a Woman of Influence in San Diego in 2021. She's a certified specialist in estate planning, probate, and trust law, and served for 3 years on the California State Bar Committee that writes and administers the legal specialist examination. She also served in the executive committee of the taxation section of the California State Bar. Ms. Henderson has spoken and written extensively on gift, estate, and generation skipping taxes and has presented outlines on numerous estate, taxation, and charitable planning subjects throughout various organizations around the country over her 30-plus year career. To her right, we have a wonderfully meticulous wealth manager who has an eye for investing. We have Trevor Callan, who co-founded Callan Capital with his brothers Tim and Ryan in January 2007. He's the Chief Investment Officer of Callan Capital Investment Committee, responsible for portfolio management and corporate executive services. Trevor began his career in financial advisory and wealth management in 1992 with Shearson Lehman Brothers. In 1994, he transferred to Merrill Lynch, where he spent the next 13 years. During his tenure, he was selected through a rigorous testing process to become the first advisor in San Diego to represent the Merrill Lynch Private Banking and Investment Group, an operation dedicated to serving clients with liquid assets in excess of $10 million. Trevor has a VS in finance from SDSU and earned a certificate investment manager analyst designation following coursework and examination at the Wharton School and certified private wealth advisor designation following coursework and examination at the University of Chicago Booth and School of Business. To his right, we have an amazing, Laura Stees, who has an amazing acumen of accounting and is tremendous at tax returns. She's the founding partner of SWC, Southern California's independently owned tax planning and financial strategy advisory firm for small business owners, real estate investors, and high net worth individuals. The driving force behind SWC's brand and operations, Laura advises the firm's clients on several fronts, including tax planning, estates and trusts, investment vehicles, legacy planning, and other net worth generating strategies. A Series 65 registered advisor, Laura graduated from San Francisco State University's nationally acclaimed Lamb Family College of Business and is a member of the American Institute of Certified Public Accountants. She has more than 3 decades of experience in public accounting, business management, consulting, and financial advisory services. And last but not least, we have Jordan Marks. He's been known to accurately assess the situation and your house. And so, yes, we're talking about Jordan Marks, the Jordan Marks. He's a San Diego County Assessor Taxpayer Advocate for the Office of Ernest J. Drunenberger Jr., San Diego County Assessor, Recorder, County Clerk. In his position, he assists taxpayers with navigating issues in the office and has resolved over 1,000 taxpayer cases since joining the office in 2017. Thanks to the work of Jordan, San Diego taxpayers have received a record high property tax savings in 2021, topping $250 million. As Chief Deputy Assessor, Jordan leads the office's county-wide award-winning educational outreach program on property tax exemptions and exclusions that provide taxpayers for homeowners, veterans, and nonprofit affordable housing and seniors. And with that, I will give it over to the panelists.
Hi, good morning. It's still morning for all of us. You know, when Brian sent out the request to all of us about speaking today, one of the things that we first started talking about was what did we all have in common? And we realized that between all of us, the sum of us is greater than the parts of us. And acknowledging that when we work together, all of us, when we work together, we achieve more. We get better results for our clients, and we land bigger cases, don't we? Now, the size of the case is never our goal, any of our goals. Our goal is to do what's best for our clients. But working together, we end up with better results and more creative results for our clients. So what we're going to cover today is we're going to start with a sample case study because we want to get your creative juices rolling. Then we're going to move into some recommendations and ideas in this current economic landscape and the challenges that all of us are having and the concerns that our clients are having. It's hard for me to say clients all of the time because the focus of our firm is on families and not on clients. So we tend to deal with families in our practice. And then we're going to end up with a discussion of Prop 19. And the reason for that is because a lot of us are getting questions about that right now from clients. So the ideas that we're going to present today, are any of these going to work for your clients, for your families? Maybe they will, maybe they won't. But that's not the point. The point is that all of these are about a conversation with our clients. They are conversation starters. We all know that there are a lot of strategies out there that people hear about in the news and they're not ideal for our clients, but it gets the client coming to us to have those conversations. And when we listen to those conversations, it's an indication of something that's going on with the client. So for example, if somebody comes to you and says, what do you know about ESOPs? Well, the ESOP is not the real issue that they're coming to you about. If they're looking at ESOPs, what they're looking at is exit planning, not an ESOP. The ESOP is just what starts the conversation. And so we're going to try to give you some conversation starters today, things that we're seeing in the news, things that we feel are solutions that could help some of your clients in this economic period that we're going through. And then also, by doing this as a team, sometimes as individuals, we don't hear what it is that the client or the family is bringing to the table because we haven't had exposure to some of the issues that they're presenting. But by having a team, someone else in your team is probably hearing the message that they're presenting. So one of the things that we want to encourage all of you to do today is we want you to look around the room. We want you to look around at who is here in the room with you. There are some absolutely amazing, incredible specialists in this room. And this is a great opportunity for you to network with all of those. And we also want you to encourage you to call on Brian, call on Ronnie, call on RJS Law. So I'm doing the RJS Law plug here. Call on them to introduce you to others in the room and even those that are here virtually, because there's a lot of specialists in our network that can help you with your team. So for introductions of each of us, Brian gave us just incredible introductions that are, all of us have those as our little puff pieces, don't we? But those don't always tell the essence of who we are. So each of us will give you just a little brief about who we are. So I'm Laura Stees, I'm a CPA. I've been a CPA my entire life. I come from a family of CPAs. I have a huge family. I have 100 first cousins. 30 of us are accountants. I have over 700 cousins, and the estimate is about 250 of those 700 are accountants. Yeah, we're a lot of fun. We actually are a lot of fun because we are both, just because we're fun. So I have a boutique CPA firm with a specialty in tax planning. I serve small to medium enterprise companies. And what we do, what most accounting firms do, is they give their clients tax projections and tell them what they owe. We go a step beyond that and we focus on tax planning. We use 130 different strategies that are focusing on tax efficiency. We focus on educating our clients about what they need to do to be in compliance. We all know that the IRS is really good about communicating the fact that you must record and report 100% of your income, right? But the focus is not on educating taxpayers about all the deductions they're entitled to, and the IRS doesn't require them to take all the deductions they're entitled to, do they? So it's our job to educate them about all of the different deductions and strategies they're entitled to use and what they have to do to be in compliance with all of those strategies. We all know that clients still walk in the door today saying, oh yeah, I get an auto allowance. And we know that auto allowances do not meet the code. That is not the proper compliance methodology for auto expenses. But people still think that those are the right techniques. So the earlier panel was talking about a lot of their cases start with cleanup, and that's what all of us focus on as well, the cleanup. So not only do we focus on education, but we have a very unique process in our firm to support them in their compliance. So that's a little off the side about me.
Thank you, Laura. Hello, everybody. My name is Trevor Callan. I feel really special here today, being, I guess, the only wealth manager here in the room, which is fantastic. Thanks for having me. As Brian said, I am one of the 3 managing partners at Callan Capital, which is an independent wealth management and financial planning firm founded by 3 brothers, if you can believe that. We've been in the business together for about 20 years together. We have crazy boardroom fights, but it always works out. We have 3. If it was 4, it wouldn't work, but it's a family business at its core. We started the business in 2007, which was a fantastic year to start a financial planning firm right before 2008, but we managed to grow the business over the years. So we have 2 offices today. We have an office in La Jolla and an office in Austin, Texas. We've got 14 very highly accredited people on staff, 4 of which run our financial planning group. And this is relevant to our discussion today. Our head of financial planning, Jessica, is a Texas licensed attorney, trust and estate planning attorney. And then we also have Chris, who's not a CPA, but has many, many years of preparing and reviewing returns. Today we serve about 165 families who have entrusted about $1.5 billion of their liquid capital under their advisement. And in addition to that, they have private equity interest and business interest in real estate. So if you kind of do the math on our typical client, they typically have on average about $10 million in liquidity, and then that translates over to net worth between, say, $15 and $100 million. That's kind of the world we live in. Our staff is really dedicated their careers to understanding the unique nuances that are so specific to our niche. And our niche is fairly narrow. Most of our clients are entrepreneurs, usually first-generational entrepreneurs. that have built liquid capital by either cash flow generation or most often a liquidity event, a sale of a company, an IPO, merger, recapitalization, or insiders of publicly traded companies. That's kind of the narrow niche that we serve. The importance about me introducing my team, and it comes down to this idea of collaboration, is that my industry, we're running into a lot of companies, our competitors, that are bringing in-house legal and tax into the wealth management world. And we believe very strongly that's the wrong way to do it. Well, first of all, I know that I can't afford people like the people to my left and right. I mean, these people are, top notch, and we feel that if you're going to be doing business in the world of tax and legal, you really need to be working with partner level experienced folks, and that's imperative. The second reason is that we tend to want to be nimble as well. Not every client needs the exact same specialization. The story I'm going to tell today, there's a component I won't get into much, but the family has a real unique offshore planning opportunity. So we're going to need a specialist to come in to talk about offshore taxes and things of that nature. And the third, and I think is most relevant to this conversation today, is that we found over the last 30 years that if we compete with our outside advisors, with our own internal, we tend to alienate them, and they will do whatever they can to kind of earn a seat at the table, and that's not where we want to be. So that's a little about Callan Capital. I'll be up in a minute with my story, but thanks again for having me. Am I up on the story?
You are up on the story.
Okay, here we go. So again, I'd like to, paint a picture here today. I think this is an interesting story that has a lot of moving parts. This family was referred to me out of our Texas office. They're based out of Houston, phenomenal family, 3 generations of wealth. The patriarchs are in their late 60s. Their 2 sons, Harvard grads, very educated. One was late 30s, early 40s with the other. The early 40-year-old ran or is running their private equity-backed business. That was one of the reasons we were called into this case. And then those 2 boys are married with 5 kids amongst them together, so five grandkids. And so the patriarchs were very successful British petroleum executives who built a lot of wealth over the years, and interestingly enough, a lot of the wealth landed in an IRA. An IRA of between the two of about $10 million, and doing this for 30 years, it's hard to get an IRA of $30 million or $10 million, given the limitations. They did a successful job over the years doing that. But the 2 boys were really driving the discussion with our team, and they were looking up at Gen 1 and saying, we got a problem here. We've got not only a taxable estate, and by the way, before I go there, this is right when there was a lot of talk about Biden lowering the lifetime exclusions last year. So there's a lot of angst about moving some money around, reducing estate taxes and things of that nature in advance of that. So the goals of the family were to protect and preserve assets for Gen 2 and Gen 3. They also had, the patriarchs had a lot of worry about the impact this wealth would have on their grandkids. And that's a common theme that we see in our industry quite often. They also wanted to make sure that they took care of all their education. And then lastly, when we brought our planning team to do what they do, they ask our clients about what life looks like today, where you want to see yourself 3, 5, 10, 15 years from now and into the next generation. We ask them about dreaming about vacations and upsizing, downsizing homes, and we go through all that. We usually end up with charity. And we asked the family, are you charitably inclined? And they all paused on the phone. I remember this, and they said, we've never given to charity before. We all been talking about it, kind of, in passing, about giving back to our alma mater. They all went to Harvard. They wanted to give back to Harvard. So our team, went to work, and this is in our world. I'll paint the picture of what we do and how we fit at the seat at the table here today. My team goes to work for about 3 weeks, and essentially what they're building, and we call it a financial plan. But what is a financial plan? A financial plan is a very detailed cash flow projection. Basically mapping out every single dollar going in and out of their lives, very detailed. And it has everything from salaries with inflation going out, to the retirement date, mandatory distributions on IRAs, pension plans, calculating taxes on real estate over their entire lifetime, educating the kids. Every dollar's there. And my tax person, Chris, on our software is running a 1040 return every year and generating the tax calcs. We usually run that out to age 98 to be conservative. And what we're trying to do in every case is solve for 2 things. One is, what is this family's critical capital need? And critical capital in our world is, what does this family need diversified securely so that they're never going to run out of money? And that's going to be a changing number for every family we deal with, right? It's a function of age and expenses and all the dreaming that we just asked them to do. The second part of the plan is to really define what we call excess capital. And here's where we can add some value, because a lot of our families, they don't know when they come up into our doors, but they have money that I can quantify mathematically that they will never spend in their lifetime. That's the excess capital. It's either going to go to their kids, the government, or charity, period. So that really kind of poses some of the big opportunities we're going to talk about today. So what we did at that point, we run a base case. Here's what life looks like if nothing's done. But then what we do is we always bring in the outside partners that's what we're here to talk about today, collaborators. In this case, an outside their trust and estate planning attorney and their CPA. And we spent a few hours on a whiteboard just, batting around ideas. And we came up with some pretty interesting ways to solve for an enhanced financial plan for them. The first thing that we wanted to do with this excess capital, before I go to that, I want to talk just a little bit more about the financial plan, because what I talked about is this straight line projection. And the straight line means, we're getting a certain rate of return on the portfolio every single year. We have an inflation rate of, say, 3% then and maybe 9% now every single year. The world doesn't work that way. The reason why you do the straight line is because we want the family to really understand all the numbers that are going into a plan, but then we have to actually circle that through what we call a Monte Carlo simulation. And what a Monte Carlo simulation does is we run 1,000 trajectories, introducing real-life volatility of the financial markets. And what you end up having at the end is a better, more accurate plan to give a family exactly, a range of where they'll be at the end of their lives with some very sophisticated calculations. That's what we rely on when we're coming up with critical and excess capital. A lot of planners just use the straight line mechanism. It's the most generous. It tends to be too optimistic when you compare it to the Monte Carlo. So I just wanted to give you a little background on the industry there.
Trevor, can I make one comment about your family there? I just want to point out to everybody, in my little boutique firm, last week alone, I had donor advised fund conversations with 4 families. Families are extremely interested in this as a solution, and for the reason that they want to teach their children how to properly select charities to contribute to.
Great, thank you. So the team, we came up with a multiple pronged approach. It's an evolving story, but just to give you a sense of what we did. First of all, we just looked at the low-hanging fruit here, right? There's excess capital. We have 5 grandchildren. We're going to front load their 529s day one. That's $750,000 tax-free transfer. The second thing we did, which was largely due to their trusted estate planning attorney, who I was so impressed with, came up with a strategy in which we looked at that big IRA up there and we said, that's a nasty tax situation at some point. Let's pick on the IRA a bit. Let's take, in this case, $1 million out of the IRA and put it into a charitable lead annuity trust. And a charitable lead annuity trust is basically an irrevocable trust that's irrevocably designed, in this case, to give 7.5% per year of whatever's in that trust to their Charles Schwab donor advised fund, which is basically their private charity account at Charles Schwab. And for that irrevocable commitment, we're able to get a present value deduction on all of those future 15-year gifts today, which because of the CPA, we designed it perfectly to perfectly offset the $1 million distribution out of the IRA. And the great thing about the charitable lead annuity trust is that if we can generate a 7.5% return or higher, we'll have $1 million in it in 15 years or more that gets transferred to Gen 2 or 3 tax-free. So that was, go ahead, do you have a question? Okay. There was also a lot of other components. After the 529s, we're able to front load the 5 years of gifts. We designed the plan to show years 6 on out, maximum annual gifting. We also designed a plan that picked on the IRA as a way to do charitable qualified distributions later in life to the charity tax-free as well. So the net effect of all of this is that we essentially extrapolate. So we have the base case, do nothing, work with the team, we design, and then my planners go and re-extrapolate the plan, putting all these moving parts in it, because we want to quantify for a family What is the impact on your cash flow every single year? What is the impact on your tax return every single year? And what is your impact on your estate every single year? And we usually run a comparison at age 86, their actuarial lives. And in this case, I'm assuming that the provisions are still high. We were able to lower their estate taxes by $4 million. We increased the amount to their heirs by $13 million. And we funded education for 5 wonderful kids. And I think that's what we're all here about, right? We're here to, provide our clients with comfort and clarity so that they can pull the trigger. Without a plan, how would you possibly feel comfortable doing all that, right? And without showing the numbers, and that's kind of where we sit at the table. So thanks for your time.
Not just comfort and clarity, but also leadership, because that's what they need right now in these economic times, is they're looking for leadership from all of us.
Well, let's see, is this on? Again, thank you for having me. I won't tell you anything more about me. I was embarrassed by everything that was read in the beginning of this program. My name is Nancy Henderson. But I will say one thing. I've been a tax lawyer for 31 years. Now, most people know me as an estates and trusts attorney, which I've also been for nearly 31 years. That was a specialty I went into after examining different options as a young lawyer. But I'm a tax lawyer at heart. A lot of estate and trust lawyers don't view themselves as tax lawyers. In my case, I grew up in the tax section of the state bar long before there was the California Lawyers Association, and I view myself as a tax lawyer with all the other things that come along to make what I do as a tax professional more interesting for me personally, because it suits my personality. But the nature of my practice, just listen to what Trevor just described. The nature of my practice is, fortunately, after 31, 32 years, my clients tend to be the clients that I choose to work with, either because I really like them as people, some people I've been working with since I began practicing law, and some were just brought to me in the last week or two, right? And the newer ones tend to be the ones with the $100 million and up estates, and they have to be nice people also, because I'm too old to put up with people who aren't nice. And in fact, that's probably, I've been too old for that since I was about 35. So I have a delightful practice. But I want to say something. One is, this is a tax controversy institute, and the question is, what the heck am I doing here? I have filed one tax court petition in my entire career that I filed personally, and that was a play on somebody that an IRS examiner that I just could not get to act reasonably, and I just let the time clock run out. He's like, well, why didn't you go to appeals? I said, I'm just going to go straight to tax court. And we settled immediately when he heard I could do that. I had done that. But other than that, I've never been in tax court. I have the certificate on my wall that says I can go if I want, but I don't. My audits are pretty simple. They can be complicated issues, but they're examining gift tax returns and estate tax returns. And my examiners are all lawyers, right? So that puts you in a little bit of a different spot. I think probably the most I've done in terms of tax controversy work is probably on property tax appeals. And for a long time, I had a specialist in my firm that I sent that to, and now I let an associate do it because I'm getting old and grumpy. So in any case, in my practice, I have always been very, very clear on what I know and what I do, and I don't try to stray beyond where my skill set is. Again, the older I get, less I need to do that. I don't need to get any new clients to do things I don't already know how to do. And by the way, people pay me a whole lot more to do what I know how to do than to do the things I don't know how to do. So I would rather put together a team of people, all of whom are experts, who are similarly minded to myself in terms of how we go about working with clients, who are transparent in what they're doing, including how they're paid, and who educate the clients and are objective. And that's the team I pull together for my clients, and I make my engagement letters very clear about what I do and what I don't do. I don't give financial advice. I don't give business advice. I actually don't even give asset protection advice. Lots of lawyers out there can do that too. I give advice on estate and trust matters. I draft complicated trust instruments to accomplish tax and non-tax goals. and I provide advice on estate, gift, and generation skipping transfer tax, for the most part with occasional incidental income tax benefits. I have to bring in somebody for all those other things, and that's how I practice. So collaboration for me is it's just what I live and breathe, and I honestly don't care whether I'm the quarterback or they're the quarterback. The quarterback should be the person the client has the most relationship and trust in, and then we use that person to help the client to make the most decisions. And maybe over time that relationship flip-flops. They might develop trust with me or somebody else in the relationship. And then sometimes the people who bring you a client you actually have to think about, because they may not turn out to be the best advisor for the client, and of course that's touchy. But it's all collaboration. And why is this all related to controversy? Because every planning matter that I'm an estate, gift, generation, skipping, transfer tax lawyer with incidental income tax consequences of what we do. Every single matter has the possibility of an audit. And most of those matters do involve a filing of some kind of return. Not always. Some of the strategies we have don't require a return, just a documented position so they can justify that you didn't have to file the return. But, and so when I'm working on a matter, I was talking with LeVar after the program when I walked in, that everything is a controversy in the making, and the best thing I can do is to be thinking about that while we're planning. And all of the things that Patrick Martin and his group were talking about are relevant. I have conversations with clients who want to bring, oh, you said, Laura, that you represent families. Actually, I do not represent families. I do not represent a single family. I represent individual clients. Now, sometimes it's one client, sometimes it's a husband and wife. Sometimes, although I don't like to, it can be co-trustees. I prefer to represent one trustee and let the other trustee get their own lawyer, because I don't like conflicts either, if I can avoid them. I don't represent, in most cases, mom, dad, kids, but my families who are affected by what I do sometimes don't understand that. And so I'm often having conversations about privilege issues. And I have to think about that when I'm planning. But I do believe that everything that I have in my file will be discoverable, even without ever having read the In re grand jury case that Patrick was talking about and his colleagues. I just know, based on experience and what I've seen in other files, that you just can assume that somehow they're going to get everything that's in your file, and has nothing to do with you. It may have everything to do with your client and how they handle everything in their possession. So regardless, that's the nature of the beast. So what I do for a living is pre-controversy planning. Now, if I do a good job, there's no controversy, no audit. I also, when I deal with the IRS, I provide, when we file a return, if I prepared the return and file it, I provide everything, sort of everything. Everything that I think they should have in as much detail as possible. So when they pick up that file, I've filed estate tax returns that are in 3 banker's boxes. Because I want you to see now that we are prepared, and I want you to see that Laura was involved, and Trevor was involved, and my appraiser is the top of the line appraiser, probably an appraiser the IRS uses too. So collaboration for me is key. Now collaboration is going to be even more important for all of us now. We are in turbulent times. Now let's stop back and say, have we ever not been in turbulent times? High times are turbulent times, low times are turbulent times, and those in-between times are turbulent times. We're in turbulent times right now because the interest rate, wars are are upon us, right? So we've been living on free money for a decade, and now suddenly money is getting expensive. So we have rising interest rates. We just had a 9.1% inflation marker that was published yesterday. I work with a lot of people, and traditionally have people that are in, I wouldn't even say startup companies, but companies that are being funded by outside investors. And the lead article in the business section today in the Union Tribune is on the tightening of that market and just how the availability of money there is plummeted. So all the strategies that I've been talking about with those people, like get rich quick things that are, we're going to use this strategy or that to move the assets to the kids, we have to rethink what the next few years are going to look like. We don't know what the effect of all the global conflicts. I'm wondering when the sovereign debt issues are going to come up by all the countries, including the U.S., that had to fund the economic shutdown. And when is that going to come up? Because I kind of remember, Trevor, not too long ago, talking about how Greece not being able to pay its bills was affecting the global stock market, you know? So when is this going to come back? I don't know. And laws are constantly changing. Laws, not just the law that I know about, but laws, and we're going to talk about property tax laws, but laws, the privilege laws are changing. Everything is changing all the time because that's the nature of laws. And so it's a complicated world. And in my world, I started practicing in 1991. In 1995, somebody told me, a very well-regarded estate professional here in town who may now be retired or is about to retire. She told me I should not go into the practice I'm in 1995, she told me in 1994, because they were going to repeal the estate tax and I wouldn't have a job. So that has been almost like the start, you know, in 1994 of the turbulence in the law that I deal with all the time. Okay, so it's turbulent times. You know, I'm the one that's supposed to be running this thing, huh? So what are some strategies? Now, I'm not here to tell you what strategies we should be using for any particular fact pattern right now. I'm going to give you a couple examples of some strategies and why they might be interesting in this market to help people save the state and give taxes on transferring assets. I'm not going to educate you on these strategies. If you don't know anything about them, happy to have a conversation with you offline. I'm totally fine. But a grantor or retained annuity trust is a strategy for all times. Now, most people will say it's not a great strategy when interest rates go up. Well, keep in mind, interest rates are relative. I don't know, I bought my first house in 1984. I assumed a mortgage at 11.1%, and it was a bargain because prevailing interest rates on new mortgages were 13.1%, and that was just normal, right? So just live in the moment and stop playing comparisonitis. We are in a good moment here with interest rates still, and grants were principally for assets that have extraordinary changes in value over a short time horizon. And they're wonderful because they're heads you win, tails you break even. I don't know whether assets are going to go up in value. I can bring in the smartest financial advisor here and say, what's your best bet on an asset that's going to go up in value in the next 2 years? You could be totally wrong because we don't control this environment. So what strategy can I use where it doesn't matter? And grants are awesome because they are a heads you win, tails you break even strategy. You can put in an asset today worth $1 million, report a $50 gift because you're going to take back. It's essentially like selling the asset for a note of exactly the same amount, but it's called an annuity and I'm getting it back. And if the assets appreciate over the amount of the annuity that I have to pay to myself, which is interest rate sensitive, just like a note, the appreciation goes to my children tax-free or trust for their benefit or whoever else I wanted to get it. What happens if it doesn't? Because I will tell you, most of the time grants fail. What happens if it goes down and you get everything out? Nothing. You use $50 of estate tax exclusion. So it's an awesome strategy, but it also requires you to collaborate because it's asset sensitive. It's asset sensitive, and you also need to be thinking about if you have a catastrophic beginning or an awesome beginning, what's your exit strategy to either capture winnings or to get out and retransfer the assets, and that can be complicated, not impossible. Been doing it for 30 years, but it requires collaboration. Also requires maintenance, and part of collaboration, I don't like maintaining strategies. I can't charge $1,000 an hour to maintain a grant. But my CPA friends and my financial advisor friends can work with the associates in my office and make sure that everything is going the way it's supposed to go. Because that's another thing about collaboration. I would rather do what I do at $1,000 an hour, that is my hourly rate, because I only do certain things and I do them well, than to try to do everything at $500 an hour, because I'll have to work twice as many hours to make the same amount of money. Why do I want to do that? So collaboration is important for me financially. Another strategy right now, interest rates are going up, terrible time to make loans. Oh, I disagree. Interest rates are awesome right now as compared to where they will be when you're looking at them 2 years from now. So we should still be thinking about intrafamily loans. But intrafamily loans, you gotta be careful. You're all tax lawyers, you know, you can't just treat something as debt and say it's debt. It might be equity. It might be a gift. So you have to make sure that the borrower has the capacity to repay, that the parents have the reasonable, or grandparents have a reasonable expectation of repayment, and all of those other facts and circumstances are dealt with appropriately. And no, it's great actually, because you can renegotiate if interest rates drop. Plan in advance to have something you're going to negotiate to get that interest rate adjustment when the time comes, right? So in any case, it's a possible strategy. It requires collaboration, and it requires us to put our heads into the future and stop whining about we're not like as good as it was yesterday. Okay. Some other strategies that we have. You know, we always think about step up in basis when somebody dies, because community property gets a step up in basis. You can have a step down in basis. So I've had in different recessions where clients who have recently acquired assets that have lost value, I've had them segregated in from community to separate property, so that if one of them dies, they don't lose both halves of the basis. So very different from what you do on the opposite side when it's going up. Life insurance sometimes can cover some, you know, some temporary things. We could talk about life insurance. Trust, when you create it for kids, be really flexible, because again, you're living in the moment, forgets that you don't know anything about the future, and I'm a big advocate of, I don't know nothing about what your kids and grandkids are going to be dealing with in 10, 20, 30, 40, 50 years, and to make sure that we haven't boxed them into something terrible.
Don't worry, they end up in my office talking about it.
Right, exactly. And then, so there's also issues that I'm facing right now in administration, because unfortunately, now that I'm doing this 32 years, a lot of my clients are dying, and I seem to have a death every couple of weeks. Not my fault, it's just march of time. And these are some of the things that we're seeing in these turbulent times. We're seeing losses of value during post-mortem administration, and how does that affect things? Where, you know, we're having to deal with, or we will have to deal with, problematic deductions on things that haven't matured, like guarantees that could result in loss to the estate but aren't mature. Lots of other issues, raising liquidity for taxes. When do you do that in a volatile market? And a variety of other considerations that are complicated in these times, and again, often require collaboration. So with that, I would like to talk about something, or we would like to talk about something that is bugging all of our clients and is a problem in administration right now, which is you die and you no longer get to preserve the favorable basis of your California properties for your children. And since that's bad news, I'm going to let somebody else talk about that.
All right. My name is Jordan Marks. I'm your assessor taxpayer advocate here in the county of San Diego. And what's interesting is if you're dead, you're not usually at my office because it's already taken place. So hopefully you've hired Nancy to do it really well, so that way you don't find myself in your office. In our office, we are responsible for assessment services, and that includes transfer at change of ownership, which happens at death. So in 2020, voters in the state of California, I want you to get really excited about this. Okay, if you're over 55, I'm about to just blow your mind here. But if in the state of California, they voted for what's called Prop 19. And it did two things that we're going to concentrate on today. First, for the family, which we're going to come back to, and the most important part of our conversation, you used to be able to transfer $1 million of assessed value. Now, in the state of California, we have Prop 13. Prop 13 passed by the voters said we're going to limit and restrict property taxes to a 2% increase per year from your purchase price in a fair and open market transaction. So that locked-in lower rate over time hasn't kept up with the market. Last year we had a 29% increase in market value, but the assessed value only went up 2%. So you could keep that lower amount and transfer it to your kids, and you could do it for your primary residence, an unlimited amount, and $1 million of assessed value on other properties. Those are small businesses, rentals, secondary properties. Prop 19 eliminated that, and it limited it only to your primary residence that you live in, and your kids have to now move into the property and become their primary residence. So kids living out of state, kids living in different areas that don't want to move into the home don't get that benefit, and we'll reassess now when that property gets passed down. You have to live in the property,
and take ownership of it within a year as your primary residence. And if you ever move out or try to rent it, we reassess you. In exchange for that, anybody over 55 here? No, I'm not, but if you are, it's okay. We'll just quietly raise our hands. You're considered a senior by the state of California. Not my definition, state of California's definition. It's actually the realtors, you can go talk to them. But you're a senior, and now you get to take your tax base. So when Nancy said she bought her home in 1986, she might have paid $100,000 for that home. 75. And over time, in 30 years, it's gone up 2% per year. So now she's paying, maybe based on 150 or 1%, that's what we pay in California, $1,500 a year in taxes. That home may be worth over $1 million, and if she went to replace that home in the market, she might be paying $15,000 in taxes.
I'm gonna go look up the value and cry.
So people don't want to move. Now you can move 3 times your primary residence, and so it's changed the way that we look at our estate planning. I think also with the changing rental market and the rules and regulations coming down from government on what it's like to be a landlord today, families are rethinking, is this the real estate piece that we want to hold into? It's appreciated, but what do we want to do now that we have what's called a step up in basis? Upon the death of the parent in the transfer, they don't pay capital gains if they sold the property at that point. So Prop 19 changed it, and if you want to go to the next slide, there's a grandparent to grandchild option. I can talk to you about that later, but we'll just concentrate on this portion right here. So those are the old rules. Again, very favorable for the parent-to-child transfer. Very slimmed down, now favorable and more expanded benefits for the 55-plus crowd so they can move about freely in the state of California. I kept it pretty quick, didn't I? There we go. Okay, so here's some things to keep into consideration. And I'll tell you, we have a lot of people that were surprised that this passed. And so when we talk about collaboration and keeping in touch, I think Trevor mentioned that they have their Monte Carlo program and their way of looking at it. This change and big change in estate planning interrupts those timelines and how you forecast it based on when the original asset got in. So it's forcing a lot of people to go back. And what was really interesting, I want to highlight when we talked about the implementation of Prop 19, it happened during the pandemic. And when it happened during the pandemic, our government offices were shut down, so you couldn't walk in. So a lot of folks were trying to transfer properties under the old rules that were much more favorable to their kids and take it as part of their gift, as part of their estate. And they couldn't do so if they didn't have the real estate professional in place. A lot of people did it and made poor decisions because they didn't call their CPA like Laura. A lot of folks didn't talk to Trevor and say, hey, what's this going to do to the timeline and the portfolio of financial planning that we did together? Because they were faced with a decision passed by the voters in November and implemented in February the next year. Wasn't ratified as a passed initiative until December. So you really had 3 months, and if that, 2.5, to make a decision. And by the way, I get the family members afterwards, after somebody passes, they come into our office. A lot of folks, they find out if their attorney was really good. I haven't seen any of Nancy's cases in my office, so it's a good thing. But our office makes a decision. There's no appeal, there's an appeal, but I'm saying there's no process where you're getting audited. They don't audit your estate plan and your trust and your will to make sure it was written to exactly match. We find out afterwards, and usually you get a Brian Malloy call in my office going, well, we're trying to fix this now. And so that's what my job is, to help unwind it. So here's some things to keep into consideration. Under Prop 19, if you're using part of your property now for commercial purpose, like a 2-on-1, or you've got an ADU that you're renting out, that doesn't count as part of the primary residence. So let's say Laura's growing something on her property, tomatoes for the farmer's market, right? And she's taking those to sell, okay? Well, if it's a commercial purpose and it's actually a license and a business license, and we see that, we'll carve out that part of the property that she's using to grow the tomatoes and sell. Now, if at the time of sale she decides, I no longer want to sell those tomatoes at the market, I'm just going to give them out to free for charity, it wouldn't be a commercial purpose, and we can dial that back. Also, when you're divorced, My wife's a divorce attorney, keeps me really honest, really good guy. And so when I talk to my divorce attorney wife, she goes, well, it's interesting, not a lot of people think that they need to make sure that they have the right to use that lower assessed value. Only one person gets it. But before, you only got to use it one time. Now, you can actually transfer it under that senior 55 plus. You get 3 times, so the other person that doesn't take advantage of that benefit when they leave the divorce will get to use it on their next property.
Jordan, can I ask you a question about the previous issue with the commercial purpose?
Yes.
What
Were you
about-
growing something else? It's legal now, okay?
Yeah, it's legal. What about home offices?
So home offices are not considered a commercial purpose, or let's say you have a Rotary Exchange student spending the summer and you're getting compensated for that. We don't go in, and our office is the friendlier assessor office. And so, but you know, these are good questions. When you have a new initiative pass, you tend to iron out some of these ideas. Luckily, the initiative Prop 19 was based off of 2 prior propositions that were passed. So we knew some of the rules, but that was the other part, you know, when this initiative passed and you're making these quick decisions, a lot of folks weren't sure whether they had to transfer these properties before the instituted date in 2021, by February 16th. And so, again, having a resource, talking to professionals, I spent a lot of time where the government didn't know what was happening at that time, but we decided in our county to give some clear direction. But I hope that helps answer that.
Absolutely. What if they have set up separate facilities on the property and are running it as a home office type of scenario where it is a depreciable event?
We don't look at your IRS filing to make our determination. We look at, so if let's say you're using a home office for your ADU, we wouldn't consider that as a commercial purpose.
Good to know.
Commercial purpose is more of the sense that you're renting it out, you're a landlord on the property.
Mm-hmm.
Or if you have a 2-on-1, you can't possibly reside in both residences as your principal residence. So it's pretty clear in that aspect. So those are the major changes. Beforehand, you had this more expanded benefit for family transfer. Now you have a much more narrow gifting opportunity, which is changing the way that families are thinking about the properties that they want to keep. Especially, again, when you're seeing, in some cases like Point Loma Homes, we're seeing $30,000 increases on property taxes when the kids receive the property. They're like, oh, we don't, you know, we wanted mom and dad's $1,500 bill, and now we're getting the $35,000 to $50,000 annual bill. They're like, that's a different game. The other part is the senior transfer being strategic. We are seeing that some families, in advance of their family planning, are selling their primary residence while their parents are alive, taking it to another place that the family would rather be at, living there, and then passing that down, or intergenerational buying. With the housing market the way it is, while we don't have 11% interest rates, we do have unaffordable homes. And so we're seeing Encinitas families selling 2 properties and buying together. And when they do that using the senior transfer, they can then give their kids 99% of the ownership. They just have to be on title 1%. And in effectuating, transferring the lower tax base to their kids. So there's a lot of opportunities. And under the senior transfer, by the way, you don't have to live in the property after you take it as your primary residence. You can then rent it out. You can then do whatever you want with it and not keep it as your primary residence, and you won't get reassessed like you did under the parent-to-child, more restrictive. Did you have a question?
How long are those senior exclusions taking to process right now?
So that's a really good question. Prop 19 got implemented, and the same way that the practitioners were kind of caught off guard, I think some of the government entities at the county assessors that were implementing these senior transfers were kind of like, okay, well, what does this actually look like to implement? Some counties, like Los Angeles, have not processed a single application to date. And so in those counties, I just saw a state senator was protesting this. The families are waiting for a lower tax bill. In the meantime, they're having to pay the higher tax bill, thousands of dollars, and carry that until it gets processed and refunded. In San Diego County, we've processed all applications, what we consider timely, which is 6 to 9 months. And the reason why it takes 6 to 9 months is we have to actually go out and appraise each deal. We actually have to look at your sale and look at your purchase to make sure that it was a fair and open market transaction. And so if, let's say, Trevor and his brothers, I'm going to sell you my property for $100,000 that's worth $1 million. You don't pay tax based on the purchase price of $100,000. We'd take it up to the $1 million market value. There's no inside deals. Nobody gets an added benefit. So it takes time to actually go out and appraise the deals. But I would like to say that we're closer to the 6 months right now. And our office within each tax year has processed timely. So that's a good question. All right.
Okay, so we have some final couple of ideas that Nancy is
Can I ask?
chomping up a bit to
Yeah,
talk about.
actually, these aren't ideas. These are some questions while we have our government resource here. So the first is,
I get to not charge any dollars an hour, so this is free for, no, I'm just joking.
So this, I'm just going to throw out one of the things that was, that you didn't write Prop 19, so I'm not holding you to this. But, you know, there are a lot of estate planning strategies that are irrevocable and put in motion that involve the transfer of residences that now are being caught in the crosshairs, whereas when they were put together, it was kind of in reliance on the existence of these strategies. So an example is a qualified personal residence trust. You're probably familiar with that, where mom and dad transfer their interests in the property to trust, and they're in motion, and I have a few that are terminating this year because they were on a 10-year time horizon from 2012. So there are a lot of transactions that are maturing this year, and they're going to children only, and yet they'll be reassessed on a transfer that was made then, but because it's coming out of the trust now. That seems very harsh.
So I'm going to speak on behalf of San Diego County, and that's really important to know that you have 58 county assessors that are elected, and each office has a different approach, much like a sheriff or a district attorney, on how to implement and administer the law. So we all have the same rules, and we try to be consistent as possible, but there's these gray areas. Now, generally, we are all in agreement that if you had an irrevocable trust that transferred and was set in motion prior to the implementation of Prop 19, you can't take it back. It's not revocable. So therefore, it's already transferred. Now, when it comes to the QPRTs, some of them were written well so that they really were irrevocable. And quite honestly, Nancy, some of them are not written well. So it comes into this gray area. That's why I'm an attorney. We have some attorneys here. They'll tell you, well, it depends. It depends on how it was written. And so we'll look at it. But generally, if it was written and is a solid, irrevocable trust, you'll be under the old, more favorable Prop 58 rules. If it's not, and it is revocable, then we'll actually reassess you based on the date of transfer, which would be under the new Prop 19 rules if they're expiring today.
Oh, that's awesome. I'll have to get you soon a copy of the trust.
Yes. And we try to be accessible, and as an inside tip, Ronnie said, don't reassess anybody today in the audience. Make sure their taxes don't go up. But well, sorry for the folks that stood outside right now, okay? Well, I got their APNs. No, just joking. But what we do know is we try to make ourselves accessible and get there with you beforehand. We try to do the same idea of education. Have the taxpayers know enough to be dangerous so that way they can talk to you. A lot of the folks that we do have coming into our office, their homes are their sole asset. This is their life wealth. They can't afford the $1,000 an hour attorney. That's wonderful. And so we try to meet and make ourselves accessible to them so that way they can prepare themselves and not have their family reassessed and pass down that generational wealth. And so we're doing a lot of education on co-tenancy transfers. A co-tenancy transfer, as I told you, the parent to child, if you ever move out of the house after it's passed, if you ever rent it out, you get reassessed. On a co-tenancy, that means you're a joint tenant on title with the parent and you live with them the year before they pass, it gets transferred under the old rules, and that's an unlimited amount of assessed value on the primary residence. Plus, if you don't want to stay there, I had a family, the kid was going to medical school. They're going to get reassessed. If he moves out of state for that period to go to medical school, that's their concern. This would take that off the table. And then also make sure that we're keeping families together and living, thriving here in San Diego.
So unfortunately, we're getting the hook. But we have lots of interest to talk about a lot of different things. If you guys want to reach out to any of us, we're happy to talk to you further in more detail on anything. And thank you, Ronnie.
Yes, thank you very much,
Thanks, everybody.
That was very insightful. And now we have, it's lunchtime. So,
Yes.
okay, we have a plate-seated luncheon in the room to the right here, or your left.
I'm sure it's a video presentation, correct?
That was an awesome panel.
Why, thank you. It was fun.
I wanted to add a government.
Well, I got my money's worth on that answer. Got what?
Let's do a quick picture.
Oh, sure. Yeah.
How much time do we have?
Until 2:45. So we have 1 hour. So I want you guys to be able to finish what you want to say. So yeah, we have nice time to meet.
Yeah, I feel like I say that.
It's cool if
Jordan
they
and I have actually never met in person.
Yeah.
We've done this, I don't know, this is probably like our 4th time, and it's all been virtual.
Fun.
You drive down today?
Wasn't too bad, actually.
No, yeah.
Check.
Oh, that's really bad.
Yeah. Yeah, so
I'm at least
you know,
I'm gonna skip to.
I can see you from right.
Yeah, right.
Some place. That's far. Yes, sir. These slides that the meeting stuff is back.
So we'll just move that. Do you have a clicker?
I don't know.
I thought the clicker was right.
Yeah, where's the clicker? You guys see it anywhere?
It was here.
Yeah, I think it's up here.
I don't know which one you guys need first.
So Sam's gonna do a quick intro.
Whatever you want to have us get started, just let us know. You guys brothers or cousins? He's in LA too?
No, I guess.
Even if you so here, that's fine with me personally.
I know.
Here. We can bounce off of it if you want,
Just so.
Sam's gonna do an intro to the topic. If you could go with me, I'll introduce the three of you.
Trickling in, we should wait a few minutes. Go to the restroom.
So, put a hard stop at 2:45.
Yeah,
We start a few minutes.
All right, everybody. Hope you guys enjoyed your lunch and the speech by Commissioner Chuck Rettig. We're going to be beginning our panel on taking the cryptic out of crypto. This is an emerging area of tax law and regulation that whether you are an
EA, a CPA, a financial advisor, a tax attorney, or whatever else operating in this industry, it's vitally important for you to understand what's going on in this landscape. I thought I would just give you guys a couple of interesting facts. Thought I would get people hooked into this, but between James Lee and Commissioner Chuck Rettig, I feel like they put a highlight on this stuff, so I'll still go ahead with the interesting facts. At its peak, the market cap of cryptocurrency approached $3 trillion just recently. There are over 9,500 cryptocurrencies now. The first cryptocurrency transaction occurred in 2010, and that was to buy a couple of pizzas for 10,000 Bitcoins. Those 10,000 Bitcoins are now worth $200 million. And I just want a show of hands, just to get an idea of how many people here have seen a picture of a monkey wearing a t-shirt or smoking a cigar. Okay, I see a few of you out there. Those are NFTs, and they can sell anywhere from hundreds of dollars to millions of dollars. Although Jordan has updated me and told me that maybe that's not the case anymore, and that's why we're here. So the IRS is putting a big focus on cryptocurrencies and NFTs. As you heard James Lee talking about the IRS seizing billions in cryptocurrencies. It's becoming a focus at the IRS. Commissioner Chuck Rettig just also pointed out that they're ready to take it to us. Don't touch the dragon, as he said. And we've put together an esteemed panel of experts here, and I'm going to allow my co-moderator, Kava Imendaus, to introduce them to us, and also to introduce myself. I'm Sam Imendaus. I'm of counsel at RJS Law, and I've been handling civil and criminal tax controversy for over 10 years now. So go on ahead, Kava.
Hi everyone, Kava Imendaus. I'm a JD MBT CPA with RJS Law. I'd like to introduce you to our panel members. We have Jonathan Kalinsky at Hockman, Salkman, Tosher, and Perez. We have Jordan Bass, attorney CPA at Bass Law and Taxing Cryptocurrency. And we have Michael Friedman, CPA shareholder at Levin Sachs, focusing on taxation. Gentlemen, I'll let you have the floor.
I'll get started. This is an area that, to say there's uncertainty in this area is probably the biggest understatement that we'll say all day. It's complicated because there's a lot of technical terms here that a lot of us don't understand. There's a lot of innovation in what's been generally called decentralized finance that's happening everywhere. Things are getting tokenized that we wouldn't think about, like real estate. There's different types of virtual currencies all over the place. They're all different things. They all work in parallel. So we're going to talk about a lot of concepts, and there isn't a lot of answers. We've got some rulings out of the IRS in terms of some important notices, and I've answered some questions. But this is an area where the technology is moving so fast and the innovations occurring so quickly, the IRS is struggling to keep up. And we got a sense of that with the pointed way in which Chuck, at least a moment ago, was talking about why we put a question on page 1. Because they're struggling to realize just the volume of financial transactions occurring in this space. And us taxpayers are struggling to figure out how to comply with the law. And we professionals, I've been doing this over 30 years. I don't have cryptocurrency. I'm still trying to figure it out myself. But I'm a tax geek, like a lot of you guys. I just like eat this stuff up. And so, figuring out what's going on in the law here is fascinating. But there isn't a lot of answers. So we're going to try and get into a little bit of stuff here. Jordan knows a lot technically about this. It's not just because he's a younger guy, but he's a pretty savvy guy. Jonathan knows a lot about this too. So together we're going to try and lead you through some important concepts. So, the first thing that we're going to talk about here, till we get past all of our beautiful pictures, is, what is this about? Blockchain, cryptocurrency, this idea that what the blockchain is this a distributed ledger. It's a database that stores information about activity and transactions. It collects information in terms of blocks, and that's where the cryptocurrency comes in. It's a way of permanently keeping track of things. As a CPA, I'm an auditor also. In my past life, I did actual auditing.
But what that means is that there's a more permanent ledger here of what's going on. And it's hard to eliminate something when there's a permanent record of it. There's new information being added and compiled all the time. Cryptocurrency itself, it's just a digital asset that comes into play, and there's different types of cryptocurrencies. Before we move out of here, can you explain this a little bit better than I can, Jordan? I would appreciate that.
Yeah, of course. So it's important to think about it, honestly, the way that Commissioner Reddick was saying, sending people back to those communities and speaking that language. This is like a new language. There's a lot to digest when you're talking about crypto and cryptocurrency, digital assets. So understanding, having the foundation, blockchain, crypto, we're going to talk about mining, staking, proof of work, proof of stake, all of these things. When people come to you with issues, you'll want to know what they're talking about. So it is important to have this foundational background, which Michael was kind of alluding to. But when we're talking about cryptocurrencies, as he mentioned, there are so many different types of digital assets. With cryptocurrencies, we have stable coins, things that are pegged to the US dollar, to the euro. They're supposed to be pegged to the US dollar. We've had problems in the past where there's slippage on these pegged assets where people thought they had $50,000, $100,000, but that price slips to 70 cents, 50 cents, 2 cents. This happened recently on the dollar, and now they lose all their money, right? So what are the issues from a tax perspective with that? You need to understand what cryptocurrency is to even tackle those issues. We have utility tokens, which give people access to using a platform, using a protocol. Some people would argue they look like securities. Other people would argue they just give functionality to whatever the person's trying to do on that blockchain protocol, on that platform. There are so many different ways to describe these assets, and it's always evolving. So like we were just hearing with the criminal investigation unit looking at the crypto, you're looking at transactions that occurred in the past, but we can't predict the structures of things that are going to happen in the future. So these definitions they're going to change, right? But at the end of the day, what is a digital currency? What is a cryptocurrency? It allows for a means of transacting on a blockchain, on a native network, whether that's private or public. And it's really important to understand these terms to define what the tax issues are that can come from them. So as we were mentioning, we have mining, we have staking. These are ways where, effectively new cryptocurrency, new assets are brought into the market, but they have specific purposes for doing this, to facilitate network activity, to ensure that things that are supposed to be going on with mining, let's say with proof of work, are actually happening. We're proving that these transactions are occurring, and it takes a lot of computing power. Some would argue it takes a lot of energy, but at the end of the day, we're here for tax. So what does this mean from a tax perspective? When you successfully mine a block, these blockchains build on top of each other, block on block, and when you successfully mine and you generate a reward in that block, you're generating exactly that, a reward, and it's taxed as ordinary income when you receive it. That can be confusing to individuals and entities that have these organizations that are trying to successfully mine Bitcoin is usually what's being done, because they don't understand how we generate this asset, it's worth a certain value, and it could go down significantly from there, but we've already triggered that taxable event. That's pretty set in stone. We've had guidance from the IRS for a long time about how mining transactions are to be treated. But at the end of the day, what a tax professional or someone that's providing guidance to individuals or businesses in this space needs to understand is that they've accumulated an asset that gives them that net accession of wealth. They have income at the time that that block has been successfully mined, and they've generated their reward. It's slightly different, which I think Michael wants to talk about a little, of staking. It's slightly different to staking, but it has the same tax consequence effectively, where you're generating, whether you're lending your assets to a network to facilitate the activity, or you're staking in a platform to generate a yield, you're generating a reward, and in that case, income.
Yeah, so staking is something this is the first dive into a complete unknown in law. But there is something we can relate to here. The concept of staking is something technologically that came around because the concept of mining proof of work is proving to be so costly. I mean, we've heard the speculations about how much energy it takes to constantly run these calculations to keep this blockchain going. So this concept of a new version of staking came around. It's proof of stake. And so what does it really mean? Well, you're basically using this concept where you take some coin and you basically pledge it to a marketplace. And then they hold it and they use it to compare new coins to mint new coins. And that's kind of the proof of stake model. And so if you pledge enough of it, you can become a validator. And these validators are essentially getting the right to receive new minted coin. And so if we think about what that means in the tax law, it's an interesting concept, but that's essentially what's happening. And so you have this idea that you're like putting money, value of asset, on reserve somewhere, kind of like putting money in a CD. And then the marketplace is paying you some return for doing that because they're using your currency for something, much like a bank uses your money for something. So the IRS hasn't really had a chance to talk about this. And what does it all mean? But you're getting a reward that's paid back to you. And there's usually transaction fees. You know, as I said before, I haven't invested in this space, so I don't have the experience knowing what this means practically. But there's agreements that you're signing, and there's lockup periods, and there's interesting issues you've got to deal with. And the one question becomes, what is it that I'm getting? Well, you know, you're getting something that you're receiving as a result of providing them an asset. So, you know, like mining, it's an accession to wealth. So for us to expect that these rewards would not be ordinary taxable income is, you know, really doesn't make a lot of sense until we hear something more from the IRS. The question then becomes about timing and really what it is that's happening there. So, okay, so we're getting these rewards. It's very much like interest. So it's very much like ordinary income. So then we've got to go back to what else the law says, and we're just a very basic concept, the constructive receipt doctrine. And what does the lockup periods mean? What have you agreed to? What kind of fees are you going to have to pay to access the reward? Is that what that means? Or is the reward mine now? So the question becomes really, I think, not necessarily whether these rewards are more ordinary taxable income, but the timing of it all. And some people have been speculating on tax notes. If you've all read that, there's been some articles coming through where people are speculating about timing. Maybe they shouldn't be taxed on this until they sell them. I don't know how you feel about that, Jordan, but it doesn't seem much different than mining in some ways.
It doesn't. There's a case, the Jarrett's, for anyone that's familiar, they were suing for a refund because they had paid their tax liability associated with their staking rewards, and they were trying to say that that those rewards should not be taxed at the time that they received them, but rather on disposition. I don't know what I think should be the right solution there because the market moves so much, it's so dynamic, and if these rewards are locked up for 4 weeks, 8 weeks, 12, 16 weeks, that could have a significant impact on price. There could be 75% reduction in the value that was received week 1 versus what it is when it's freely transferable in week 16. Like you mentioned, constructive receipt doctrine, there's lockups, there are different services that allow for you to stake as a service where you're not running your own validator. Someone else is doing it for you. So how does is that different than if you're running your own validator? I don't know, but it seems to me that when you receive that staking reward, it's taxable unless proven otherwise, unless the IRS provides some sort of guidance, some sort of ruling that would stipulate that it's not. So I think people should move forward under the assumption that it is. Now, there are a ton of different ways that people can stake their assets, like Michael was saying, but it creates much more sophisticated and complicated transaction structures. Ethereum, if any of you could raise your hand if you've ever heard of Ethereum, so Ethereum's moving to from proof of work to proof of stake. So there's Ethereum. On some centralized exchanges, you can lock your assets up for ETH2. There are other staking as service providers that you can do that. You can get staked Ethereum that's freely transferable, it's liquid, you could actually sell it in the open market, you can use it as collateral to borrow against, but you're receiving rewards on the potential that Ethereum will actually successfully merge and you'll have access to these Ethereum 2.0 tokens. That creates a different tax situation. How is that taxed? We don't have the answers to that. We can only take existing principles and try to, utilize them, but staking is a huge area that is providing a lot of tax questions, and it's important to at least know what this is so that you could, again, provide solutions to clients or just to anyone that's asking and seeking advice. We could talk about staking for hours, but in order to get through at least as much as possible, we'll move forward to hard forks and airdrops, but I really don't want to focus so much on hard forks because that's not really a transaction structure that we see anymore. It's something that happened really in 2017 with Bitcoin and Bitcoin Cash. A hard fork, effectively, a bunch of the community wanted to expand the block size of Bitcoin. They voted on it, they forked, there was a hard fork, it was successful, it created Bitcoin Cash. A soft fork is something like when Bitcoin moved to segregated witness, and I think it was 2016, I could be incorrect on that, where everyone agreed, but the native token, the native chain kind of stayed the same. All the validators agreed, all the nodes, all the miners agreed, or at least a majority of them agreed, and they had to move to a new sort of Bitcoin, right, segregated witness. So I don't really want to focus on that, but really what's happening more and more in this space, it's airdrops. And it's airdrops some people receive just from being early to utilizing a platform or a protocol where you get in early, you're utilizing something, you're bridging some of your assets from one blockchain to another, and now it gives you maybe the right in the future to receive an airdrop when they actually send out some utility tokens from their chain. Or with the ENS airdrop, which is right here, it's like an Ethereum domain. I can have jordanbass.eth, or Jonathan could have jonathankalinsky.eth. We can set up our own sort of wallet that's tied to our public name. People that did that over a period of time, for years, many years, there was an airdrop, an ENS airdrop. And what they had to do with that was they actually had to go and claim those rewards. So the tax issue there is, when is that income to that individual? Is it income when they claim it? Is it income when they have the right to claim it? Different price oracles had the ENS token at like $175 to $250 per token when the first person claimed it. There was a little bit of liquidity on like a decentralized exchange, and someone sold it, and that was what the price was. So if every single person were to use that price, and we were to say, once you had the ability to claim it and there was a marketplace for it, that's your income, some people would have hundreds and hundreds and hundreds of thousands of dollars of income, but 10, 20, 30 minutes, an hour later, it would only have been worth like $25,000. So what do you actually do with that? I think you just want to be reasonable in your approach there, obviously, but it creates issues when you have these airdrops with tokens that you're receiving that have a value at X, but really there's no liquidity in the market. So do you discount that value? Maybe you do, but at the end of the day, these airdrops are happening a lot, and people are generating a lot of taxable income from them. Another really popular one, which Sam was talking about, we're talking about Bored Apes, right? Those monkeys with the cigars and the hats. They had an airdrop, they called an airdrop, associated with their project called ApeCoin. And so what a lot of people were doing was they weren't claiming their tokens. They're taking the position that this is not taxable because I haven't claimed it. I just have this NFT that has the right to claim it. And they're wrapping their right to claim that token and selling their ape for maybe $40 or $50 or $75,000 above market price of what it should be, because that second person who acquires the asset then has the right to claim that. Does that mean that they can shift that income and shift the characterization of the income? Probably not, but that's an approach that I've gotten approached with a lot of people, and they want to try to do that. We don't have answers on this, so it creates issues, but we see a lot more airdrops now than hard forks. So if you're learning the lingo and trying to speak that language, I would definitely advocate for learning about these airdrops as opposed to hard forks that probably won't happen too much in the future.
Can I comment on that?
Of course.
I'm commenting on this from almost an outsider, but as a guy that's been studying the tax law a long time. What we're starting to see is really two issues emerging here. It's the idea of the timing. It's not, we recognize that there's an accession of wealth happening here, but it becomes a question of timing and valuation. So I think that's what we're seeing over and over again, and we're seeing the IRS starting to comment on that. FAQ 23, they talked about timing of airdrops, And so I think that that's what we're struggling with here as professionals, is advising our clients about how best to deal with the question of timing as to when the income happens, and the valuation question, because it's such a dynamic market. What the hell is it worth? Is it really worth what that coin was worth? You know, right? I mean,
Yeah, it's hard to
that's really
value.
what it's coming down to, is a lot of valuation questions and timing under constructive receipt.
So lastly, I know we have a couple of other things we want to talk about, these wallets and some lending items that we want to talk with crypto. I do want Jonathan to really talk about the enforcement aspect of this, because as we just heard a few minutes ago, it's an area of importance, right? Definitely with the IRS. But before we get to that, just really quick, something that Commissioner Reddick was mentioning about the Criminal Investigation Division being able to track these, what people believe to be anonymous transactions. They're definitely not anonymous. I've seen this for the last 6 or 7 years that I've been doing it, finding assets in different wallets that people are holding that they don't identify are theirs, or maybe in a divorce proceeding, a spouse that hasn't told anyone about this wallet, and we find it doing on-chain analytics and tracing data on these blockchains, which store everything. It doesn't go away. But some of these wallets really allow for easy identification of the assets to the IRS. The ones that are on centralized exchanges that you go through the KYC process, the Know Your Customer process. It's tied to your name, your address, your social, everything. But there are wallets that are a little harder to associate with an individual. That doesn't necessarily mean it's hard to track the funds in the wallet. It's very easy. It's actually, in my opinion, one of the easiest things to do. But it's hard to identify whose wallet that is unless that wallet has interacted with that centralized exchange. If it hasn't, it's kind of just out there. We know the funds exist. If they want to get US dollars in their bank account, ultimately they'll have to take those funds into a centralized exchange, which would be tied to their identity. And then from there, we could easily trace the flow of the funds. But if someone's living in what these are, these online wallets we call sometimes unhosted wallets, for people here that have crypto or NFTs, like a MetaMask wallet, or on different blockchains, there are other types of wallets, like a Phantom wallet or whatever. Those wallets, unhosted, there's no identity tied to the wallet just to set up the wallet. Anyone can do it. So you can go back and forth, and if you're just living on this one wallet and you've never taken the funds to the centralized exchange, sure, it could be hard to identify whose wallet that is, but there are other methods and mechanisms to do that anyway. So people that think this is like anonymous cash, it's not. There are even privacy mixers that you can use that people can unwind the data from. There are firms which you could look into, like CipherTrace and Chainalysis, that do these sort of analytics that work with the government to help find funds that are used for illicit activity. So it's definitely not anonymous, but that's the only thing I wanted to kind of say about, the wallets. And then I know we should probably get Jonathan in here on the tax compliance side and the reporting side. So Jonathan, if you...
Yeah. Thank you, everyone. I'll just wait for the chime, unless that was for me.
That was all for you, John.
Excellent. Okay, so I'll go back a couple of slides here, I think. And you probably can't read it, but if you've looked at a tax return in 2020 or 2021, you know, as Commissioner Reddick mentioned, the question is up front. And from an enforcement perspective, we should all be used to this in the foreign account realm that we've been dealing with for the last close to 15 years. When there's a question on the tax return that requires a yes or a no, that yes or a no is going to be signed under penalty of perjury and can form the basis of, down the road, a criminal case. So if you have transacted in virtual currency and you check no, or you don't answer the question, I think you're going to be on the radar. Certainly answering no when the answer is yes, that's a false statement. But it is a yes-no question. It is not a leave the box blank if the answer is no. So as a tax preparer, you should make sure that that box is checked one way or the other, not left blank. The other thing I would point out with that is the definition, right? As we see more and more products and types of assets, some people think Bitcoin is what everything is, okay? Bitcoin is like Xerox, it was to copiers, okay? Or Kleenex is to tissues. But that's obviously not the answer. There's lots and lots of virtual currencies and digital assets. Is an NFT virtual currency, or is it just a digital asset? I don't think that question on the tax return is the time to be cute for you or your client. If your client is in this space at all, it's not going to be subtle. Check the box, yes. Okay, you're not signing up for an audit. But if you check the box no, and you're trying to play games later with, well, this asset was, I didn't think it was virtual currency, and you have like, you know, millions of dollars in it, you're asking for trouble. And again, not the time to do it. As Chuck mentioned, enforcement is picking up. Just on June 30th, the government, DOJ, announced charges for 6 more individuals with cryptocurrency-related fraud offenses. It wasn't long before that you saw 2 individuals charged in an NFT fraud scheme, what's being termed as a rug pull, basically. It's a type of like a Ponzi scheme in the NFT world, right? And you basically have people who have come up with this concept. They get investors, and the investors don't get what they had bargained for. The other thing you might notice is your clients are getting a little bit younger. And the criminal defendants in these cases oftentimes are a little bit younger. I would have liked to think that when my clients started getting to be my son's age, there would be time for me to retire. My son is now 8, but it may be only a few short years away before I start to get clients that are his age. Some of the people involved in these cases are, I think, 21. Not your typical white-collar criminal tax case. And so the people investing in these products and transacting in here, I think generally it's a stereotype, but you can set up that stereotype and it'll be true in many instances. And it may not be your typical client over a 30-year career. It's probably somebody, like I said, much younger, who doesn't have wealth in the traditional sense built up in lots of real estate or cash. Their assets may exist entirely in some type of digital asset. Ask yourself, you as a professional, are you going to accept digital assets to pay for your services? That's something that has come up all the time in my practice. These people don't have often accounts that they can just write you a check or wire you funds. They may want to say, well, I can get you some Bitcoin, or I can get you some this through Coinbase, and then you can turn it into cash instantly. Well, think of whether you want to do that. These are all questions that are coming up. Think of the ethical, yeah, you had a question.
With that box, would you go to IRS seminar and ask if you only buy, you check that box, yes or no?
If you could speak into the microphone that Remy's about to provide to you.
And I'll also note, that's the 2020 on the slide now. If I go to 2021, you'll see the subtle change in the question.
Okay, I think that answered my question. If you just buy, you don't have to check the box, yes. Thank you.
Well, okay, so receive, sell, exchange, or otherwise dispose, yeah. And I think the FAQ has definitional answers for that. So I would look on the FAQs and on the instructions to the 1040 when answering that question. But I think generally you're correct. But again, I don't. In the kind of cases that we're likely to see now on the enforcement realm, you're not going to see, hey, I heard about Bitcoin, I saw a Steph Curry commercial for FTX and decided to buy, one fraction of a coin and just hold it. Those are the people who aren't going to need your help. They're certainly not going to need my help in a fraud investigation or criminal investigation. It's the people who are doing the transactions that Michael and Jordan have talked about, whose lives are almost dedicated to these types of transactions and have millions and millions invested in these. Oftentimes, these are people who have never filed a tax return. They may be in their early 20s, they may be in their mid to late 30s, and have essentially never had a job the way, we may have viewed a job. And so they don't have W-2s, and there's never been that, hey, somebody is going to report X income to the government. And so I've seen lots of cases where people have filed maybe 1 or 2 tax returns sporadically over the years, or people who have never filed a tax return in their life. And so one of the questions, and I'll get to it in a couple of minutes, is how are you as the attorney or the accountant going to deal with that? What I was going to say is, think about the ethics for you as the practitioner. If you're an accountant and you're not really familiar with the terminology here and what's happening, are you really the best person who's going to put down on a tax return what your client's gain or loss is from these transactions? Think whether this is a client that you should be taking on, if it's a new client, if it's a pre-existing client. Maybe you need to consult with somebody strictly on the crypto aspect of it. It's really, if we're talking major dollars, this is not the time for guesswork, not the time to say I didn't understand the transaction, because the IRS is looking at this. My general philosophy is, when in doubt, disclose. You can put an 8275 on a tax return and explain the position that you are taking, and that is usually the right answer, as opposed to, yeah, I didn't really understand what was going on, so I just told my client, let's not report it, roll the dice and hope the government never finds out. Wrong answer in just about every circumstance. So you as the practitioner need to really be careful when you're practicing in this space. It might sound sexy and cutting edge, and you might think it's quite lucrative, but it does require, I think, a fair bit of knowledge to get into that field, so you can best serve your client. DOJ named a director of national cryptocurrency enforcement team a few months back. Again, as Chuck mentioned, this is very real, this is happening, this isn't theoretical government speak of, hey, we're coming after you. They are there, and as I mentioned, there are prosecutions that are being announced, and there will be more and more and more. As Michael mentioned, we don't have a lot of guidance. So as the practitioner, to try to keep your client on the right path, you have to do, I think, what you think is reasonable, using the tools that we have, which are some FAQs. But it's not much else. And the guidance is years behind the transactions that are occurring. As we were prepping for this, what we would have done 2 months ago probably has changed by what's happening now already. And as you've seen the price of most cryptocurrencies tank recently, instead of people worrying about gains, we're now saying, well, is this transaction a lost transaction? So be careful in understanding what you are going to do. In terms of getting somebody into compliance who has not been compliant, there are various types of voluntary disclosures. And I use the term voluntary disclosure there broadly speaking. One of the voluntary disclosures is the formal voluntary disclosure practice program. And that requires a 6-year disclosure. It is designed specifically for people who have criminal exposure. And with that, you will fill out a form, which has just been modified as of February, to include specific questions on virtual currency. And that form now reads, and the instructions to it, like a manual on virtual currency.
Jonathan, I think we have a question from Mr. Taylor.
Is there, I don't think this is the case, but I got to ask the question. Has there been any talk of the IRS treating crypto as having to be reported on 8300s?
Not that I have heard, no. I don't think that's in the definition of what would fall under an 8300. I think not. Not that I've heard. I don't think that I have seen anybody put those transactions on an 8300, and I don't think I will. Yeah, as of now. And until further notice, and I think that would be the reasonable position. Yeah. So on the voluntary disclosure, you know, understand the government has got a lot of information, and they're getting more and more. There have been John Doe summonses with Coinbase, Kraken, Circle. And if you're just in that space, there's a very good chance that you have a Coinbase account or have had a Coinbase account, whether you love it or not. A lot of my clients now gravitate away from that. And in part, that's why they're clients, right? Because they like the anonymity that may come with a MetaMask, for example, okay? But again, that mentality of I'm gonna outrun the government, or I just am gonna outrun some type of trust for whether it's big corporations or big governments, and they're trying to be as anonymous as they can. But it doesn't always work, and as we saw in the foreign account realm, the walls close in, and eventually some people have nowhere to go. And so when you're doing a voluntary disclosure on this, make sure that you answer the questions correctly and accurately. If your client thinks that that's the best approach, they can pre-clear. The government will then, you know, your name gets run through CI, and you'll receive a pre-clearance, and then you'll submit the second part of the form. Eventually, you'll do amended returns for 6 years, you'll pay the tax for 6 years, and you will pay 75% fraud penalty for 1 year on the highest year. But again, if your client's name was caught up in one of the John Doe summonses, there's a good chance they are not going to pre-clear. So it is, in one sense, a race to the government if you're doing a voluntary disclosure. That's one option. The Streamline, which was for foreign accounts, so I'll say this, in terms of a virtual account, an FBAR is generally not required, and so I don't know in most cases that Streamline is going to be the first stop for somebody in this area.
It has the PowerPoint up to where you...
Oh. I keep talking and don't think of the slides. There we go.
You're on a roll.
FBAR. And so I don't think Streamline in most cases is really the program here. Are you going to advise your client to do a quiet disclosure? Possibly, and have them just file returns and call it a day. If you don't think your client has criminal exposure, strictly speaking, the formal voluntary disclosure process isn't for them. And again, you need to advise your client what the best course of action is and what the options are, and oftentimes just have them choose. Yes, sir. Yeah, well, yeah, and it's not cash, right? It's go ahead.
Yeah, could you repeat the question, please?
Crypto is considered property, correct, not security? And if so, the wash sale rules wouldn't apply?
The proper answer is it depends, because there are such things as security tokens. There are companies trying to, like Michael mentioned, with NFTs, fractionalize real estate and sell off the ability to have equity in that property and earn a right to the revenue that's coming from the rentals. That's a little bit different. There are security tokens. There's a token under investigation currently. It's been like a long legal process about whether it's security. Most assets are deemed to be property. Therefore, there's no wash sale for now applicability on that. Now, you don't want to execute a transaction and then immediately purchase back, and maybe that would get shot down as not a valid, sale. But there is something that might change that. It's not something we've seen that would be passed or that was passed, but last year and leading into this year, there was a bill, the Build Back Better bill that was trying to get through Congress, and that kind of stopped, obviously, but in there was to add wash sale applicability to these digital assets. There's a lot of legislation associated with crypto digital assets in the infrastructure bill that kind of changed some of the reporting requirements, and there was a definition of what a digital asset is, and there was a big concern about what that was, and then subsequent to that, there was going to be something to bring wash sale rules specifically to digital assets, but no, as of now, there's no wash sale applicability. So you could, in theory, harvest your tax losses, and a lot of people do that at year end. Last year was really difficult to do because the market was so, high in terms of valuations, but now that can be done. Unfortunately, it's not going to help you for the prior year gains that you had, right? But if you really believe in a project or an asset and you want to hold on to it long term and you don't mind resetting your holding pattern, you can do that, right? You can liquidate the position, maybe buy it back lower even, harvest that loss, and you don't have to really worry about those wash sale rules for now. But I do think over time that will change.
Perfect, because we're getting some questions from some clients. If wash sale rules don't apply, can they just lock in the losses now and then just repurchase the crypto?
Yeah, it's a strategy that people have been using a lot, for sure, with the crypto space. Not so much in 2017, but in 2018, definitely people that bought at the top of 2017 or the top of the beginning of 2018, some of the prices came down much like what we see today, 90, 95, even like 99%. I don't know why people were still holding on to those positions, but they were, and they can trigger losses by selling and maybe buying back. There's a token in particular that I know I had a client that held on a 90% drawdown. They sold, they bought back, not right away, but maybe like a week later, 10 days later, it was lower. And that asset over 3 years went 400x from when they rebought it, right? So they still ended up making a large return. They held on to their assets all the way up through 2017, paid a very large tax liability in 2017, and they weren't really that liquid. Their portfolio almost was not even worth what their tax liability was, but they were able to stay in the space, stay invested, and keep their pulse to what's going on, and they had that crazy 400x return in 2 or 3 years, which you don't really see anywhere other than crypto, right? So the answer to your question, in short, is no, it's not applicable. In long, it will change, but people can definitely leverage those strategies and then re-enter a position that they really believe in, whether it's an NFT or a utility token, but not a security token.
Thank you.
Question, sir.
I'd like to ask you to clarify your answer to a question earlier from this lady here. I think she asked if you simply bought crypto but haven't sold, are you supposed to check yes or no? I thought I heard you say no, but looking at the words of the 2021 return, it looks like you should have to say yes if you received it, which sounds like buying, but I'm not clear on that. Can someone elaborate?
I don't have the FAQ definition here. I think what Jonathan was saying with that question is in 2020, for sure, there was a lot of uncertainty on that. I take the position that I don't really have any clients that only bought, but if I did, I would check the box anyway because I don't see what the issue in doing so is, to be honest. The receive definition, which I don't have in front of me and I should know, probably is alluding more so to receiving payment for services in crypto, which happens a lot. Especially for contractors in the space or like developers or blockchain engineers. A lot of them elect to get paid in a stable coin like we mentioned earlier or the native token of the project that they're working in. Maybe they want to receive payment like that. But there's really no, in my opinion, I haven't seen any issue, but again, all of my clients that I've dealt with this buy, sell, receive, I haven't seen any issue in checking that box if somebody were to just acquire or enter into a Bitcoin or Ethereum, or Jonathan's example is a little more complicated, an NFT position.
We're just going to ask that you hold the questions until the end, just because I want to make sure we get through the entire presentation. We're just getting a little tight on time.
One of the things, and I'm going to turn it back over to Michael and Jordan in a minute to talk about some of the crypto finance and lending. If your client's in an examination, you know, how to treat that examination. I would say generally there's no random examinations in this space. If your client is under examination, it is because the government knows that they have transacted in cryptocurrency. Over the last several years, there have been a series of letters, sort of a soft letter, and I think there were eventually 3 different types of letters that went out to lots of people who the government knew had transacted in virtual currency and may not be in compliance. And so if you have an audit of a client who has received the letter, there are no secrets as to why that person is under audit. And one of the difficulties here is how you're going to get the information. Again, this isn't somebody who did 1 or 2 transactions that you can say, oh yeah, you know, what was the price of Ethereum on such and such date. Oftentimes, there are lots and lots of transactions, either in quantity or in somebody going from one virtual currency to another, to another, to another. And so you have to trace that. They may have several wallets. They may have 2 wallets or 10 wallets or 20 wallets. They may not have access to some of the wallets that they used in the year at issue. And how are you going to get an IDR response to a revenue agent that's asking for this information? Think about that. Think about how you're going to work with others. In the estate planning panel, which I thought was excellent, collaboration and working as a team came up. In these types of cases, we work with others. Somebody is going to have data, and you may need to hire a data company to get a lot of this information, right? If you're the accountant, you want to say, okay, what's the bottom line? But you don't have the software. There's lots of different, you know, softwares out there, some good, some not so good. And because the space is evolving, the softwares are evolving. And so figure out what team you need to put together to best serve your client, to get the information, to compute the information, and to eventually get them to where they need to go. Again, I think one of the biggest things here is you really have to understand the area. There are no, you know, flying by the seat of your pants in this space, because you're really going to end up, I think, getting your client in a whole heap of trouble, and you may get yourself in a whole heap of trouble in this. And as everybody from the government has mentioned, cryptocurrency enforcement is here. It is not going anywhere. And so beware for that, for yourself professionally and for your client. And with that, I'll turn it back over to Michael and Jordan to talk about lending transactions.
Let's advance this up a little bit here. So we're running low on time, but there's some important things we should talk about here. There's 2 more big subjects we should talk about. Lending and NFTs. 2 areas where it's astounding how much we actually don't know the way the law works. But you have to understand, with lending, this is happening a lot as far as I understand. So just think about it this. If an exchange is going to offer an owner of crypto the ability to short the crypto, they need to get that from somewhere. So there's a lending transaction occurring. As far as I understand, there very well could be within the agreements you're signing to be on these currency exchanges, the ability to actually execute these types of transactions. The law is way behind here, and we got some affirmation as to where the IRS sees the law behind in the 2023 Green Book discussion. But basically, the question is, what is the transaction? Well, when somebody is borrowing crypto It is being transferred to another person in exchange for a contractual right to get it back. But, you know, because of the place on the blockchain, because of the unique nature of each item of crypto, you're likely not getting the same one back. And you have this right to get repaid. And so the right of repayment is dealing with all sorts of questions. I should get some sort of return for having lent you my crypto, which means since I'm lent it to you, I don't have it. So I should get something like interest back. And what happens if in between, now Jordan's telling me we don't do hard forks anymore, but airdrops or other types of protocol changes, what if that happens when somebody else has your crypto? Well, you can put in the agreements how you deal with that. And so all of this stuff has to be thought through. There is really no statutory protection right now for this being a lending transaction. We only have the idea that it's not a debt instrument. And once again, the Green Book confirmed this because they want to have it statutorily called a debt instrument, which means that, guess what? No OID until it becomes a debt instrument. So, and the other important thing to say is this isn't a security lending transaction. So 1058 does not apply, which sucks, because that would really help us here. So I went through what I think the tax results are. And I think the big thing to keep in mind is that when you execute this lending transaction, you probably have a taxable event when you transfer your coin for the value of the right you get back. And then when you get a payment, there's another valuation question about what's the value of what you're getting compared to the principal payment you're due. And then at the very end, there's a transfer of the contractual right itself to get your coin back, and you're getting something like it. Each of those steps could be taxable transactions that need to be dealt with. If the IRS is successful in getting Congress to change the law here, this would be like a debt instrument. We wouldn't have each of those steps, wouldn't be an issue. We would just have to deal with the return, interest-like return as being taxable, and then they're still saying it's 1058 doesn't apply. NFTs. There's no time to get into NFTs very much. But all I can tell you is that it's just a whole new world. We don't even have a definition as to whether these things are really property. The IRS has said crypto is, so this is probably property. But I think if we jump right to it, one of the big issues here is whether or not it's a collectible. And as we know, under 1H5A, we have this definition of collectibles, and it says that the tax rate's higher. So when you read through that list, it sure looks like some of those come in. Everyone's heard of works of art being tokenized and stuff like that. But you know, there's also the word tangible in this definition. And depending on how you associate those words through there, we all know that NFTs by definition are not tangible. That's the whole point of them. So perhaps this doesn't apply at all. But once again, we don't know. Maybe the safest thing to do is to call it a collectible and move forward. The other thing to keep in mind is there's all sorts of things that come up here. I mean, do we have a trade or business or not? That's a high hurdle. It's possible that this is really just a hobby activity. The other thing to keep in mind is that when you're the primary transferor of an NFT, you probably aren't giving up all your rights. So all of these transfers, a lot of them might actually just be licensing transactions, which means that there could be royalties that are happening here. You're paying a royalty, which means if it's a foreign person, you should be withholding. You're receiving a royalty, not gain or loss from a sale transaction. So there's a lot of law here that we need to get through to figure out whether or not we actually have a license or a transfer. The other things that I kind of wrote down as I was scribbling out here, some notes to myself, is we could have a state income issue allocation, depending on the nature of the income. We could have amortization and depreciation expense, which means we could have recapture as when we sell these things. There's all sorts of questions that are just completely unanswered. What about the idea of is it an intangible? Is it a 197 intangible or not? Looks like it should be, but maybe it's not. What about theft losses? I mean, you know, the whole idea of the blockchain is we have a permanent record, but, you know, when do you reasonably have a prospect of, no reasonable prospect of recovery? And what about NFT swapping? When you don't want to sell your collection of NFTs, you just want to trade it for another collection. So I think there's a lot of open questions here. I don't know what the seconds left. You want to?
About
Yep.
1 minute.
1 minute left.
I guess in
Is there
closing
something
on the
we should say?
NFT side, no, I think Michael covered it really well. There are a lot of open questions. There are some questions that have been answered that you can utilize certain approaches to. But just like with tokens, with cryptocurrencies, not all NFTs are created equal. They have collectible-like NFTs. You also can get a quote-unquote NFT for providing liquidity on a decentralized exchange, which gives you the right to receive a reward or a yield. So they're not all one blanket statement, just like cryptocurrencies. You can't put in one bucket, like the gentleman asked about security or property. We don't have all the answers, but you can look at what those assets look like, what that collectible looks like, what that NFT looks like, and then go from there. But those questions that Michael posed, those are not going anywhere. They're going to be around for the time being, so it's good to learn these terms so that you can provide guidance to people in the future.
Yeah, and just as closing, just once, as something I said earlier, this comes down to the question of ownership of property, the transfer of the ownership of that property. So it really seems to come down to an area of timing and valuation.
Want to thank our presenters very much. Give a round of applause.
sitting over here, the guy that's sitting in this row is Jason. He's an IRS special agent. And the very first time I met Jason, he was executing a search warrant on my client with a shotgun in his hand. Hi. Yeah, just point that gun away from me. Get it too close to me. The first time I was there was probably 1980 or 81. I remember being really took us off the plane. Said, you go in there, I'll be around with your luggage in a second. Yes.
But I certainly know the players. So our
Richard, do you get veto rights on who gets your award every year?
I don't even get Ronnie picks it.
It's been a very impressive. You know Kroc.
Sure.
Have you seen him at all in the last year or so?
In the last, since the pandemic started, I've only seen him on Zoom.
He was my boss, but he was getting breakfast for a bunch of guys, plants. Once every month, stopped 2 years ago, and I haven't seen him since. He was always such a pleasure.
I've seen him on Zoom a couple of times. Good afternoon, everyone. Welcome to the panel called Key IRS Collection Topics in 2022. We have a star-studded panel for you today. To my immediate right is Darren Guillot. Darren is the IRS Deputy Commissioner in Small Business Self-Employed Collection. To Darren's right is Stephen Jagger. Stephen is a CPA, a United States Tax Court petitioner, and a partner at Feynman West. And far right is Mitch Dubik, a tax attorney, partner at Higgs Fletcher Mack for 40+ years. The first topic we're going to talk about this afternoon is the IRS's new use of artificial intelligence in improving the taxpayer experience, and Darren will lead that topic for us.
Thank you, Richard, and thank you everyone for inviting us to attend. Is this mic turn on? Thank you. So first, let me start at the beginning of how we got to the point where we're using artificial intelligence the way I'll just describe to you. Late in 2019, Eric Hilton was the Commissioner of Small Business, and and I was the deputy commissioner then, as I am now for collection, and tasked with the opportunity to try and improve levels of service. When we see the data, and you heard the commissioner speak a moment ago, taxpayers are invited to call us and we can't answer every call. And we want to answer every call. The notices that taxpayers get, the toll-free number they're calling, the notice that stimulates them to call us is no ordinary notice. It tends to be a notice that also advises them of consequences if they don't reach out to us. We may levy the funds in their bank account. So you can imagine that would give you added impetus to want to pick up the phone and call us, and none of our employees, not a single one, wants to not be able to pick up that phone. But we simply don't have now, and we certainly didn't then, have enough people to answer every phone call. So how do you answer more calls? Well, late in 2019, we visited campuses, and Eric and I literally, with headphones on, would sit with a stopwatch and listen to the conversations the employees would have with taxpayers, trying to find where we could save seconds on conversations, because when you multiply that over thousands and millions of phone calls, well, there you can help thousands, tens of thousands, hundreds of thousands more taxpayers. And the result of that, very shortly after, was a new policy that's still in place. You may be familiar with it, where if you owe up to $250,000, an individual, you can set up a payment plan without providing us a financial statement, because that interview takes 17 to 21 minutes. By saving 17 to 21 minutes per call, times the number of installment agreements, you see the savings we were looking for. Now, that was a couple of months before the pandemic started, and so it had the added benefit of giving people relief as times got tough and maybe they couldn't afford to pay their liability in full or as much as they wanted to pay each month. They could basically name their price so long as they could pay within the life of the statute. But we're still not answering enough phone calls. How do you answer more calls if you don't have enough people to answer those calls? What types of services are we providing taxpayers on the phone that you don't need a human being to do it? Well, our streamlined payment agreements are simply a calculation, right? Can you pay the liability within the life of the statute or 72 months? A robot ought to be able to do that, a voice bot. In the private sector, we see that all around us, right? Airlines do it, banks, and so forth. And so in January of 2020, we specifically assigned the directors of collection and operations support in the small business division to design a concept. We named it ACS Level of Service 2021. The name was for a reason. The name was to create a sense of urgency, where at the beginning of 2020, can you build this in a year? The challenge was to design a proof of concept where robots in chat and voice could interact with taxpayers and set up a payment plan with them, answer basic questions. By the end of 2020, they had built the requirements, the step-by-step instructions, the blueprint of how the bot would have to do this. And we handed that off to our IT function. The initial estimate we got was that this could be done by 2024. And we had conversations with leadership in the Information Technology Division at IRS. The same story I just shared with you. These aren't ordinary notices. These are taxpayers who are under the possibility of enforcement happening. And lots of taxpayers who want to work with us, we can't talk to them because they can't get through on the phone. And IT came back to us in a matter of, I think it was less than a couple of weeks, and found a way that they believed, no guarantees, that they could do it by 2022 and move the timeline up to 2022. I've never seen that in 35 years at the Internal Revenue Service. They are truly heroes for taking that on, because we all took on a very risky endeavor. And Commissioner Reddick, he believed in it from the very beginning. We showed him a mock-up of what it would look like, that it could interact with taxpayers in English and Spanish, multiple languages. He's a bigger proponent than anyone I've ever seen at the IRS for getting us into serving taxpayers across all types of languages, multitudes of languages. And so he helped make sure that we got the funding and the priority to make it happen. Well, now the hard part.
can you build it that fast? And by December of 2021, by 2021, our IT function, our collection operations, customer experience office, and our online services office on a combined cross-service team delivered the chatbots in English and Spanish, December 21st, 2021. It's important because that's the template the voice bots will be built on. It's only answering basic questions and helping you understand notices that you may have received. But we get a lot of phone calls. That's all people are looking for. And just a week or two later, the first week of January, the first voice bots went live. And those voice bots went live in January 2022 in English and Spanish, and they could answer basic questions also. How many between January 2022 and last week, those bots answered almost 4 million phone calls with a 40% containment rate. What that means is, of that, it's about 3.7 million taxpayers, 40% of them got what they needed and they were satisfied. What's 40% of 3.7 million? Those are phone calls that live assisters didn't get. Those millions of taxpayers didn't wait on hold. And here's the best part, the authenticated bots. And I remember it like it was yesterday. It was a scary week. We approached the second week of June, the authenticated bots. Now this is the full bore thing we've never done in the history of this agency. Artificial intelligence that can interact with you, prove you are who you say you are, go into your account and give you a case resolution. No more notices, no more enforcement so long as you keep the agreement. We came close around June the 10th of having some concerns, errors with the Spanish bots being able to function properly, and we were going to have to delay delivery. One of the executives in IT, a guy named Rob Hill, had his team voluntarily come in on a Saturday and Sunday that weekend and fix the problem, and they fixed it. We went live on June the 14th, and between June the 14th and today, just a month ago, I got the stats this morning, as of last night, those authenticated bots have answered over 600,000 phone calls and successfully established over 6,400 installment agreements in 4 weeks. Combined with the unauthenticated bots, we're well over 4 million taxpayers who've been helped in just 6 months. They didn't have to wait on hold. This frees up our assessors to take phone calls from taxpayers who have a hardship. I don't see, at least not now, where a robot can do that. The types of back and forth questions you have to determine someone absolutely cannot pay. So now we have more bandwidth to answer those calls. A taxpayer has questions about penalties or an abatement, something more complex. But what will happen also this year, soon, is that the bots will be able to, the authenticated bots, give you a transcript. Now, how many of you call the IRS to get a transcript? Imagine not having to wait on hold for 1 second to ask for that transcript. That's coming very soon. It'll also be able to give you a balance due on your account, a current balance due. And it'll also be able to tell you a history of your payments. A voice bot can do that. So this is exciting. This helps us make sure that our ACS employees can get to more people than they otherwise would be able to. We're talking about millions of taxpayers who were able to interact with the bot and get what they needed.
Currently, this is just for taxpayers and not POAs?
That's correct. Thank you for pointing that out, Richard. So I believe in the future a POA will be able to have this access, but at this time, no, they don't. The taxpayer needs to provide things like their date of birth, their social security number, the state that they're in, and some basic information to prove who they are, some shared secrets with the bot. The type of things that the taxpayer is going to know off the top of their head. They're not going to have to go search their records to get it.
Darren, so we shouldn't expect to have this affect the tax practitioner hotline anytime soon.
That's
That's something we're open to discussing, so let me take it to that next step, Mitchell. Now that we've proven we can authenticate a taxpayer using artificial intelligence and go into your file and work your case, now the IRS examination function is we're working on their requirements. Anyone with a phone line that's tied up, right? They all are. You heard the comments earlier today, we can't answer all the phone calls. But now that we've proven this works, we've got the platform, and other parts of the IRS coming soon, IRS examination, SBSE examination, and also the Taxpayer Advocate Service is also looking at using the bots for her phone lines as well. So that's part of the big win here too. It's for taxpayers, certainly that's the big win, but it's also a big win for the rest of the IRS moving further and further into the 21st century, because as we've proven in collection that this can be done, and did it at rapid speed. And again, they're the experts in IT. When they said 2024, that was disappointing to hear, but we accepted it because they're the experts. But they went back to the drawing board, and literally just a couple of weeks came back to us and said, we think we figured out a way that we can do this in two years quicker. That happened in US government. So when you hear that old phrase, close enough for government work, that's not true of the IRS, because nobody pushed them on their own. Our IRS IT people decided we can do it 2 years faster. Yeah, and so on the authenticated bots, you may be curious, what's the containment rate there? It's somewhere around 30%. This is important to point out why that's good. So 40% is in the ballpark of where the private industry is for successful robotics phone operations. 30% is good for the authenticated bot for this reason. Right now, it's only giving you one product. It's giving you a payment plan. What if you called because you want a transcript? What if you called because you want to know the balance due? As the weeks and months go by, those bots will be able to do that, but right now they can't, and yet they're still containing roughly 30% of the calls that are coming in. So we're very pleased with it.
Thank you. Next, Stephen will talk about the IRS administrative record and how to be proactive in shaping and preserving it.
Thank you, Richard. Well, I think I'm preaching to the choir by, talking to you guys about the administrative record, because I'm sure you all appreciate the administrative record. But the accountants that come before you, if you're a lawyer, or the enrolled agents that come before you, if they're a lawyer, they may not be as sensitive or know anything about the administrative record, except that it's a file that's kept by the Internal Revenue Service, usually by a revenue officer, and then by a settlement officer if the case goes into a CDP, or it's a record at the Innocent Spouse Unit in Cincinnati. Why is it important? Well, it's important because if something didn't make it into the administrative record, it's deemed not to have occurred. And if it didn't occur and the case gets to the tax court, where the tax court looks to the administrative record as their basis upon which they're going to decide a case, if it's not in the administrative record and it didn't occur, you've tied the tax court's hands. Happily, there's something you can do about it. Okay? And what you can do about it is you can become proactive in shaping that record, okay? And seeing to it that things that are important and need to be in the record get into the record. Because if you don't, you're at the, I don't like to use the word whim because I don't think it's intentional, but the administrative record is only going to be as good as the note-taking skills and the judgments made by the revenue officer and the appeals officers and the innocent spouse examiners that add stuff to the record. Okay? So I'm here to tell you that you can change that dynamic, okay, by helping to shape the record. And how do you do that? Okay? Well, you do that by becoming what I call a memo maniac. Okay? I've been called a memo maniac, and I'm proud of it. Okay? I didn't go to USD. I went to UCLA and Cal State Northridge, and that taught me the value of written communication. And written communication is the only communication that matters when it comes to working with the Internal Revenue Service. Okay? Otherwise, you get into a he said, she said. And there's case law out there, okay? And I cite one of the cases in the materials, very, very well known, very well respected attorney who I don't see in the room, okay? But if I were to tell you his name, which I won't, but if I were, you would know him instantly, okay? And he had a conversation with an offer specialist in the context of a CDP, which is why the tax court was on board, okay? And he had some handwritten notes that documented some decisions that were being made between he and the offer specialist. And the offer specialist didn't note those discussions precisely in her notes, and this attorney didn't do the same, didn't send a memo, okay, to the offer specialist or to the settlement officer with, here's a copy of the notes taken of our conversation a few minutes ago. Please take a few moments to, to review these and let me know if I've misstated anything. Love and kisses in his name. That's all it would take, and then faxing it into the person he was working with to get it into the record. And the tax court judge was apologetic. Like, we know that you are a very skilled and very prominent attorney, and we're disappointed that we can't give the result to you that you want. Okay? And that was a real eye-opener for me. So at every opportunity I get to speak to staff at my firm, or enrolled agent groups, or CPA groups, I am touting shaping the administrative record. Okay? So that's why we really care about this.
Stephen, for an innocent spouse case, what would some of the potential administrative record items be?
Okay, so the administrative record in an innocent spouse case is still, there are a lot of questions about that, because the law was changed in 2019. Okay? As of July 2019. The rules before July 2019 were that evidence could come in at trial, okay? Didn't need to be part of the administrative record that had been shaped prior to trial. Okay? Since that time, Code Sections, I think it's 6015E7, okay, said that the trials are still going to be de novo, but they're going to be de novo based on the administrative record, unless, okay, there's new information that wasn't previously available. Okay? Well, I don't know what new information previously available, that wasn't previously available means, okay, all the time. That's one problem. The other problem is there's more than one way to get a case into the tax court on an innocent spouse case, right? One way is you file the innocent spouse claim on the Form 8857 and you wait 6 months. If you don't hear anything, you can file a tax court petition. What does the administrative record consist of at that point? A Form 8857, maybe nothing else. So I don't have a good answer. Okay? The other, of course, the other way, just to be complete, the other way of getting the case before the tax court is to raise an innocent spouse defense, either in writing a petition to the tax court after getting a statutory notice of deficiency, or in a CDP hearing. You might get that. But you actually have to raise it in the CDP, okay, in order to be considered having raised the defense. Again, you have to make sure it gets into the administrative record. How do you get it into the administrative record? Okay. In the CDP, you have to specifically state that you want innocent spouse consideration for your client. Okay.
Stephen, are you a fan of specifically asking the person with whom you're dealing to be sure to include it?
Yes, absolutely. I have pat language that I put in every one of my love and kisses memos. Okay? Because let me back up. If I'm the preparer of the CBP request, the Form 12153, I put in the body of that request that I hereby respectfully request that all correspondence henceforth generated become a part of the administrative record for use later, if necessary, by the United States Tax Court. Okay? And then I follow through on that. So every conversation that I have from that point forward, I memorialize.
Well, let me ask a question, a follow-up about what I guess used to be referred to as gilding the lily. You know what you'd like to say, but occasionally the revenue officer or officer specialist on the other side is going to get into a memo or letter writing war with you. So how do you go about trying to get in enough in your letter or your memo that you send so that the person on the other side simply puts it in their file for use by you later and doesn't feel the need to respond, in which case you're just going to get into a he said, she said, he wrote, she wrote?
I guess I don't see the problem. If my memo is in the file, it's in the administrative record.
How do you avoid, yes, but how do you avoid getting into a letter writing campaign with the person you're dealing with on the other side? Being accurate is all well and good,
Yeah.
but your opinion of what was said and agreed to may not be exactly his or hers. And in various contexts, I've always prided myself on being able to get a memo or letter to the other side, says what I needed to say, but doesn't go so far as to make the other person feel that he or she needs to disavow what I put in. I'm only asking about how far do you go in reciting your side of the story?
Well, I guess it comes down to how I interact even when I'm not writing a letter, how I interact with the settlement officer or the revenue officer. I try to make every one of my conversations, if I'm having a verbal conversation, in a respectful tone. And so when they do get a confirming memorandum, they may look at it and go, okay, yeah, this confirms what we talked about. Great. Okay. I don't come at them, with hostility or from a place of anger. I come at them from a place of information. Okay. This is what we talked about. This is why I believe this offer should be accepted. And if you don't like that, let me suggest that my client would be willing to entertain a future income collateral agreement. Because then what happens if that falls on deaf ears and the notice of determination is written by that settlement officer and he or she fails to include the fact that I offered to talk about a future income collateral agreement, well, now I've got abuse of discretion. Okay? Now when I go into the tax court, I have something there where I can point to and say, Your Honor, there's abuse of discretion because I was amenable to a future income collateral agreement and I was ignored. Okay, that's a case that'll be remanded.
Stephen, what do you do about a innocent spouse case where there's allegations of spousal abuse? Do you want to try to get photos in there?
Yes.
Police records?
Yes.
Medical records?
Yes, unfortunately, with innocent spouse cases, and I'm sure most of you can speak from personal experience even much better than I can, but just about every innocent spouse case that I've ever worked had some sort of spousal abuse, and abuse doesn't have to be physical, okay? It can be mental. And I don't have to tell you guys, there's a lot of good case law on that. But the fact is, these are painful cases. They're painful for the requesting spouse. They can be very painful for the non-requesting spouse. And this cuts both ways, by the way, okay? And what I mean by that is, if you're representing the non-requesting spouse, the intervener, okay, you have to be just as mindful of the administrative record. And if you're representing the intervener, and that intervener is going to oppose the requesting spouse's claim, well, sitting on the sidelines and saying he or she doesn't deserve it, because innocent spouses can be either husbands or wives, his or her statement needs to get into the administrative record early, or it's not in. Okay? And going back to your question, Richard, which I'm not trying to avoid about the emergency room photos and whatnot, yeah, they do need to be there. Because if they're available, they need to be there. If they weren't available, theoretically you can get them in as previously unavailable.
Next, Mitch will talk about the IRS's assertion of dissipated assets in the context of an offer in compromise.
Good afternoon. As I was getting ready to get prepared for today's event, I looked at a couple of things on the shelf of my office, one of which was a 1992 or 1993 program for the state bar on offers in compromise. And I was curious, but learned that at least at that point, dissipated assets had not yet been invented, at least not by the Internal Revenue Service for people for purposes of offers in compromise. Let me ask, if I may, how many of you do some work with offers in compromise? Okay. And how many of you have never, if you don't mind, how many of you have never heard of a dissipated asset? Okay. So what's a dissipated asset, and what does it mean in the context of an offer?
Excuse me, Mitch?
Yes.
I would say a dissipated asset is the IRS secret weapon.
Oh, I think you're right.
Okay? That's exactly what the appeals settlement officer is going to pull out of seemingly thin air and say, oh, that sale that you did 2 years ago, how was the money used? If you can't explain why it didn't all go to pay the tax that's due, it's a dissipated asset.
I had described it in quotes as an OIC killer, but your point is very well taken. A dissipated asset is described in some length in the Internal Revenue Manual, which is cited in the materials that you have, but it's generally any asset sold, transferred, encumbered, or otherwise disposed of within 3 years of a submission of an offer, unless the funds are received on unless the funds received on disposition were used for the production of income or used to pay for necessary expenses for the health and welfare of the taxpayer or the taxpayer's family. Now, why is this such a killer? The reason is because, by definition, a dissipated asset has been spent, even if not dissipated. So the taxpayer doesn't have it anymore. So when you submit an offer in compromise on behalf of the taxpayer, and it says, we can pay $20,000 or whatever the number might be, and the offer specialist or the person in appeals says, well, that's nice, except what about this dissipated asset that was another $100,000 or $50,000? Well, you don't have that money anymore, and it can stop your offer completely. And that's why it is so terribly important that you do your homework and look at things before you submit your offer. So if we're all clear on what a dissipated offer might be, let me talk a little bit about, and also call on my co-panelists, to talk about ways that you can perhaps avoid an argument for a dissipated asset. Stephen mentioned that an example of somebody who disposed of an asset within the last 3 years. And normally that is the rule, but Darren and I were discussing this morning about a situation where it doesn't have to be within just 3 years. You want to share that?
Sure. I mean, an example would be 4 years ago. You were under audit. During the audit, you transferred real estate for less than full consideration to someone. And then there's an assessment, and 4 years later, you file an offer in compromise. So that's beyond 3 years, but clearly the taxpayer was structuring that transfer to avoid payment of tax, which I believe is in its essence the foundation of the dissipation of assets. It's to avoid payment of the taxes in full.
That's exactly right. There is relatively little case law. If you compare the case law on dissipated assets to the case law on innocent spouses, it doesn't begin to compare. So much of what I'm about to suggest to you is stuff that I have tried, and it may be only successful because I only did it once, and it may not be something that will work all the time, but let me talk a little bit about it. When you have a client come in for an offer in compromise, you know you're going to be submitting financial documentation, you're going to be submitting credit cards and the like. We all learn lessons by being embarrassed. I will never forget the time that one of the offer specialists with whom I knew well and liked, said to me, Mitch, the next time you submit an offer, don't send me your client's credit card statements if they have round-the-world cruise tickets listed. So that's lesson number one. You have to take a look at what it is that you're going to turn in. And in an offer and compromise situation, like certain other ones, it is particularly important that you be careful. So what can you do? As I think other panelists on other panels today have mentioned, we don't always get to pick our clients or know what they've done during the last few months or few years. But one of the things we can do is to attempt to avoid this somewhat artificial or presumptive 3-year rule by telling the client when he comes in, look, let's get your business affairs in order. Let's get your credit card statements in order. Let's make sure that you're not putting stuff on those credit card statements that's going to be embarrassing, that you're not disposing of assets or income in a way that we can't justify. So the first thing is, if you need to take a little more time, there are ways to do it to slow down the process. I've always found that one of the frustrating things that I can't control is in the offer experience is that sometimes they will want financial information, all the backup stuff, as of the time you're submitting the offer. Over time, I've learned with both the state and the federal government, you can sometimes hold up doing it. That is, when is the IRS going to take that snapshot of your client's life against which his offer or her offer are going to be measured? And if you send the documents in and then they tell you 3 or 4 months later, oh, now we're ready for the documents, so send in the 433-OIC with all the supporting information, you've at least had a few months to do some planning and help your client get his offer to look in a better, be in a better situation. I want to talk a little bit about a couple of examples because I think that they are illustrative of what can be accomplished on a good day. Some years ago, I had an elderly client who was undergoing an audit. I won't go into the details of what got him in trouble, but we sized it up and saw that if we, that there was an asserted liability of some $2 million. And I figured that if I really did a great job, spent a lot of time and resources, I might get that number down to somewhere between $1.25 million to $1.5 million. His net worth was about $1 million. And I sometimes liken that to asking clients, if you're 10 feet underwater, how much would you pay for a 2-foot lab? The answer is nothing, because it doesn't really change. So we dispensed with the audit and moved to an offer and compromise situation. He happened to have had a condominium in San Diego, and he was able to get it sold before a notice of lien had been filed. That's the good news. The bad news is now he's sitting with $1 million. What do we do with that? He had some significant health issues. That notwithstanding, if we presented his offer showing $1 million sitting in the bank, I was not real optimistic about how things were going to work out. Now, I'm not a huge fan of annuities, but we went out, and it's not so easy to do, but we went out and got him an annuity. So in a sense, we traded $1 million of cash for what turned out to be about $9,000 of monthly income. The revenue officer who I knew, and I talked a little bit about it, and I wrote her about it, so it would be in the administrative record. But we were able to trade that big pot of money for a monthly amount. The IRS, of course, stands in the shoes of the taxpayer. But when you added that taxpayer's monthly income plus his Social Security, let's just say he had $13,000 or $14,000 a month of income. He had his normal expenses. So worst case, if you were under the 12 months times the amount of disposable income rule, if it was $9,000 a month, 12 times 9, I think, is 108. And so we thought we were down to 108,000. We thought we had done a pretty fair job. The client, of course, was not impressed. And so he said, what else can we do? So we went out and we got a medical professional, someone who does this stuff for a living, to write up a report explaining that his medical expenses were not going to be the normal ones that are allowed for an offer, but we're going to go and be $4,000 and $5,000 and $6,000 per month. And when you subtract that, we were able to end up with, I believe, a partial pay installment agreement, but essentially an offer-like result, where the client was paying approximately $1,000 a month. So my point is, we were able to take a big pot of money that if we could have kept a quarter of, I think I would have been happy, and we were able to turn it into something that would not be so difficult, and he would retain the benefit. In doing that, we also looked into life insurance. That is another thing that you may wish to do, or may wish to think about, that is buying an insurance policy. That's got a cash surrender value, which the government can get at. But eventually, when it comes to fruition, if the taxpayer has a good reason to be buying such a policy for his spouse or his family, it could make a huge difference in the amount of excess cash that he will have around. In other words, what I'm talking about now is if you have an asset that you're either gonna have to give over and you don't wanna have it be dissipated, what is it that we can do to avoid it? So annuities are one possibility, insurance policies are another. If your client has a significant pension plan, consider explaining to the IRS that his and his younger spouse's life expectancy is several years, and they're gonna need that money to live on, because he or she is gonna stop working, they're gonna be living only on Social Security, and again, you may be able to turn a several $100,000 pension plan into the equivalent of the annuity by saying, look, this is how much. We actually hired an actuary so that we were able to show that this taxpayer and his wife were going to need the funds that were in his pension plan for the rest of their lives. And we got it, this is probably 20 years ago, but we got about a $400,000 pension plan excluded from an amount that had to be included in the offer. I will say, once you have something that the agent, and there are some agents who will work with you to avoid something being a dissipated asset. I believe there are some other agents, offer specialists, the occasional appeals person. I wouldn't use the word revels in, but enjoys being able to say, we can't accept that offer because of this dissipated asset. Now, once you're in dissipated asset territory, you can often negotiate an amount down. At the end of the day, they'd like to see legitimate taxpayers get their offers through. But make no mistake, if you have a dissipated asset and there's a good excuse for it, you'll come up with paying more than you wanted to, but less than you might have feared. If you played fast and loose, it can be a lot tougher. Let me give you just another couple of examples. Some years ago, I worked on an offer for a gentleman who owned quite a bit of real estate. The point here is not the real estate that he owned, but the fact that he collected, it was about $15,000 a month that he collected in property taxes. It turned out, at least at that point, you could not prepay property taxes monthly in the state of California. You had to send it in every 6 months. So we were looking at bank accounts that were running up to $180,000 that we didn't want to include. So we told the revenue officer, we set up a separate account. We called it the Real Estate Property Tax Trust Fund. The banks then would do almost anything you asked. And we had this separate account that we put the money in, and every 6 months, of course, we spilled it out. But we didn't have to worry about the agent thinking that that money should be included as an asset. Finally, there are situations where if you have a client who's doing an offer and has a business, there is an exception under the dissipated asset rule for income used for the, funds used for the production of income. So if your client has a business, maybe it's struggling, maybe it needs to have some R&D done, maybe there's something that you can put this money into the client's business where it won't necessarily affect the valuation of the business on the 433A or any evaluation that the IRS does. My point is, when you get in these sorts of challenging offers, if you have the opportunity, doing some thinking, trying to see if there are ways to define the assets that are involved in a way that excludes them from being dissipated assets, you will have done your client a real service.
Next, Darren will talk about and provide you with an update on the IRS passport verification program.
Thanks, Richard. If you don't mind, just before I start, I want to read a comment, a reminder that's the very end of the IRM section that covers dissipated assets, and I think it speaks well to what Stephen mentioned about the administrative record and Mitchell's concerns about, depending on who's working your case, are they going to genuinely hear you out on whether the asset was dissipated. Reminder, the value placed on a dissipated asset should be included on the AET, which is provided to the taxpayer with the rejection letter. This is necessary so the taxpayer has an opportunity to dispute the value and/or inclusion of the asset in any appeal submitted. I'd like to know, please reach out to me directly. Happy to give you my phone number before I leave today. If I have an employee that's not giving you that opportunity, I hope they all are. I think they are. So if we detect, it's our job to make sure, in fairness to all taxpayers who don't need to compromise and pay a lesser amount than a legally perfected debt they owe the United States, right? It's our job to be thorough. If we're saying you dissipated an asset, we have to give you an opportunity to disagree and dispute that, and that should be part of the record when it goes to appeals. So thank you. The passport program. So you're all familiar with it. This became law in 2015 as part of the Fixing America's Surface Transportation, or FAST Act, and we implemented it in January 2018. It's section 7345. It requires the denial, and it authorizes the revocation of a passport by the Department of State. We certify to the Department of State individuals who have a seriously delinquent tax debt, which is defined, and it changes periodically, annually. It's adjusted for inflation. Right now, I believe it's $55,000. An automated program sends that list to the State Department through a secure portal, and the State Department, if you apply for a renewal of a passport or to get a new passport, they are required to deny it, but the State Department has that exclusive authority. The revocation is something they are authorized to do. So there are some, but we can't tell the State Department, you have to revoke this person's passport. It's totally up to the State Department. We send them a recommendation. There are certain situations where a taxpayer is exempt. So you just heard about one. They've got an approved offer in compromise. They have an approved installment agreement. They have an approved, they've submitted an innocent spouse request, or they've got a CDP hearing on a levy that's underway. Those are right there in the law. Also combat zone. Those are statutory exclusions. But the IRS, and this could change, it's subject to change, but right now we also have discretionary exclusions. So if a taxpayer is in bankruptcy, or we determine they're currently not collectible, or they're in a federally declared disaster area, or they have a pending installment agreement, or they have a pending offer in compromise, we will not certify it to the Department of State. So if you're curious about, Richard, you were asking how successful the program's been. Since we began sending the certification list to the Department of State in 2018, we've certified 831,176 individuals. Now, when we send that certification to the Department of State, we can currently send it to the taxpayer, not the representative. And the State Department then engages with the taxpayer, gives them 90 days to try and resolve this. Now, keep in mind, the average taxpayer we certify has owed us taxes for an average 7.4 years and owes on average $243,000. That's who these taxpayers are. So they've already had, on average, 7 years to get an installment agreement, some sort of payment arrangement, and they owe almost $250,000. We have a decertification process, I believe, that works really, really well. If you meet one of these criteria, either statutory or discretionary, to be decertified, we do it within 30 days. If you have an expedited need for a passport, goodness, I just saw one last week.
or someone needed to go to a family event in a few days. And by 2:35 in the afternoon, we did our part and headed off to the State Department. But then the taxpayer has to work with the Department of State after that, and that's outside of the IRS's control. The number one reason for decertifications, if you're curious, statute expiration. The collection statute expiration date expires. The second most prominent reason that taxpayers are decertified is a pending installment agreement. So the program has been working. It's getting people back into compliance. They're coming in and making full pays. They're coming in and establishing installment agreements. They're submitting offers in compromise. There's a phone number. If you need an expedited decertification, it's 855-519-4965. 855-519-4965. If you need an expedited passport decertification, we've got a passport team in collection headquarters that's what they do. They manually handle those decertifications and fax them to the Department of State. And we do that as quickly as we can. We generally can shorten the 30-day decertification window to about 2 weeks, about 14 or so days. Now, revocations, a little bit more rare, but there are taxpayers who, their behavior is so egregious, we do recommend to the Department of State that the passport be revoked. And we send a letter 6152 to the taxpayer, letting them know we're going to do that. The taxpayer's got 30 days to work with us before that happens. Again, it's totally up to the Department of State whether or not they revoke that passport. So to date, we have decertified over 328,000 taxpayers, and we've generated, since 2018, $7.5 billion in revenue into the Treasury.
We have a couple of minutes left. I don't know if anyone has any questions in the audience.
Yes, ma'am.
I think the biggest challenge I run into with installment agreements and offers is if the returns haven't been filed.
The biggest challenge I run into when trying to do an offer or an installment agreement for a client is they don't have the money to pay us to do the delinquent returns. And they'd like to start making payments on their debt that already exists, but they can't until everything's filed. So it's sort of a vicious cycle. Is there anything that would enable them to start paying and avoid these kinds of things while they're trying to get the money together to pay to have the returns prepared?
So now the policy is that you have to be in compliance before we can put you in a payment agreement, but a taxpayer should always be making payments, especially if they agree they owe the money, because they're paying interest and penalty that are accruing every day, right?
But that wouldn't take them out of this, like they could still get their passport revoked then, right? Even if they're making the payments.
A pending installment agreement would get them in would help them get decertified. Now, if it's a question of they can't afford to have somebody prepare the returns, taxpayers got all kinds of alternatives on how to get their returns done. There are VITA programs. Correct.
But you can't go pending installment agreement if you're not current on your tax returns.
Right.
So if they're not current, their passport will get revoked because you can't get on the pending installment agreement.
Yeah.
Right.
With respect to payments, I would just have one thing to add. If you're going to suggest to a taxpayer that they send money to the Internal Revenue Service, consider a designated payment. Because if you look at how old the tax is, if a tax might become dischargeable fairly soon, you don't want to put it to the oldest tax year. Okay? Or if there are trust funds there, then you want to really be sure that you designate the payment to the trust fund liability first. Because the biggest mistake I see people make is they just throw money at the Internal Revenue Service, and what happens, the Internal Revenue Service can use the money in the government's best interest, which may not be what you would like.
And I would just add to that, you said the taxpayer is having difficulty paying to have someone else prepare their tax return. If they're working with us and they need the passport decertified and they want a payment agreement, and the barrier is they have some unfiled returns, they can ask us for assistance with getting those returns prepared. Our time's up, but I did want to point something out. You heard about virtual currency earlier and things that the IRS knows. On May the 2nd, every revenue officer in the country now has an electronic indicator on all of their cases. If you have a client that has foreign assets or a foreign bank account, we now have a FATCA indicator on every case. So before we lay eyes on that taxpayer, we started going to the field a week ago, we know that they have or may recently have had a foreign bank account or assets. So it's important that they're honest with us about that when we interview them.
It's a bad first line.
Thank you very much.
want us to? Yeah, give us some tips and tricks, Joe, on how to deal with, like, what is it going to take to get a departure? Give us some advice.
Upward departures. I changed my plea agreement. The plea agreement now says either party can ask for a departure. So you can ask your tower. If you don't know about it, is that fair? That should be fair. Why is it that everybody thinks departures is down? Thanks for coordinating everything.
Welcome. I'll be right there.
Okay.
We got Sandra Brown moderating. We got an expert here. It's going to be a great panel. She's going to definitely do a great job moving this stuff along. You guys got such a wealth of knowledge right here. It's a great group. Yeah, it's a good group.
We'll try to entertain too.
You might have to cut some of Joseph's time. You know, if he goes over his time. You know, he might talk a little too much.
That's where she elbows me under the table.
Yeah, Jordan.
Oh my gosh, he was a delight.
He was great. Yeah. Growing. Here's some good relevant stuff. Just very relevant to today. Good topics. I thought for sure.
Yeah, you have a permit, right?
All right, guys, you want to get started? Oh, Nathan, okay.
He's here.
Nathan, time for showtime. Sorry to interrupt you, sir.
But if anytime you need to.
Yeah, I might need to be poked too, because I have.
Wow, those lights are strong.
We're gonna get a tan in here. Yeah. Can't see my name.
Are we ready?
We are ready.
We're ready. Wonderful.
This is the showcase panel. They've all been the most amazing panel.
They've all been amazing.
Criminal work.
I've learned a lot.
Criminal work.
I've learned a lot. I did go back and forth and try and decide, well, first of all, welcome everyone to our last panel. I'm Sandra Brown. I'm a partner at Hockman, Salkin, Tosher, and Perez. In a former life, I was a government prosecutor, AUSA, for almost 27 years, and doing exclusively tax work. My fellow panelists said I should mention to everyone that I had the unique position in LA in the tax division where we did actually both civil and criminal tax cases. And so unlike in DC where you're either in civil trial or you're in criminal enforcement, once in a while somebody gets to jump the line, but that was what we did in LA exclusively. So I bring that unique perspective here. So I will go ahead before I go off on a tangent I was going to go on right away and Joe and I went back and forth about whether or not, based upon his last name spelling, whether or not I just have him introduce himself, but I think I got it, Joseph Orabana. But Joe, why don't you go ahead and introduce yourself in regards to a quick background.
See, I'll make fun of Sandra because she got it wrong. Even though we talked about it. Oh, yes, Orabona.
Bona.
Yeah, there's no O. That's okay. There's a lot of O's and A's in my last name.
By
Good afternoon, ladies and
spelling.
gentlemen.
There, that was right. We'll turn it around.
No, that's okay. Nobody can ever pronounce my last name anyway. I'm Joe Orabona. I'm a U.S. attorney here in San Diego. I'm a senior litigation counsel right now. All that really means is that I've been doing prosecution work for a really long time. So they figured they'd change my title. And that I have a wealth of experience of doing things other than just tax cases, but fraud cases and some other interesting types of cases. I've worked very closely with the guy to my right over here. It's like you got an entire panel of either prosecutors or former prosecutors. And so I'll turn it over to him so he can introduce himself.
Thanks, Joe. And thanks, Sandra, for inviting us on this panel. My name is Eric Best. I'm a partner at the law firm of Barnes & Thornburg here in San Diego. Joe and I used to work together in the U.S. Attorney's Office here in San Diego in the criminal division. I was in the major frauds and special prosecution sections, and we worked on a number of different matters, both as we actually worked on cases together, too, a couple of times. Joe brings a substantial wealth of experience on tax cases, so much so that he now wants to do other things in the office other than tax cases. I now represent companies and individuals that are facing government investigations. So I bring the perspective of having been on the government side for over 2 decades, mostly in San Diego, but also in Washington, D.C., and now I'm advising companies and individuals on what to do when they find themselves under the eye of perhaps Special Agent Jason Powell from IRSCI. Maybe I'll pass it over to you, Jason.
We'll let you go next, Jason.
All right.
Good afternoon. Notice Jason didn't have any pictures besides himself with his dog, so we use his bag.
I look back at, I only had ones with my dog in it, so. I'm currently a supervisory special agent with the IRS criminal investigation. Been with IRS for over 20 years. Worked a lot with Eric and Joe down here, and definitely miss Eric in the U.S. Attorney's Office. Glad to be here.
Well, sir, it's up to you.
Hi, Nathan Hockman. So tax kind of runs in my blood because when my dad, who was a tax lawyer for about 50 years, proposed to my mom, his proposal line was, do you want to file a joint income tax return? If that doesn't say love, I don't know what does say love. So I ended up following in my dad's footsteps a bit. Went to the U.S. Attorney's Office after a clerkship, did a whole bunch of tax cases. About 10 years after I left, got appointed by President George W. Bush to be the Assistant Attorney General in charge of the U.S. Department of Justice's Tax Division. Got to work with Sandra back then in LA. She was holding up the entire West Coast operation, which was very impressive. And then have been on the defense side. And I must tell you, you get to speak a lot more forthrightly and honestly and controversially on the defense side, so I'll take that opportunity during this conference.
Thank you. As you can tell, we have an amazing panel. And we got a lot to talk about in the next hour and 20 minutes before we get you guys all to what will be another wonderful reception, as Ronnie always puts on for everybody. Thank you. I will try and keep that really close. Don't hesitate to somebody yell out. It won't offend any of us. So Ronnie gave us the topic of criminal tax workshop, but then we kind of looked at it and it was like, okay, so kind of a subtitle, nuts and bolts of criminal tax case and how to prepare your client's defense, which means we gave enough for the government side and enough for the defense. And so what we're really hoping is that we're going to kind of go back and forth amongst us as we go on to the different topics. And you can see we kind of have the outline of kind of like what is the whole, bits and pieces of a criminal tax case, all the parts kind of going into different prosecution theories, and then a lot of defense strategies, and probably a lot of personal war stories as we go through this. So one question I have, because we're going to start in an area which, as I turn it to Jason real quickly here, but one of the things I want to know is how many people here have represented somebody who was the subject of a criminal tax investigation. Okay, not very many, okay, because that helps us with regards to knowing how detailed to get into it. Because one of the things we are going to focus on, maybe a little bit more than if you've ever seen a criminal tax panel before, is actually an administrative investigation. Because I think we can all kind of figure out, okay, grand jury, right? That's kind of obvious, you get the grand jury subpoena. But there's a whole lot of different things that go on in an IRS CI administrative case. And so I know Jason's going to really get into a little bit more detail than maybe you might get normally in, in a criminal tax workshop panel, because we are seeing more of those. I'm seeing a lot more administrative CI investigations than I used to see even as a prosecutor. Former prosecutors, current prosecutors, we all have opinions about what we think about administrative CI investigations, so we'll share that with you. But there are definitely nuances that I think are very important, particularly if you kind of had an eggshell audit and you're dealing with a really tough examination case that ends up going to fraud referral and things to look for. So I think that information will be hopefully very interesting and very useful to everyone here. So with that, I will go ahead and turn it over to you, Jason, to get us started.
Thank you. I'll just briefly cover the structure of CI, and a big thank you to our current commissioner, who is very pro-criminal investigation. We plan to hire up to 500 special agents this year. I believe the last 2 years, each year we hired 400. At one point, we had 3,000 special agents in the country. We have fallen just to around 2,000. So we're trying to improve those numbers. And I think that's why we're going to see more administrative investigations as we get newer agents coming on board. And so for those, we'll go over that shortly. So briefly through the structure, you saw our chief lead this morning. He's basically our CEO of our organization. Our special agents are the investigators. They can be CPAs, revenue officers, revenue agents, or former computer experts. We come from all sorts of backgrounds. I personally have a sociology degree. Don't particularly like accounting, but I think I'm a pretty good investigator. So I'm a supervisory special agent. I oversee these special agents. I have 10 agents in my group, and above me is an assistant special agent and the special agent in charge. For the audience, most likely you will come in contact with either the special agent and possibly the special agent in charge. We have the Special Enforcement Project, that we call them the SEP group. They are a group of revenue agents that assist us with technical matters on criminal tax cases. Again, I'm a sociology major, and I definitely rely on my expertise as we get into technical issues on the tax returns. We have analysts that assist us in the investigations. They will run databases for us, input bank records into spreadsheets and things like that. I think the chief covered the J5 this morning, so I'll just cover the NCIU if he didn't. That is a team we put together, a couple of supervisors, special agents, and analysts, and they basically do data analytics, and their role is to produce leads, and we'll get into lead generations later, but produce leads for the field for special agents to work. So anatomy of a criminal case, these are generally the charges we will investigate, although it's not every charge. 7201, tax evasion, that is our go-to case, along with 72061, which is filing of a false tax return. Occasionally, a case may not rise to the level or meet the elements of a tax evasion, or the tax evasion statute, so we may go the route of filing a false tax return. At least one thing on the return is false, it's material, they signed it under penalties of perjury. 72062, we call these our return preparer cases. If we have a bad return preparer out there creating a scheme for fraudulent tax returns, that is the statute we would go after. You can see some of the Title 18 violations there. I would say the primary statute we investigate is money laundering, 1956, and 1957. We currently have 8 agents in San Diego County who work organized crime drug enforcement cases with DEA, FBI, HSI, and their primary role is to conduct a money laundering investigation, which is parallel to a human trafficking investigation or a drug investigation. won't go into too many of the charges here. IRS, with the administrative investigations, has anybody dealt with a criminal IRS administrative investigation? 5 or 6 people? So, as Sandra mentioned earlier, the grand jury process seems self-explanatory if you get a grand jury subpoena. How do you know if IRS is conducting its own investigation without the use of a grand jury or a prosecutor? A couple of signs. IRS agent shows up at your subject's door and wants to interview them. And if they agree, we would read them their non-custodial rights. It mirrors Miranda rights. So we're basically giving them all the outs to get out of the interview, that they don't have to self-incriminate themselves and all that. So
Yeah, you heard all of us laugh, okay?
I have it in my wallet.
Yeah.
I have not done an administrative investigation in a long time, but I won't comment on. We're required
Yeah, and
to
I
do
know
it.
Nathan's gonna go probably right where I'm gonna go. So, the first thing your client calls you up and says, so 2 agents showed up, and they were only here for 10 minutes, right? They were here for 2 hours. I said nothing, etc. And they read these rights, which again, as he's saying, it's an interesting thing because as former prosecutor myself, it used to drive me crazy. I'd be like, Miranda is based upon a custodial situation. Why in the world are you reading these Miranda rights? Because it's in the Internal Revenue Manual. And I'm like, the Internal Revenue Manual is a doorstop. It means nothing unless it's based upon a due process. So it's attention, and he's smiling because he can't really say a whole lot about that, but other than nod his head and agree with me. That is one of the frustrations that a lot of prosecutors have with an administrative investigation. It is one of the benefits, however, if you are a practitioner dealing with administrative investigation, because there's generally nothing covert. So, they're not out issuing bank subpoenas because they have to issue a summons, and it's a third party. So the same rules for a civil examination on summons powers with notice to your client apply. And so it's a very different game, I'll say, in the sense of figuring out up front, and Nathan will always say, in every criminal case, you as a defense lawyer need to be doing either the same investigation or in front of the investigation, because you need to know what the damage is and what the issues are, so that if there's a reason to communicate with the agent quickly and up front to control the damage, get a declination if you're lucky, but to control the damage and figure out if there is an appropriate and softer resolution. And so sometimes an administrative case where there's no prosecutor involved who hasn't bought into the case, and the agents also know, at some point, I'd much rather be working with Joe here and have a buy-in, and Joe's backing on me in a grand jury case. And so there are a lot of tactical things there kind of to think about, which is why some agents don't like it. But some agents really like it. They like to go out there and do the gumshoe and work this case by themselves and not have to work with Joe until they need Joe to charge the case. And then they just want to tell Joe, here's my pretty little package to charge my case. But so kind of big picture, and, in regards to why we chuckle about the brand.
So, Sandra, real quick question for Jason. So how does the IRS decide which cases are going to be administrative and which cases are going to go through the grand jury? And again, for the people in this audience who have not gone through an administrative case, can you just describe what you do in an administrative case different than what happens in a grand jury case?
So the administrative case, I would work it just by myself. All investigative steps are determined by me and my team of investigators. The process of the administrative case, how do we decide grand jury versus administrative? Most cases might start off administrative, and something in the investigation warrants elevation to a grand jury case. Perhaps we have uncooperative witnesses that need to appear before the grand jury. Maybe we need the secrecy of the grand jury. Maybe we need the support of the U.S. Attorney's Office. So it's on a case-by-case basis on how we determine administrative versus grand jury.
I have a question real quick. If there's a power of attorney in force, and you know how collections needs to call the representative, in a criminal case, if there's a power of attorney in force, is the IRS obligated to talk to the representative first, so they can show up at the door?
Because we have people who are listening remotely, so to repeat the question, if there is a civil power of attorney on file. So if you're representing the individual in a collection or an exam type issue, does then, in an administrative criminal case, does CI have to come to the power of attorney first, or can they go directly to the target? Right. This is interesting because CT, criminal tax, has, I think, a different view than perhaps sometimes CI does, because there are state bar rules with regards to contact with represented parties. So if I have a CI agent who's also a lawyer, we may take a different approach. And CT will, when I say we, so I'm referring to CT taking that approach and giving advice. A lot of times, and my point is, so that's why we had CT on the slides, also to understand there's a role throughout the process, often where criminal tax counsel will get involved with regards to giving that kind of advice. But as a technical matter, that power of attorney is not applicable for the criminal investigation. I don't know that any of us want to go in and file a power of attorney that says, I'm represented in case you have a criminal investigation. But to kind of flag in the middle of an exam there might be. But yeah, they can ignore it. They can ignore it.
I wouldn't be qualified to represent them in a criminal case, but I just didn't know if that was required contact by the CI people first or not.
Yeah.
Yeah, it sounds like it's not required.
And Jason can get into, and everybody else can get into this point, but often the first touch is the taxpayer without notice. And if they know it's perhaps a false return case where there's a return preparer involved, there's usually 4 agents out at the same time. 2 are knocking on the taxpayer's door and 2 are knocking on the return preparer's door.
So my question, actually, I've always wanted to ask this question. Why ever use an administrative investigation? Grand jury powers and dealing with the U.S. Attorney's Office are so much more vast. So in other words, if you serve a subpoena to a bank to get records, in an administrative case, that is a summons and the taxpayer gets notification of it. In the grand jury case, it's a grand jury subpoena and the bank's doing its job, the taxpayer will never know it occurs. If you want to get their email records, you can serve a grand jury subpoena to the Yahoo, AOL, Windows, wherever you think the email is stored, and the taxpayer never knows about it. You serve a summons, the taxpayer knows you're there. Search warrant. You need a search warrant. You need the U.S. Attorney's Office to go ahead and do a search warrant. You can't do that just yourselves in an administrative case. So I've never understood why the IRS would forego all the powers of a grand jury case and do an administrative case in any situation.
Because, Nathan, I can only take so many criminal cases.
It's a reason.
That's why there's an entire tax division back in Washington, D.C. to help you out here in San Diego. And maybe that's the answer. Maybe the answer is that, and maybe you can even talk about the volume of investigations that you start out with, what percentage are administrative versus grand jury, and what percent actually finally make it to indictment or some type of criminal charge.
Sure. We can ask DOJ Tax Division for an authorized grand jury, which they will then be our prosecutors, as Joe would. I think it comes down to a resource issue. Like Joe said, the U.S. Attorney's Office also has priorities. We have priorities. Lack of resources, they cannot take every single one of our cases, but we still need to complete our mission, which is to foster tax compliance, deter crime. So that is why we will go the admin route. You mentioned search warrants. We do search warrants on administrative warrants. That might be the first time you hear from us. However, we still need the support of the U.S. Attorney's Office to review the affidavit and bring that with us to the magistrate judge.
Historically, the IRS-CI did administrative cases unless it involved with organized crime or some other type of a joint investigation. And probably for about 50 years, that's what it was. It was administrative cases, and that's how they worked the cases. We're very good at it, very document intensive, and they're gathering the documents, and they have the extra year on a criminal tax case. Congress saw fit to say that I guess tax cases are complicated enough. They get 6 years to have a statute on the criminal, unlike most 5 years for other cases. But in the Department of Justice Criminal Tax Manual, as well as in the Internal Revenue Manual for CIs, they have to have a justification to explain to DOJ tax division why a grand jury case should be authorized in an administrative case will not suffice. So that's when a CI agent either decides, I want to work the case administratively because I can work this case administratively and equally effectively. And I don't want to be another case on an AUSA's desk where all they're doing is signing my subpoenas, perhaps. And then I've got to deal with returning everything to the grand jury. And so there are sometimes strategic reasons for it. Sometimes there are particular scope type cases where maybe they have information that's come in from the exam and maybe they're not sure on a fraud referral. There's enough there to open up the case and number it, but it may be not enough that there's any real good reason to actually use the grand jury resources.
But to answer your question, Nathan, my preference is every case would be a grand jury.
And by the way, from the defense side, I love an administrative case. Because the person who's going to prosecute it and actually bring that case to trial, if it has to go to trial, is the prosecutor, is the assistant U.S. attorney, the tax division attorney. If they're supervising the investigation, they'll do it with an eye for let's create the evidence that'll be admissible at a trial. Now, agents are very good and some excellent, but they're not ultimately the prosecutors. They don't have as good a working knowledge of the rules of criminal procedure, the rules of evidence. They rely on CT counsel, but again, CT counsel aren't trying the case in criminal court. So what does that mean? Potential mistakes can get made. Potential evidentiary footfalls can occur. And this is the type of thing when you finally get this case, if you're on the defense side, that you're looking for. Because if you can say they made some type of error along the way, and I would argue depends on the case and the agents and the prosecutors, but I've seen some errors made in administrative cases that I don't think would have been made in grand jury cases, then voila. I mean, you could throw a sledgehammer and sort of destroy the beautiful edifice that has been built by these agents for years sometimes, and tear it down to the ground. So on the defense side, if I see it's an administrative case, hallelujah. I've just always been curious why they ever go administrative.
Yeah, I 100% agree with Nathan on that. On the defense side, an administrative case gives you so much more to work with. And one of the big things is the point that Sandra made before. There is a limited opportunity for covert investigation by the government in administrative cases. Jason explained, you walk up to the taxpayer and you say, hi, I'm from the IRS, and you have the right to remain silent. Anything you say can be used against you. Even if the taxpayer doesn't get it at that point, when they tell their lawyer, some very polite agents came to me and told me that I could potentially go to jail, right? At that point, it's really hard for the government to do stuff covertly. And so as a prosecutor, I hated admin cases because your opportunity to get statements from people before they know that there's a criminal investigation is substantially reduced. And on the defense side, I love it because you know from Jump Street, okay, this has potential criminal exposure, and let's prepare for that.
Eric, that's a great point, Eric, because if it's a company and the IRS knocks on the door of the president, hi, it's the IRS here, criminal investigation, love to talk to you. As soon as that's done, they call me. I then get lawyers for everybody in the company. So from now on, and then I tell the agents who've shown up, everybody's lawyered up. And if you want to go to anybody, you got to go through a lawyer. Now the ability to go covert, the ability to even have an interview where a lawyer for the defense or the witnesses is not present is gone. And that would not have happened if it was a secret grand jury investigation.
But at that point, Joe, are you ready to have a grand jury come over so you can help Jason do his job now that Nathan's lawyered everybody up?
That makes it way more difficult. It's not as much fun for a prosecutor, obviously. I like sending in people with recording devices to get your tax preparer who's doing the wrong thing on a recording. And, as they're sitting there in front of my undercover agent and saying, oh yeah, sure, I'll do that return for you, no problem. I can get you a $10,000 refund right now. Oh, don't worry about it. You don't need any income. Here, look, take a look at this chart right here. Why don't you just point to a number, and then we'll do all these credits and things, like child credit. You don't have a job, right? You got like 8 kids. Oh, I'll take Eric's kids and put them on your return, okay? And so
you think he's joking? Like this is the type of evidence that you can get in a really good undercover.
And I'm sitting there in my office thinking, this is a great tax case. I'm really loving this. No, I don't want an admin case, and it really does make it much more difficult, obviously, if Nathan's got everybody lured up. I'm probably going to look at Jason and smile really pretty and say, that was your admin case, right? Yeah, we're not doing a grand jury on that. Have a nice day.
I think in that case, DOJ would have already approved our request for a grand jury case, and now it falls on them to take the case. And I'll just say another thing for admin cases. Again, as Nathan said, we're still under the summons requirements, and that delays the investigation, having to wait the required time for waiting for petition to quash to proceed, and it just, so you may get 100 summons, third-party notices on the first day, just so we can kind of handle all this at once.
Jason, can you talk a little bit about what it would look like to the practitioner, though, when you open an admin case if there's already been an audit activity with the civil side of the house, right?Maybe just talk about from what the rules are of the road from IRS, and then what they might see, when you go admin.
The return preparer?
Well, either return preparer or any kind of criminal tax case that comes out of like a civil audit, let's say.
Oh, is it a fraud referral, perhaps?
Yes, yeah.
It's a strategic investigative move on who we interview, when, where, why. And we treat every interview differently depending on the circumstances. So, if the return preparer is culpable, perhaps we approach that differently, or perhaps they just have no idea what is going on with their client. But our attempt is to interview the subject and the return preparer on the same day, or within close proximity, so that if they are in collusion, they don't have time to talk, they're both caught off guard.
And how much time would you say passes from when you get the referral to when the interviews are taking place, optimally?
Again, case-by-case basis, it's an investigative decision, but we tend to want to do it on the earlier side, which drives every single prosecutor a little crazy.
Really crazy.
Because, at that point, we don't have all the evidence to question, at that point, but we do need a starting point, and this is an administrative case. We need a starting point, and generally that's through the fraud referral. Generally, our next steps are interviews.
So that is a pointer there that if you have a reason to believe it is a fraud referral, and I know LeVar, I think, may have been, when he was on the other side, taught me this, the FOIA request. As much as it can take a while, it's amazing what information you can sometimes get if it is a fraud referral. And so the point is if I've got a revenue agent or revenue officer who's made a referral, and their history sheets indicate some information that may be inconsistent with some information that CI may have, early conversations, Jason doesn't want to waste his time. The IRS, CI, has always had over a 90% conviction rate. It's because they pick the right cases. They may be small, but they're mighty. And, when you think of the fact that a criminal tax case is the hardest case probably out there to prosecute. There are not wiretaps. There is not, kind of the type of case where the jury they're like, I can't relate to this, maybe the CP case or the bank robbery, or the massive Ponzi scheme. But they know I file a tax return every year, because if they didn't, they wouldn't be on the jury. And so, they have to be able to figure out how is it that this is not a mistake. Big numbers, clear documents, because you got to get into the person's head. It is a subjective state of mind, not an objective, not what I would have done in those circumstances, because that's what the Supreme Court has said. So it's a hard case to put together. So if you have an administrative case, there are often opportunities, not just to hope they make mistakes, but opportunities for you as a defense lawyer to be able to get in to the CI agents, be respectful, be a zealous advocate for your client, but say, this is why this is not a good case. And this is why your resources should be used otherwise. This is why perhaps the fraud referral got written up, and if that agent is the one who interviewed the taxpayer and has these certain comments or interviewed, workers, because they did site visits, that you now have inconsistent statements, because I'm going to tell you I've interviewed these people, and that's what they told the agent, and I have it in the FOIA, is not. And now he's interviewed him, I've interviewed him, the RA's interviewed him, you got 3 different statements. talk about a field day for cross-examination. So there are strategic things you can do in an administrative case that you may not always be able to do in a grand jury case because you're getting in way behind, where the government already has a lot of information.
Yeah, on an administrative case, as a defense attorney, you get 2 meetings. One is with the SAC, or Special Agent in Charge, excuse me, and then one is with DOJ Tax. You do not get those opportunities in a grand jury investigation. And with defense attorneys, I've worked with several in the room, Ronnie and Mitch and several others. We have great working relationships, it's very professional, and they're always trying to get more information than we're going to give. But
So Joe, we've turned to grand jury cases now. So tell me, we already know you like grand jury cases better, but so grand jury cases where the IRS has come to you first, and maybe you're thinking about bringing another agency in, or you've got another agency and you're thinking about bringing Jason in.
Yeah, there are definitely advantages to having IRS. If I already have an agent working with me, maybe the FBI, I bet you didn't know that Secret Service does fraud cases as well. They don't just protect the president, they also actually investigate fraud cases. I think one of the largest fraud cases in this district was done and brought by the Secret Service. So they may have a case and I may have a need to bring Jason involved, because if Jason's not on my team, then I usually can't look at tax returns in a view of prosecuting tax charges. I have to have an IRS agent assigned to the case. I've got to go through the processes I need to go through. So that may be an advantage if I'm looking at not only money laundering, but maybe tax charges. I want to bring Jason in, or vice versa. Maybe Jason brings me a tax case, and it's not just a tax case. Maybe it's also a mortgage fraud case or a Ponzi scheme. And so I may want to bring in the FBI or the Secret Service to help me work that fraud case. So there are advantages to both sides of working those types of parallel proceedings. But for sure, if I want to use tax returns to charge your client with a tax crime, I have to have the IRS involved early on and much in the beginning of the case.
So, Joe, you said, I want you to explain the 6103 issue. I think everybody here knows confidentially 6103, okay. And so there's obviously an exception if IRS has a criminal case, they can make the referral to DOJ and DOJ can get the information. But to give a little bit more detail in regards to what we call 6103I orders in regards to getting information and what the limits are.
Yeah, so one of the things I can do, for example, I had a mortgage fraud case. One of the large real estate agents here in San Diego was doing those liar loans back in 2008, 2007. And what he did was he just had the owners of the homes, the owners, the straw purchasers, list what their jobs were, where they worked. So what we did was we could go to the court using 6103I and get tax returns to see, hey, do those people in fact, when they filed their returns, say in fact that they work at those places? And so that's an avenue of evidence that I can use to prove that they did or they didn't. One of the restrictions on doing that, though, is my intent as the prosecutor and as the agency is that I have to be using it for that purpose, not trying to go like they did back in the 60s against the mafia, my Italian brethren. And when they were trying to prosecute them for tax crimes, they could try to use statutes, that's where the statute came from, because they would get your tax return and then turn around and charge you with a tax crime. You can't do that. You can't use a 6103I order. I can't go to the court and say, oh, I want to look at those tax returns because, it's a mortgage fraud case, right? And then turn around and charge those defendants with tax crimes. So I have to have another purpose for using those returns. Otherwise, I can get myself in hot water, and it gives a defense attorney a field day if I do end up bringing tax charges later.
Okay, so we're going to switch topics here a little bit with regards to sources of information. And so I think, who did I give this to? Eric?
I think so, yes.
I did.
So we have a little diagram here on the screen. The short answer is there's a wide variety of sources for criminal tax cases. And maybe not unique in federal criminal prosecution, but pretty special because you have this component of the agency, the civil component of IRS, that is doing examinations. They have an examination division, and revenue agents are looking at activity, transactional activity, or looking at people's business activity, and they come across things to them that looks like it could be a crime. And sometimes it's because they're running into such resistance with the taxpayer or whoever they're trying to get information on. But other times it's just because they're good investigators. They just see things that look weird to them and then they refer it over for criminal investigation. We also can get referrals from other components of the government, for example, bankruptcy trustees who are not, they're not part of the United States government, the private trustees. They're working for the bankruptcy court, but they will see things in the course of their duties that may reveal to them what they think are tax crimes, and they can make a referral for potential tax investigation. Other parts of IRS, as well as other parts of the federal government, are pretty regular feeders into the criminal tax investigation mill. And I guess I'd say the two I wanted to focus on, the orange one over the left, cooperation from other agencies. And this is what Joe was talking about a little bit, and I think it's very common in this district. I don't think it's common all throughout the country, but that is that different law enforcement agencies will work together very closely. This district tends to be one where there's not a lot of turf battles, where people are yelling at each other over, I want this case and I want you off of it. They tend to sort of work collaboratively here. As Joe mentioned, Secret Service, they will be working on a case, and every 2 to 4 years, they have to disappear and do protection detail. So if they don't collaborate with some other agency, their case is just going to stagnate. Whereas if they work with IRS and FBI, they'll get stuff done. And when I was a prosecutor, I often would bring together groups of agents because I felt like it gave a better chance of trying to get to the bottom of what actually happened and potentially beat some defenses. The last box that I think is really interesting is the third party box. And I'd add into this, not just informants and cooperators on criminal cases, but whistleblowers. So the Title 26, 7623, there's actually a bounty provision. So if you bring in information about what you believe to be tax fraud going on, you can get a 15 to 30% recovery. And the whistleblower statutes, the SEC has a very active whistleblower program, and sometimes people will come in because they've found something out at their employer, and they don't really know what it is. So they'll just hire a lawyer who will file with the IRS and will file with the SEC and will file with anybody a whistleblower allegation. I see more and more of those. I get people coming to law firms saying, look, I think that my employer or my ex-spouse, that's always a area that's very ripe for a whistleblower, that they say, look, I think that they're committing some kind of crime, and that then generates a whole investigation. So there's the short answer is it comes from a wide variety of sources. You cannot assume that it's coming from just from IRS. It could be coming from a number of different areas. And the sooner, as in the defense side, the sooner you can figure out where this is coming from, what is animating this investigation, the better you can start preparing your own investigation and following. There's nothing worse than being blind and clueless. I don't know where they're going or what's pushing them, but now they've done a search warrant here and they're interviewing this person, and you're constantly playing catch up. And so that's part of the reason why you want to have a good relationship with the agents if you can, because even though they won't tell you everything, they may give you some indication of what's motivating the case so you can try to help your client.
And as far as sources go, 2 points. One, you have to understand how rare a criminal investigation leading to a criminal indictment is. Let me give you some rough numbers. 200 or so million tax returns filed every year. So from about 150 million people or entities. So if the IRS did 10% of that, let's use 200 million, that'd be 20 million tax returns reviewed every year. That's 10%. 1% would be 2 million tax returns. And they estimate between 1 and 3% of tax returns that are filed go through civil audit. But now we're on to criminal investigations. And generally the numbers I've heard of initiated criminal investigations in any particular year is roughly 4,000 to 5,000 in the old days. That was 10 years ago when the IRS actually had 3,000 agents and they had a lot more money proportionally. Now we're down even less to 4,000 to 5,000 out of 150 million taxpayers with 200 million returns. So they have to figure out where those couple of thousand criminal investigations are going to come from, because they don't have the resources to not strike gold pretty darn often. That's where these sources come in. So they've got to winnow down all that information and get the leads on the best sources where a criminal violation might have occurred. They're using, as you've heard before in other panels, computer and AI analytics that basically look, I mean, anybody who's ever filed a tax return and gets that little automated message back that your 1099 did not match your stated amount in the tax return. Picture that only writ large by the analytics and the AI being used by CI right now to take 150 million taxpayers and winnow that down into a couple thousand and then begin the investigation. And whether you look at all these different sources or you add in, my favorite is sort of what Eric was talking about, the X's. So here's the deal. If you've committed a criminal tax violation, don't get divorced. Really bad.
You've got to, save your marriage. If nothing else, save your marriage.
Wait the 6 years, and then you can divorce him or her. Because then you won't be prosecuted. If you have a computer
and
program,
don't break up with your girlfriend.
Oh, girlfriends or boyfriends, just as bad.
While you stay married.
Yes, don't have a girlfriend and a wife or a husband and a boyfriend.
Practical advice for your clients.
Thereof, it's not worth it if you're engaged in criminal tax violations. If you have a computer programmer, love your computer programmer, because guess what? They have the passwords to all your programs, which they're happy to share with the IRS. And by the way, that NDA, a grand jury subpoena, blows through a non-disclosure agreement. Let me make that crystal clear. Blows through it. And then get all your passwords from the ex-computer programmer. And God forbid you have an ex-partner that you've now gotten into a fight with who hates you and is willing to take themselves down and you down because they hate you so much. That is just manna from heaven for the IRS to go down from 150 million returns to those couple thousand where the dirt is gold. A little digging underneath and there's that enormous gold nugget. So that is the point I wanted to make on this before we go to the next slide.
Exactly. So now we have the sources, and Jason's got a great case. He's got a bow on it, whether it was admin or whatever. And so now you're looking at it, and it's coming into you, whether it's coming in as a grand jury, Joe, or it's coming in as admin, and you get this little pretty letter from DOJ Tax Division telling you how to run your life.
Yeah, that's always super fun. Prosecutors love to be told what to do by the mothership in DC. That's fantastic. So I do get this letter, and it tells me what I'm supposed to do and who I'm supposed to work with. Although if I'm savvy enough, I already know who I like to work with. So I call Jason or somebody that Jason works with, and usually they'll bring me that case. But now that it's grand jury, when you guys call me, I get to say things like, particularly nice weather we're having. When you ask me if your client is under investigation, because I don't have to tell you, and I don't have to answer your questions, because it's secret. So when the disgruntled wife is mad at you, and she comes knocking on my door, I smile from ear to ear. I'm saying, you're going to grand jury, and you're gonna testify, and I'm gonna lock in your testimony under oath. And that's the end of that. It's a great investigative tool. And the grand jurors can ask questions. It's a really unique tool that prosecutors have. We're the only ones in there. There's no defense attorneys. It's just the prosecutor. And then it's the witness.
No judge.
No judge. And then the witness, and then usually anywhere from 16 to 24 people in the community who can ask relevant questions of the witness. But they're the ones who are doing the investigation. And so once I have that, I have a lot of tools in my disposal. Not only can I issue grand jury subpoenas for testimony, but I can get your bank records without you knowing about it. Jason's gonna give me the tax returns. I don't even need a subpoena for that, because once it's authorized as a tax case, Jason can just give me your transcripts, your tax returns, and then I need to decide what's the next avenue that we're gonna go down through this grand jury investigation. Now, if you don't get a phone call from someone like me with a 619 number, maybe down the road, you might get a phone call from somebody with a 202 number. And that's because, unlike where Sandra worked up in the Los Angeles division of the U.S. Attorney's Office, where they have their own tax division. San Diego doesn't have that. We don't have our own tax division separate and above like the LA office does. We just have a major frauds and prosecutions unit that handle all of that. And so we actually have, at the Department of Justice, an entire tax division in DC, and they're divided up into sections. There are attorneys that are responsible for different sections of the country. And boy, can you imagine what it's like being assigned to the Western region? I mean, fantastic. It's January, and you get to come to California to do your investigation. Or better, maybe you get to go to Hawaii, because they're in the Western region during a snowstorm in January. So it's not just prosecutors from San Diego that you'll deal with, you'll also deal with tax attorneys from the Department of Justice. And we work collaboratively. Sometimes we have cases where it's myself and a DOJ and tax attorney working together on a case. So it's not one or the other, we can work together on some of the larger cases as well.
Yep. And to that point, you know, if Joe gets a case and it's authorized for prosecution, it's been an admin case, or preferably it's not been a grand jury case and Jason gets it authorized behind his back for prosecution without making sure he's on board. But there are provisions where if you're obviously, you know, like the old story, like don't go over the head, talk to the person you need to talk to and try and convince them to do what you want. And so you've convinced Joe that this isn't a case that should be prosecuted. I don't think that our bench will like it. I don't think it's been put together right. Technically, the U.S. Attorney's Office can go back to the Department of Justice and say, we don't agree, and even if it's not a case where we don't agree, maybe because it's not a technical deficiency, maybe CI can meet the marks and actually get it past Rule 29 motion and get it to the jury. For some reason, the local office says, this is not a case that we want to put our resources in. DOJ can then turn around and decide whether or not they want to completely kill the case or they want to take it over. So there's a lot more like little things going on. If you do get a criminal tax case, there is DOJ criminal tax has a criminal tax manual. It's user-friendly now because it has a little, you can link on each chapter so you don't have to like scroll through everything to find what you want, but it has a wealth of information. It has a lot of directives from Deputy Assistant Attorney Generals that say things that AUSAs, DOJ, CI is not supposed to do, such as wire fraud, mail fraud charges. You know, other than
I just get over that by calling the FBI.
You do, but not always does everybody look. The agencies play well together, but they don't always want to play it well together because they all have competing resources. So, in other words, there can be strategic things, and that's why if you have wind that you have a client who is under investigation, and it's a grand jury, there is what is called a if and when letter. Okay. That is the letter that at least should give you, as a defense lawyer, the heads up, because it goes back to DOJ to main justice. And if and when you will authorize the prosecution of my client, I'd like to meet with you. It may be no more useful than knowing they've authorized prosecution and finding out exactly what the charges are, what the years are, the tax loss, because it's not an information sharing. But if you have some significant arguments to kill a case, maybe, look, every special agent report has to address health circumstances, has to address the defenses, if they're aware of them. There are things they have to do. And so this is your opportunity to try and convince an independent arbiter in DOJ, who's an expert in these matters, that, you know, there are technical flaws in this case, and you don't want to impact that 90% or more success rate. And so, you know, you're probably going to want to let Joe know you're doing that. I had a recent situation where an AUSA I'd worked with for many years, had a fantastic relationship, got heads up that I had a DOJ conference, and she gave me attitude. And I thought, okay, what did I do? And I realized 5 minutes into the call, she thought I was going over her head behind her back to DOJ, because in her entire career, she had never had a DOJ conference on one of her cases. So once she realized this was pro forma, and I'd sent the letter in like 2 years ago, she calmed down, but I was able to kill a few of the charges and get a really nice plea for my client, but that's a different matter. But so there are mechanics, and a lot of this stuff is explained in the criminal tax manual.
So
Can I just jump in? I'm just listening to you explain that, there are real tactical and strategic reasons to do that in a case where you have some good defenses. If you don't, but even if you don't know what your defenses are and you're not really sure how you're going to defend the case, just having the ability to get information before a charging decision is made is, I don't know, it's so powerful for the client. I mean, I have clients who are fortunately not facing tax charges, but they are facing other types of criminal investigation, and it's terrifying because you don't know what's going to happen. You can't plan your life, and all you can think of is, I heard somebody knocking at the door, I'm going to get arrested, right? And that's disruptive to trying to have like a normal life and to get on with everything that you want to accomplish. And so just having the ability to tell your client, don't worry, you're not going to get arrested. I'm gonna know what's going to happen before it happens, and I'll have the ability to talk to the prosecutor. That's really important.
And on that point, I mean, I've turned it over, Eric, to slide 20, which kind of goes into a little bit more, some thoughts on some other tactics besides just that.
Sure.
Thanks.
So target versus subject letters. So you may have heard in the vernacular that, is my client a target, a subject, or a witness? And in the criminal context, those words have specific meaning. A target is somebody who the prosecutor has determined is a putative defendant, somebody about whom the prosecutor has sufficient evidence to charge with a crime, and they are a putative defendant. Sometimes prosecutors are imprecise, and they say somebody's a target when that just means, I think I'm gonna try to make a case against them. But in general, if you're talking to a federal prosecutor, when they talk about a target, at that point, they've made the decision your client is going to get charged if everything proceeds as they plan. And at that point, you're in defense mode entirely. A subject, though, is somebody whose conduct falls within the scope of the investigation. It's really broad, and it essentially means if you know something about the issue that the government's looking at, if you have personal knowledge of it, you could potentially be a subject if you take that definition literally. Most prosecutors, though, will save the subject category for people who I'm not really sure if this person did the right thing or the wrong thing, and I still need to figure it out. And so when you're told that your client's a subject, or you get a subject letter for a client, you have a chance to get that person down to witness category, and you have an opportunity potentially to keep the person out of harm's way. But you have to balance that against, if you don't know the prosecutor, if you don't know how they're going to analyze this, you may be helping them with their case before you know how that's going to play out. So it really, in my experience, it requires you to have a degree of confidence in the prosecutor and who you're dealing with, and whether they're, for lack of a better term, predictable and trustworthy. And unfortunately, human beings, sometimes are both and sometimes neither. So that's, in that's sort of my short version on target versus subject letter. When you get them, it's unfortunate because your client's not just a witness, right? That's sort of, everybody wants to be a witness because then your exposure to this investigation is going to be much smaller. Hopefully you get out of it, maybe never having to be in the inside of a courtroom ever. But unfortunately for the target and the subject, they're going to be at least being looked at. And then the next bullet on here, grand jury subpoenas to witnesses versus grand jury subpoenas to clients. So, as Joe was mentioning, he uses the grand jury. Prosecutors use the grand jury as a very effective tool to get information. I will say also, and I would throw that back to the panel for their perspectives. I actually, on the defense side, I like the grand jury also because it generally slows things down. And if you're following it, you know when Joe has subpoenaed the office manager. I know when he's done that, and maybe if I interview the office manager first, and also after the officer manager went in the grand jury, then I know what he's said, and I know what information he has, and I can sort of track what's going on. But if your client gets a subpoena to testify in the grand jury, that's obviously an issue that you have to consider very carefully, because if you don't know that they're a witness for sure, and even then, some defense attorneys say, that's nice, I want immunity. I'm not going to let my client testify in the grand jury unless you give him immunity from prosecution. Joe, maybe you can talk for a minute about how does that make you feel when you issued a subpoena to the office manager and you get a call from defense attorney who says, no problem, can you give me the immunity order? Or I'll take the letter, I'll be nice, I'll just give you the letter too.
Yeah, the first thing I think is, what'd your client do wrong? Is he a target or a subject? Should I upgrade him from subject to target? Why does he need immunity? I mean, that is definitely a thought running through my mind as a prosecutor, because we're always watching and analyzing who we're calling before the grand jury, what their status is. And so, you know, I'm never just going to hand out immunity. It isn't candy. You can't get it in the grocery store and then just give it out as you feel like doing it. It's prosecutors. There's actually a process that we have to go to. There's internal approvals, and then, you know, if you want the pain in the neck formal immunity, where the department and someone at the DOJ is going to sign that, that's an even heavier burden. But you're never going to get immunity for your clients unless you're going to open up and tell me what your client's going to say. So that's going to be part one. If you ask me for immunity, my next question to you is, well, what is he or she going to say? And you've got to give me an attorney proffer as to what they're going to say. And then maybe you don't get formal immunity out of the gate, but then you're going to get a request to meet with your client, and I'm going to want to test that. And I'm going to want to ask the questions. And I'm going to have my agent present. And we're going to document that. And we're going to see whether or not your client's telling the truth. So it's not just as easy as saying, oh, give me immunity, and my client will come in and tell you everything you need to know. There's going to be a process for that. And then if I don't think your client is telling the truth, or maybe your client didn't tell you the truth, because, you know, they never do that. They always tell you the truth, right? And so maybe that's happened, and now you're in a bit of a bind, because now they've met with me, and if they lie during the immunity meeting, I can prosecute them for a false statement, or a false statement to a federal officer, because I have Jason present with me. So you've lied to him, so now you've committed another crime. So it's not that simple, but you definitely, if you're going to go that route and it's serious, your client's not in any trouble, maybe they really are just a witness or a subject, you're going to want to make sure you do your due diligence on your end and prepare your witness, then come in and talk with us. Give us a good detailed proffer. Don't write me a paragraph about what your client's going to say, but you would take your time, right?
Yeah, and I would say that there are some defense attorneys who their practice is just, no, sorry, I'm always going to demand immunity. And for those defense attorneys, I agree with Joe that generally speaking, the prosecutor's like, well, why are you asking for it? Except with attorneys like, because I always ask for it. And so you can't really draw any conclusions. And mostly I view them as just trying to throw sand in the gears, right? They're just trying to make your life difficult, because that's how they view their job. And sometimes it's effective, because then Joe's like, I got 10,000 things to do. This witness really is not that important. I don't even know why I want to talk to him in the first place. Then he moves on and goes to somebody else, and so your client never has to testify. So it can work, but it has the danger of, like I said, getting Joe interested in, I wonder why he asked for immunity. I didn't think they did anything wrong. I must be missing something.
So Nathan, now you know you're in a situation where everything has not gone well for you or your client, and you've been told, okay, here is a pre-indictment opportunity for your client to plead. What are the things that you are going to focus in on if your client has come to the point where he realizes it's going to go really badly, I'm going to get convicted, so I want to get a plea, and I want to get the best plea possible?
So when a client comes to any lawyer, they have to ultimately build a huge amount of trust, because their liberty and their riches are now going to be in your hands. So they need to know that you've done everything you can possibly do, and you've figured out the case as best as you can by the time that pre-indictment offer comes. So back to what Eric and Joe were talking about, the minute this thing goes over, whether you find out in an administrative case that there's one going on, or you find out that the grand jury is now up and running, it's an information war, and it's a war. On the government side, they've got their agents, they've got their badges, they got the grand jury, and they're trying to get information as fast as they can. On the defense side, you're doing the same exact thing. You're trying to do it for damage control, you're trying to throw some gum in the works, you're trying to slow down the process to give you an advantage, because ultimately, they have the ultimate super advantage. They can arrest your client and bring an indictment. It's a pretty good power that they have. You don't have that power. The only thing you have at some point in the process is, okay, prove your case to a jury of 12 unanimously and go get a verdict. But they have the power of indictment, they have the power of the arrest. And it's a huge power.
But when I generally start out with a huge advantage, unless they've been able to get to my client and get them to blab way too early in the process. And by the way, footnote to that, I was once given by one of our old partners, or my old partner, your partner, Steve Tosher, a shirt. And the shirt had a fish on it, big, beautiful bass with a hook in its mouth. And the line was, if you don't want to get caught, keep your mouth shut. It's actually something I then started to give out to my clients. All right, back to where the story was. It's an information power, but I've got the client. And if he's being honest, or she's being honest with me, I know where the bodies are buried. I know how far back the scheme goes. I know who knows about the scheme from the client, so I then know who to interview. I know who to then get an attorney for. I know where the documents are. And nowadays, folks, it's not documents, it's not paper, it's all electronic. What gets your clients indicted and prosecuted 90% of the time are text messages and emails. Because people will say something in a text message and an email that they would never say if they actually had to write it out in letter form. I mean, it's the greatest device that the IRS ever came up with was the invention of email. Imagine that, a written form of communication that people spend very little time. It doesn't hit the superego, it just bypasses your superego and you respond. It can be found in different locations, sender, the CC, the BCC, all these servers have the information. Here's my favorite part. If you delete it, there's a record of it, which then shows a mindset that you wanted to hide the information. How's that for a perfect piece of information? Anyhow, so you've done your work, and you've gone ahead and you've done your sort of parallel investigation. I'm not talking civil criminal, I'm talking defense versus the government. And you've tried to figure out, well, how much tax did this person avoid, and how much of this can I argue is not tax loss? Because the lower and lower and lower you can get on those numbers, the better chance you can make an argument that this is not a criminal tax case. So if my guy, for instance, didn't report $1 million, but I found out that he has a great deduction that he also didn't claim for $2 million. Or maybe he's got a carry forward that can go backwards and wipe out an additional $1 million of tax income. Now I go to the ultimate at the end of the day and I say, this is a no-loss case. We've wasted a lot of time and effort, and literally my client owes 0 tax. Take that to a jury, and good luck in convicting them that they had a criminal mind to pay 0 tax. So you're working the tax side of it, you're working the evidentiary side of it. I go ahead and pull all the emails and the text messages as fast as I can, because I know that Jason's going to be hot on my tail, and Joe's going to be right behind him trying to get that stuff, but I'm going to get it faster, because I've got access, I know where to ask for it. I've reviewed it, I know if I've got a problem. So now let's assume I've done my review, I've got the client's credibility, my credibility with the client, and I've done the homework, and he's got or she's got a huge problem. Now the pre-indictment offer comes in. And the offer is basically, take this offer or you're going to be indicted. And by the way, not only indicted, but arrested, most likely.
On a Friday.
On a Friday. So that you'll spend the weekend in
at
jail.
4:30.
On Memorial Day weekend.
Exactly. All right. When you're on vacation, let's add that one too.
When you have your dog with you.
Have your dog with you. I actually, war story, I had a client get arrested on a Friday as he was a single parent, as he dropped his 7-year-old off at school. There were 4 cars full of IRS special agents, guns and badges in front of his school.
Nice.
That arrested him right there to embarrass him.
It wasn't me.
Wasn't
they
my
were like,
case either.
hey, we waited until he dropped him off. You know, I'm sure they were like,
never
what?
have done that. By the way, a great issue. I tell the clients, I'll take any issues from any place that I can get to use for your advantage. That got me a meeting with the U.S. attorney to say, whatever you want to do in my case, that was a BS move. You know it. And you got to make sure that your agents and your prosecutors don't do this in the future. Gave me a huge chit with the U.S. Attorney's Office, which we later used quite effectively. But putting that aside, you got to take these pre-indictment offers seriously. And if you know, for instance, that the real tax loss
because it goes back not just the 3 years they're looking, but 10 years, or at least 7 years. And the real number is not $1 million. The real number is like $7.5 million. But they don't know about it because they haven't reached that part of their investigation. The rest of the documents and evidence was much harder to get. And they're at $1 million, and they come to me with $1 million offer. And I know they put another 6 months into the case where they talk to 2 more people. They're going to get to $7.5 million. I reluctantly go back, negotiate a little bit more, and then tell the client to take the deal. And then we then argue to the judge all the factors, and we'll get to that in sentencing in a moment. But I know that the deal they're offering is a good deal. On the other hand, if I know that that deal is a bad deal, but I know it because there's a fatal flaw in the case, that is the most difficult part for a defense attorney to be in, because if you tell the government what the flaw is at that moment in time, they will fix it. Let me give you the example. I had a case where the government charged a false statement on a tax return. So that's not tax evasion. They're saying that the actual number that was put on the tax return for total income was false. It should have been, I'll make up the numbers now, it was $250,000, it should have been $2.5 million. And they said, okay, that is a criminal violation. What I know is that the tax return that we are using was called a 1040EZ. It's that one-page tax return that people who don't have business income file because it's one page. Now, when you look at the question for total income on a 1040EZ, it says to determine total income, which is line 15, add up lines 10 through 14. Now, I know my math, and I know that line 15 equals lines 10 to 14. But there's no question for business income on a 1040EZ. If I tell the prosecutor that they can't bring that charge, they'll switch the theory to tax evasion, and they'll be able to bring the charge, because tax evasion is about literally, the evasive move was using the wrong return. You owe all this tax, and that's why you did it, which is exactly what had happened. But we ended up going to trial. They put the IRS revenue agent on the stand. And she says, well, there's $2.5 million of business income. Is that reported on the return? No, thank you very much. Cross-examination. Let's turn to item number 15. It says total income. You see that it's $250,000. Yes. Now it says you determine that by looking at items 10 to 14. That's true. Let's do some math right now. Is 10 to 14 equal to $250,000? After about a 30-second pause, yes. So $250 is an accurate statement on that return as to what the total income was. Isn't that correct? That was about a minute pause. And she said, no. I said, well, let's do the math one more time. And we did the math one more time. She eventually conceded that that was the correct thing because it got charged incorrectly. And I didn't want to fix it. I had to wait to trial to fix it, or to bring it up. And the judge dismissed the case right after the government rested and granted a motion for acquittal. So those are rare situations. I don't want to make it seem like you can pull that one off every time.
And not in front of Joe or Jason
Not
anymore.
Joe, Jason, Eric,
Also
Sandra,
not my case.
Forget about it. No way. In fact, he's going to look for this one next.
I would have charged evasion too.
By the way, irony of ironies, and this is very important to look at. If these two prosecutors, who were very good prosecutors, this was their first tax case. And in many of those offices that don't have a tax section, you're getting basically fraud prosecutors being given tax cases. We know that 90% of them plead guilty. 10% or less actually go to trial. They had never done a tax trial. They didn't know to ask the question to check the form out. They just assumed what they were given on their file was correct. So it's very crucial, if you, in the defense of a criminal tax case, that you know the players, you know the strengths and weaknesses, so you can make the right move at the right time.
I totally agree with Nathan's assessment on whether or not you tell the government the problems with their case depends entirely on whether you will be successful at presenting that defense at trial, or conversely, if the government can fix it, right? So, and it's hard because you have to tell the client look, they are offering you this pre-indictment offer. It's not unreasonable, but I think we can beat it, and here's why. But it's a risk, and it's going to depend on the client's confidence in you. It's going to depend on the client's risk tolerance, and it's a difficult decision to say, look, do I just take this pre-indictment offer, or do we take the chance on something where you won't know until the end of the trial how it's going to turn out?
So we have actually decided to roll the dice, as Nathan says. So in addition to having technical arguments you might have, Eric, like what are other strategies you might do? Motions in limine, other things you might do that, whether it's successful or not, but you have a reason, a strategic reason.
So my new favorite one, because I always hated it as the prosecutor, and so now I like it as a defense attorney, is the Speedy Trial Act. So in general, most prosecutors, except in certain districts, in like the Eastern District of Virginia, they're ready to go. They indict their case, the judges set the trial date 70 days out, and they go. They don't get continuances. Most districts, though, it's a tax case, it'll be declared complex, you'll get lots of time, people will look at discovery. I think, though, as a defense attorney, you should think about bringing this case to trial in 70 days. There are some risks, obviously, because you have to be ready and you have to have the ability, your client has to have the ability to fund a vigorous defense and be ready to go. But the advantage, I think, is that the government oftentimes builds up for the indictment, brings the case for indictment, but hasn't really thought, other than Joe, they don't think about how am I actually going to try this case? They oftentimes just okay, tax division said it was a good tax charge, got the indictment, here we go. And then if you can catch them flat-footed, I think the speedy trials is a good tactic sometimes. Yeah.
I don't know exactly, but I heard COVID with the right to speedy trial got adjusted. What changed with COVID and your right to a speedy trial? Because with the courts and how did that?
Yeah. So the answer is it depends, right, on the district. So the question from Ronnie was, how did COVID change defendant speedy trial rates? And the answer is it depends on the district and where you were. Some we don't have COVID here, sir, right? Some districts were I don't know what you're talking about. We're going, we're hearing court normally. But in general, that Congress passed a statute that allowed for tolling of the speedy trial clock as long as the court made a finding. And if the district court made a finding that, hey, there's a disruption because of COVID and we can't actually hold trials, that time was excluded. So you couldn't do that in those cases. I don't know. If I had a case, I would try to push it. Have any of those gone up on appeal where they said, look, no, I want my rights?
Technically the statute gives the government equal rights under the Speedy Trial Act to show that in the interest of justice, it wouldn't be fair to go forward. And I think with, not being able to seat a jury because, people are quarantined, have no vaccines, can't be, and at the point in time when there was no plexiglass up, there was no mask to be found, etc. So I think those cases would have fallen. But there's definitely a public decision out there from Orange County where one of the judges finally said, no more, where the defense did not waive speedy trial. And he said, the government's not ready to call a jury tomorrow, I'm dismissing the charges, and he did so. So it's, as Eric said, depends on where you are, which may be a perfect thing for us to kind of go through in our last 10 minutes, which is sentencing and knowing your judges. Who wants to take that first? No, Jason's not me.
I'm happy to give it a shot. So sentencing after 2005, when the Booker decision came down, is really much more of an art form. It's much more of a holistic presentation to a judge as opposed to just this guideline analysis as to who your client is. So you're constantly making the pitch to the judge that this is a good person who made a mistake rather than a bad person who finally got caught for a crime. And that's the overall structure. And how do you actually prove that? Because that burden's kind of on you. If there's been a trial, maybe there's evidence that came out about your client, good and bad. But if there hasn't been a trial and there's a plea, you already start out with a leg up, which is your client has accepted full responsibility for their actions. Then you try to show that their life before the crime, this was someone who came from nothing. And whether they came from something or not, they didn't come from as much something as someone who started with $1 billion. They only started with 100 million. Whatever they start, it's something. And now they do the dint of hard work and being a productive member of society, a community and family-centric person. And you have examples of that through letters of support from family members, from religious institutions, and whoever runs them, charities, colleagues, employees, partners, anything you can get to build out the who is. Because one of the chief factors is the history and characteristics of the defendant. The judge has to take that into account. And then whether or not you pay the tax back. If your client has the money, he's going to be paying it back anyway. I mean, unless you're going to go up on appeal and fight this forever. So I always tell the clients, if you got the money, even if you don't, go borrow the money, go find the money, but I need the money paid back to the IRS before sentencing. Because it doesn't happen in all cases. You get extra brownie points if your client not only agreed to the numbers, but actually made the payment ahead of sentencing. And so you want to make that as part of the argument. You then can get creative. You know, I had a client once in a Korean case take out an ad in the local Korean newspapers. And the ad actually said, I am so-and-so, I committed a tax crime. I'm potentially going to jail for this. This is horrible. Don't commit a tax crime. File honest returns. You know, basically they're trying to self-deter others. Because the #1 factor, the government is going to take a sledgehammer and hit your client and the judge over the head with, is judge, you got to put this person in jail to deter others. Why? Because remember that 150 million taxpayers that we're not going to be able to get to in any way, shape, or form? We need to deter all 150 million of those from filing false tax returns by putting my poor client in jail and making the point. And then issuing a beautiful press release that further stays on the internet the rest of their life and says what a bad person they are. So I sometimes want to take the bull by the horn and say, look, we sent a letter out, in this case to the Korean newspapers. We said we're bad people. We already deterred that judge. You don't need to put him in jail to make the additional point of something like that. So you're trying to get the tax loss under control. You're trying to get your client's history under control. If there's cooperation, judges love cooperation. The IRS loves cooperation. Cooperation was one of those little factors there up there. The government will reward cooperation. And all of a sudden you might have been looking at 5 years in jail that just became 3 years under the government's recommendation. Then I'm going from 3 to 0, which is a lot easier than going from 5 to 0. So all this comes up in the sentencing where you're trying to make this pitch. And quite candidly, defense lawyers have been doing this, forever. The government's somewhat new to it. I mean, they've been doing it now for about 15 or 17 years. Some are much better at it than others. But this is where the defense actually usually will have an advantage in the presentation.
A couple of other things I add on to that. In certain districts, the district judge, the first time they will actually see your client is sentencing. Because the magistrate judge will do the initial appearance, the magistrate judge will take the guilty plea. There will be no hearings of any significance with the district judge until the date of sentencing. And so that is, as a defense attorney, that is the most important part of the proceeding if it ends up with a conviction, because that's your one opportunity, and you can't like lay a foundation of stuff if the client pleads guilty. Something to think about in terms of the judge. There are judges who will make it clear that they will not penalize your client if they go to trial. That is to say, you may get the same sentence if you go to trial and get convicted than if you plead guilty, which is kind of unusual. Most times, judges want to incentivize people to accept responsibility, as Nathan said, and they want to control their docket, and so they will give the defendant a lesser sentence. Some judges won't. And so if you're in that courtroom and you have a case that might have some defense angles, and as long as your client doesn't have to get up in the witness stand and get prosecuted for perjury, you can just attack the strength of the government's case. You may want to take that thing to trial because it's not going to hurt you in front of that judge. Conversely, other judges No, if you accept responsibility.
If I got a judge like that, I'm probably waiving the jury.
Yeah, exactly, because you're like thinking, I want to be talking right to that judge, yeah.
And I'm not consenting to it.
Yeah, but you gotta get permission and they're not gonna give it to you, because they don't wanna alienate the judge. But the judge, okay, if you draw a judge, and it's not somebody you, in your prior life, appeared in front of regularly, know a lot about, you need to find out everything about that judge. Everything about that judge you can. And I will tell you, there is a probably more well-kept secret than it should be. The Federal Public Defender's Office, they will give you that information. You can call them up. They'll share with you and let you know what are the arguments that work in front of this judge, what are the judge's pet peeves, who's their favorite baseball. Nathan did that one once with a particular baseball player that a judge loved that came in as a character witness, and I was rolling my eyes.
All right, the judge loved Maury Wills. Who thought Maury Wills would be something that the judge would love? But the judge wrote like opinion pieces in the New York Times to get Maury Wills in the Hall of Fame. My client knew Maury Wills. So when it came time for sentencing, there's me, my client, and Maury Wills. It didn't really work, but it was just a great moment.
But, again, so knowing who the judge is, because it can really make a huge difference. Looking to see if that judge has ever had a case with similar charges and seeing how they've ruled. If there were ever cases where they gave a probationary sentence or a reduced sentence, and knowing what those arguments are, citing the judge to him or herself. Because one of the things they have to consider is basically whether or not there's consistency in regards to other, decisions in their own district, nationwide. Obviously, that's the whole part of, the advisory guidelines. And so those are things that are very important. The allocution. I listened to 3 judges 2 weeks ago do a sentencing panel where they said, no cameras, everything is not going to be recorded. We're going to speak freely. All 3 of them made it very clear. In white-collar cases, tax cases, white-collar cases, there are 2 things they want to see. They want to see true remorse and rehabilitation. If the banker is working at Home Depot because he got fired when the charges came down and they got rid of him quick, that's a significant thing. If they've gone out and used that time, because there's a lot of time between most cases, the plea and the sentencing. And if they haven't done anything during that time to show they really want to make up for their big screw up, that will make a difference. They're working at the soup kitchens. They're talking to their union colleagues about don't do this, don't get into this scam, don't participate in that. That's huge. The other thing is, whether they allocute or not, you as a defense lawyer have to be very much in control of what is in that allocution. And the one thing a defendant should never do is ask for leniency. You can have 50 character letters coming from family, moms, they can be crying in the courtroom asking for leniency, but the defendant should say, I will accept whatever sentence you give me. So.
We're gonna extend it a couple more minutes. I get this question a lot. We have a lot of CPAs here. This is for you, Jason. When you're out there in investigating an individual, you go to their tax preparer to ask questions. They're not a target, you're just asking them questions. They call me up and they say, if I get a lawyer, is Jason gonna think I'm guilty? I always advise them to get the lawyer. And I say, they're not gonna think you're guilty. They're gonna think you're actually smart to get a lawyer. Can you tell the crowd, when they get a lawyer, do you think they're guilty when the accountants get lawyers, or should they talk to you?
No, I think they're smart.
And he may have already thought they were guilty before they got the lawyer, so.
It doesn't influence my opinion of them. We work with defense counsel and prosecutors all the time, attorneys, it's not a big deal.
But it's a great point, Ronnie. A lot of people will talk to law enforcement because they don't want to be perceived as somebody's hiding something. I'm trying to, I'm somehow being, squirrely here. And so look, agents are really, really good at getting people to talk. It blows my mind that people talk to agents as much as they do. But it's human nature, I think.
And then one last question I get a lot. You're investigating individuals. You knock on a neighbor's door and you say, I'm looking at Joseph. And then you tell the neighbor, don't say anything to Joseph. I think Joseph committed tax fraud. He hasn't filed returns and you're looking into it. You go tell Joseph. Joseph comes to my office. We realize Joseph hasn't filed any tax returns. Maybe one false return, not filed returns. We know you're looking for him. Comes to my office. We file all the returns and pay. Do you think a criminal case would proceed or would...
That's a very generalized question. First, we would not disclose to your neighbor the existence of a tax investigation or the fact that he has not filed. 6103 applies, I think.
Or that you're just investigating him, and then you're asking questions about him, so he comes to my office.
Sure.
I see he's made some mistakes, missing a few returns. We amend and fully pay. How much will that help him in a potential criminal investigation?
You know, I think it depends on the entire conduct. I mean, it could positively influence the
I'm
case,
going to
but
direct him not to answer your question.
it just depends.
So can you pay to get out of a criminal case?
I'm always advising
No.
clients in those situations. I like going forward and paying and, at that point, see what's going to happen. I think it's less likely that they're going to, bring the case if you could kind of catch it, come forward first. I'm always encouraging compliance, even when we know we're being investigated, because I just, think it just goes a long way and I see them not prosecuting.
Jason takes the fifth.
That's why we get paid big bucks to do this, to figure out the answer to that question. Is it you're now confessing and you've given another statement under penalties of perjury and you've actually showed Jason exactly what the dollar amount of the tax loss is? Because you can't file another false return, right? And so it may be that, like Nathan said, there's $7 million of problems here and Jason only knows about $1 million. So it's part of kind of the strategy. At the end of the day, though, if you know the client's probably going to get indicted, or if it is part of the defense, what if the defense is, the accountant, told me, blah, 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 I could do this, and now, since Jason showed up and I hired you, oh crap. I realized even though I acted in good faith, maybe I was, naive, and so now maybe that is what you want to do. But the balance is because the case law is very clear that, acts that you take after you learn you're under investigation are not admissible. Now, of course, if the government wants to then use your facts, now you can use them to your advantage. But if it's a case that Jason's leaning on the fence, full payment may make a reason why, do I really want to now give this to Joe and go, it's
got
got
Joe
some,
with it's a
warts.
no-loss case. The guy's fixed all the returns. Nothing happened. I think he's in compliance. Joe's like, what are you doing in my office?
Did you come over for lunch?
I think one thing that was on one of the slides that most clients will not know is tax evasion 7201 comes with a 75% fraud penalty. That keeps rolling and doesn't stop until it's paid in full.
Right.
In answer to your question, Lonnie, you only get to amend returns once. That's just a rule. So you better make sure that you have all the numbers, and if you can do it quickly, great. Usually you can't. Usually you almost have to bring in another accountant to take a look at all the numbers to get it right. And then if it's consistent with the defense, and the defense is the original accountant, I disclosed everything to the original accountant. I don't have an accounting degree. And he came up with a tax return. Yeah, I should have looked at it closer, but I just signed my name. In fact, I didn't even sign my name. I signed my name on something called an 8879. I didn't look at the return. I signed this little form. I should have looked at the return. It says I looked at the return. I didn't look. I just signed this thing, and he electronically filed it, so I didn't even electronically file it myself. If that's consistent, then when you come to the new accountant, oh my God, my old accountant did this to me? Are you kidding? Here are my beautiful amended returns. Here's a check, completely consistent with your defense. That's when you would actually probably amend returns. Otherwise, you've just taken one of the government's obligations away from it, quantifying the amount of tax loss. Because if you put the $7.5 million on a return, you own that statement now. And now the government doesn't have to really spend much time figuring out between 1 and 7.5 million. You just confess to it.
I think we have one more question.
Thanks, Ronnie. My question is, if someone comes to the IRS whistleblower office and presents information, how confident can that whistleblower be that his or her identity won't be disclosed and will face retaliation?
Well, I've represented
Yeah.
whistleblowers.
Right.
The answer is very confident unless,
Yeah, right.
unless a civil case or a criminal case gets made, that particular witness is a recipient witness or part of the chain of custody to show that evidence or documents are real. And then at that point in the process, which would be in civil discovery, way later in the process, or criminal discovery, the existence of that person gets known.
Right.
Otherwise, they'll
Yeah.
keep that existence if I just know through triple hearsay something's happening, and I just have documents that I can't authenticate because someone just handed them to me, the IRS has to go ahead and get authentication from some other source, they don't need me. They'll keep my identity secret the whole time.
Yeah, I think it's becoming a whistleblower is a very difficult decision for somebody to make because of this risk. And I think, in the short term, your identity will be protected. And the question is, can they wait 2, 3, 4 years? If their identity comes out later, 2, 3, 4 years, how do they feel about it now? I think most whistleblowers I meet with, once you make that decision to make a disclosure, whatever it is, you should be looking for another job, right? It's really hard to stay in one place where you've just disclosed information about it. Like, you should be thinking about next plan. Not right away, but eventually.
Yeah, my comment is, you're not going to keep them secret. I think when I've been handling, like in civil litigation, where there's a whistleblower, I've always been able to figure out who the whistleblower is. Always. Every single time. If I'm counseling somebody who's might want to be a whistleblower, I say, get used to the word ratfink.
Yeah.
Because that's what you're going to be called for the rest of your life. Get used to it.
I think we're all set. Thank you all so much. Appreciate
Thank
it.
you. Thank you. Well, I know what many of you are thinking. That 8 hours sure went by quickly. No, in all seriousness, this was a great conference. It continues year after year, and with great panels and great speakers. And I know some of you may know the great ice hockey player Wayne Gretzky. He once said, "You miss 100% of the shots you don't take." What did he mean by that? You miss 100% of the shots you don't make. If you don't come to conferences like this, you miss the opportunity to learn things that can help your career, help your clients. So it's great to see you all here and the ones online. But also, the second part of a conference is the networking. The networking is probably my most favorite part of any conference. This is where you might meet maybe your future employer, maybe an employee, maybe a future partner in a firm, maybe a mentor. So I want to invite you to stay for the reception is at the Garden of the Sea. I've never been to the Garden of the Sea, but I heard it's back here. And if that's not a good enough reason to stay, there's 2 more. There's free food and free booze. So on behalf of the University of San Diego, I want to thank all of you. I want to thank Ron and his excellent team at RSJ for putting on this conference, and our many sponsors. Thank you. Great presentation. I saved the best one.
That was great. Great job. Awesome. We had a good moderator. Yeah, she was great.